Hey y'all, I'm AdaKay, and I must confess, I'm a trial junkie. I enjoy viewing trials as if I was the seated juror. So grab a cup of java, get comfy, and join me as we hop into court. And don't forget to comment, like, and most importantly, subscribe. And if you're really enjoying the channel, please join our membership. Good morning, everybody. Good morning. We already have people in court, so we're going to have to hurry up and get going. Oh my gosh, y'all. It was a late night and an early morning. So, what I'd like to do right now is I would like to get the birthdays announcements for all of you who are having birthdays today and then hop into court. Oh, let me get everything lined up. Come on. Cooperate, computer. Computer not cooperating. All right, guys, let's do the birthday.
Happy birthday to you. Happy birthday to you. Happy birthday. Happy birthday. Happy birthday to you. Happy birthday.
Oh, yeah.
To you. Happy birthday to you.
All right, y'all. Happy birthday, Jeanette. Happy birthday to Debbie. Happy birthday, Susan. Happy birthday, Tracy, Yvette, Mimi. I hope y'all have a great birthday. Theo, Danielle, and Susan. Happy, blessed birthday. Oh my God, Miss Kevin. Happy birthday to your mom, Miss Kevin. May you be a blessed and fabulous birthday. Happy birthday. Penny, oh my gosh, you have a freaking awesome daughter. You did a great job, girlfriend. Great job. She's incredible. First cup of coffee. Court is in a swing. I was trying to do something and didn't get it done. That first cup of java. You know, you take your meds and they get stuck. We stuck. Just a little bit. We stuck. Okay. I really want to finish what I was working on, so I'm going to put music on. I'm going to mute. I can't mute myself. Dang it, I'll have to do it later. Sorry. I have a surprise for someone. It'll be this afternoon. We'll do it at lunch. Get it done this afternoon. You guys, our interpreter will not be here. She has another job to do this morning, so she'll be here this afternoon. Get my notes. I'm going to get organized like the judge is.
I had brought up that an anonymous reporter had come up to the 9th floor and spoken with the deputy who's there at the desk with some sort of information. This 5 minutes ago, I was provided a letter from a law firm in West Palm Beach dated yesterday. It says that it was sent to the state and the defense. Did you each get a copy, State?
Yes.
I did, and I responded late last evening to a copy of Your Honor's chambers as well as
Yes.
Oh, I don't have those responses.
He just said, thank you for sending it. I said I didn't get an attachment and realized I was looking at the wrong email.
I thanked him. I told him it was worthy of calling it to the court's attention and that I was confident Your Honor would probably conduct the hearing as a result.
That's what I'm doing. Do you want to be heard on this, state?
No.
Defense? Do you want to be heard on this?
Yes, I'd like the court to question the jurors individually.
Oh,
No,
it's a juror thing.
the lawyer said whether or not the potential juror heard it. I have every confidence the court can do it delicately and first find out if which juror, if any, was exposed to that, and then find out if they heard anything that had any impact at all upon their perception of the case, and that was extrajudicial in the sense that it was a reference to something that had not been introduced in the court.
All jurors or just male jurors?
Judge, I would suggest respectfully all the jurors, and I think.
Even though the letter says it was a male juror?
Yes, because that's what.
Must have happened in the
this
restroom.
Anonymous source said, but I think to be safe, to the extent there was some jurors in this location, there's limited places to go for lunch around here, Judge, so I.
Oh, maybe
think
not.
that there could have been other jurors there as well, and rather than run the risk of not knowing, I think a simple inquiry by Your Honor would put that to rest.
State?
And Judge, I would just recommend that maybe we ask the group these general questions, and if anybody says that they've heard anything or seen any news or heard you talking, then we can talk to them individually, because these people may not.
Good to see you, Cindy.
And then we spend time doing individual.
The concern with that is, in my experience, respectfully, any juror that was exposed to that may be very anxious about acknowledging it.
All right, thank you. I'll bring them in individually to ask about that.
Snap.
Of course, we've already discussed Dr. Quintel when we came back from
Good
a
morning,
recess.
all.
He was approached by a reporter in the hallway while he was in the middle of testifying, but on a recess, asked if he could be, the reporter asked if he could ask questions of Dr. Quintel. Dr. Quintel said no, and the reporter gave him a card. That's my understanding from Dr. Quintel.
Yes, sir.
Anybody want to be heard on that?
Did not take it.
Do you want to be heard on that?
I'm sorry, I just wanted to add that Dr.
All right. Do you want to be heard on it, though?
No.
After
He's
hours
like, "We're
yesterday,
getting through
I
this."
was contacted by Judicial Security and notified that a witness who testified and had not been released from subpoena, and again, this is second or third hand, and it's my understanding both parties have been made aware of this, was being interviewed by a news channel reporter in the hallway outside of the courtroom. When deputies were locking up, someone told them that this was going on. I don't think the deputies actually saw it, but it was reported to them.
And Judge, I spoke to the witness, and there was a discussion with the media, but nothing was talked about what was going on in the trial or the testimony or anything like that. And I've spoken with the witness and asked them not to do that anymore before the trial's over.
This is the first I've heard of that, Your Honor. I wanted to know who the witness was.
The reason I didn't speak in specifics is this is all hearsay within hearsay within hearsay.
I understand.
It was reported that it was Eva Benefield gave an interview to a reporter from News Channel 8.
Oh, mama.
Give me a moment, Your Honor, please.
Her mother. Erica, hi. Hi, Elfie. Welcome. Welcome.
I believe she's under Stacy.
Yes.
And did the state request that she remain available under the subpoena?
Yes.
Okay. I think perhaps a hearing may be in order.
All right.
And Judge, I don't know, the state would not be opposed to a hearing. I can represent that this particular witness did not speak about anything that was prohibited by the rule of sequestration. No one said to this witness, you're not allowed to talk to anybody about the case, just, testimony and the witnesses in this trial going on right now.
All right. Go ahead.
So, not to compound it, but to the extent we're doing housekeeping things now, we also have an issue, Your Honor, with an impeachment witness to Stephanie Murphy, specifically Faith Brown, who is representing Miss Benefield during the same proceedings. She was not on our witness list, but given the testimony of Miss Murphy, we are going to have her outside this afternoon, and the court may want to conduct the Richardson hearing just for that. So just for planning purposes.
We're just going to have a whole day of crap.
All right. You understand that Faith Brown may be called as a witness?
Yes.
All right. I wasn't going to get too involved in the Richardson hearing yet. It needs to be done, obviously, and I've got a note for that. All right. So on the Eva Benefield potential interview with someone at News Channel 8, you're not asking for any relief.
No.
I don't know what relief you're going to ask for, but if you're asking for some relief, I'll let you get started.
Well, the relief I would ask for initially is that she obviously be barred from being called as a witness, potentially. Secondarily, to the extent the court admonished her about doing exactly that which she did, I've observed thus far the court's general admonishment that it gives to witnesses. I'm assuming Ms. Benefield received it as well. Is she in the courtroom, by the way? Ms. Benefield?
Here she is, yes.
Yeah, I'd like to have her step out.
All right, ma'am, if you please remove yourself from the courtroom.
Why is she in there anyway? Why is she even in the courtroom? She is a witness that is under.
This is a young girl
Okay.
who lost a father. I'm not looking to hurt her, but given her disregard of the court's admonition, I think precluding her from being called as a rebuttal witness at a minimum would be appropriate. Whether or not the court feels any further sanctions are appropriate as a result of her disregard of the
He
court's
wants her
warning.
sanctioned?
Did you want to be heard at all?
Judge, I would just dispute that she violated exactly the court's order. And if she does testify, she will testify consistently with what she has already testified to in a deposition. So counsel will know if that changes, but we know what she's going to say because she said things already in the deposition. So I don't think any potential harm has come from us.
Rebuttal?
So true,
All right.
Erica. My camera's.
Whenever we talk about having a hearing, my assumption at the beginning of that was that it was going to be evidentiary and people were going to call witnesses and present evidence. Here's what the court knows. Someone told a court deputy that they observed Eva Benefield giving an interview to News Channel 8 reporter in the hallway outside of courtroom A after court had concluded for the day. At this point, I have no facts or evidence before me. I've got hearsay within hearsay as to something that happened. Yeah, so I don't.
I'll call her.
Well, I gave you that opportunity. That's what I'm saying is that if everybody wanted a hearing, then
All right, well, I took it for granted that the court would.
I'm not going to assume this is true.
Wow.
Court
Oh,
likes, I'll
you
have her
guys
call her
go-
and we'll have a brief hearing.
It's up to you. All right, can you call Miss Benefield back in?
Go to Tryout TV Live and subscribe to them, guys. We're trying to get them in their memberships up. They're a phenomenal group.
State, just looking at the list, you have 3 witnesses left? All right. Do we expect to finish today?
Go
with the
show them
state's
some
case?
love. Go show them some
Come on
love.
in, ma'am.
The daughter. Oh, the daughter, not the mother. Oh, sorry, my bad. I'm tired. The daughter.
Do you know which deputy reported the matter?
No.
Or any of the
Oh,
deputies in
you're
the
welcome.
courtroom that saw the conversation late yesterday afternoon? Do you know which deputy it was?
Is she wearing the same clothes?
As I said, it was reported to me that some unidentified
Erica.
person told the deputy.
Okay, so give me just one moment.
The daughter. I'm sorry.
Are
I'm
you the one
tired,
that they
y'all.
told? Okay, right
I
here.
only have 3 hours sleep.
Mr. Taylor.
Thank you,
Apparently
Squeegee
it
of
was reported to
Justice.
Deputy Racky.
To have a moment with the deputy.
Yeah,
Of course, State, you want to be present?
or similar. I'll have to look.
Step into our office.
What? Oh, sidebar. Sidebar. Oh my gosh. Y'all throw out some love for TV. A trial TV live. This kitten's going back crazy. The dog's not here, so the kitten's going crazy.
Ms. Benefield, I'll remind you that you are under oath. You can scoot a little bit closer to that microphone and just answer the questions in a loud, clear voice.
She's scared to death.
You appeared yesterday and testified before Judge White in this case, did you not?
I appeared on Tuesday and testified.
Tuesday. Time flies. At the end of your testimony, do you recall Judge White instructing you about having contact with anyone because you were to remain under subpoena? Do you recall that?
I recall.
Okay. And you are here today because the state requested that you remain as a potential rebuttal witness.
Correct.
Now, what did you think Judge White's directions to you meant?
Well, I was told I wasn't allowed to speak on any of the witnesses in my testimony while in the courtroom.
So, I'm sorry, did you finish?
I'm finished.
Did you
She knew better.
realize that when you decided to have a conversation with the reporter?
Yes, sir.
All right. Tell us if you would. I'm just trying to get an explanation. Tell us if you would what you were thinking that
Objection.
Overruled.
That's for what she said.
what you were thinking that you felt allowed you to do exactly that which Judge White cautioned you not to.
I was caught off guard in the hallway when I was under extreme emotional distress after being here,
No!
hearing different testimonies about my father's murder. And when I spoke to the reporter, I made sure not to talk about any of the testimonies or anything that happened in the courtroom or my testimony.
What did you discuss with the reporter?
Just how I felt about the situation and who my dad's character was as I saw him.
When you say about the situation, you mean about the case, the trial?
Not about the trial.
What situation were you referring to?
My emotional state.
She
You
knew she shouldn't have done that.
Post on,
She had that answer planned.
social media,
I do.
TikTok,
Yes.
any others?
No.
Following your testimony here last Tuesday, did you make any posts?
I did.
Tell us how many?
3.
3. And tell us one at a time. Were all 3 of them on Tuesday afternoon, Tuesday evening?
One was on Tuesday.
And when were the other 2?
Yesterday.
Okay. And tell us, as to the first post, what was it about?
I said that I testified.
Okay. And did you have anything to say about your testifying?
I talked about it being on live television,
What else?
that somebody back home was watching.
I assume you have copies on your phone?
I do.
You have your phone with you here today?
I do not. Not on me.
Where is it?
It's over in the benches.
In the bushes?
In the benches.
In the benches here in the courtroom?
Yes, sir.
With the court's permission, may she retrieve it so we can see exactly what it was that she posted?
Oh, shoot.
He knows, clearly they have to.
Look at that face.
Well, I don't know.
It's an invasion of privacy. Dig into a
Not if it's on social media, but we started off talking about just speaking with some reporter, and now we're talking about a social media post. If you've seen it, and if she's violating the rules, let's just get it out.
Okay. I'm trying to find that out.
So now it's a fishing expedition.
Oh,
If you know a violation, let's talk about it. If not, let's just get moving. We got jury waiting.
I understand that, Judge. How do I know? She's told us she posted 3 things. How do I know what it's about? What if one of them involved discussions that were inappropriate? How am I to know that? I've been a little preoccupied, and I don't do social media.
Sir, if you have specific evidence, let's talk about it. If not, you have a team. You've got 1, 2, 3 people in court right behind you. I don't know. Maybe they can look it up. But let's focus on what we know about, as opposed to digging into speculation.
I have no further questions.
No question.
oh.
Benefield, when you had this conversation with the reporter in the hallway, were there any other witnesses around?
Yes. I'm sorry.
Oh,
Let me
shit.
re-answer that question. None that testified.
What? A witness
Okay,
testified.
so you're saying there were people standing
There
around,
were people
but
around.
none of the witnesses in this case.
No, sir. Not that.
Oh, Jesus.
Did you talk specifically about the questions that were asked of you or the testimony you've given?
No, sir.
All right. Do you have any follow-up questions to my questions?
No, sir.
Do you have any follow-up questions
Ronnie.
to my questions?
Little girl
All
got
right,
in trouble.
Ms. Benefield, you can step back out. Did you want to call any other witnesses?
No, sir.
State?
I called the freaking TV channel. They're outside. Get the news station. Get the news station. And she's going to start deleting that crap. You know she is. As soon as she's out of that courtroom, it's delete, delete, delete,
All right, Ms.
delete,
Benefield's
delete.
out the courtroom. Go ahead, sir. You have any argument? You want to seek any relief? You want to argue in support of any relief?
Yeah, I think she violated the court's admonition.
The daughter of the decedent talked to the news station.
And as a result, again, I have no personal interest in seeing the young woman suffer, but I do think violation of the court's admonition is sufficient to strike her as a potential rebuttal witness.
Judge, I think you asked for the relevant questions. I think the questions that you asked her are the admonitions that you gave her as a witness, and she did not break any of those.
Final thoughts? I am certainly
I'm kidding.
distressed
Yeah.
that, let me say first, the media policy for the 12th Circuit prohibits the media from conducting interviews inside of the courthouse. It is my understanding that our media and public relations person met this morning, or was going to meet this morning with the media to go over the administrative order again, because certainly I think the media is and should be aware of that administrative order and comply with it. The specific incident that we're talking about after hours yesterday, the facts that are in front of me are not that Ms. Benefield spoke about her testimony or the questions asked. But I also have not heard from the reporter, and I have not seen any tape or footage. At this point, I'm going to reserve on the request, and I'll make a decision. If and when she's called again, I'll make a decision at that point. You just have to remind me if we get there.
I'm satisfied. Thank you.
All right, next. Deputy, if you just start, I don't care about the order, just start bringing in the jurors one at a time, please.
Judges, Ms. Beckman, allow back and forth.
Yes. Yes, but I'm going to give her an admonition. Just, if you tell him to just hold up for a second, she can come back in. At this point, I'm reserving on whether she can be recalled or not, but I think an admonition at this point is appropriate.
Woo, she's going to get her hand
Ms.
smacked.
Benefield could come in.
The court will allow her to sit in for the testimony, knowing that she may be recalled. as the rule has been invoked.
Yes, under Marcy's. Sorry. No, hold on.
She knows. She knew she shouldn't have done that. She's taken her 15 minutes of
All
fame.
right, Ms. Benefield, you can stop right there.
Boop.
Ma'am, the court has ruled at this point that I'm reserving ruling on whether you're going to be allowed to be recalled as a witness or not in this case. I don't know if that's going to happen or not. I'll make that ruling down the road. But I want to admonish you about the instructions that I've given and the importance of those. They matter and they need to be followed. Do you understand? All right, ma'am, you can retake your seat. All right. No.
I have it, y'all. And I'm going to screen record it in case it goes down.
Morning, sir. You can just grab this front chair, it's just fine. And can you remind me, please, what juror number you were? 33. All right. Juror 33, the reason I'm going to bring the jurors out individually is that this morning, the court was provided a letter from a law firm representing a reporter who indicated that during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, two individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing you out to find out, did that happen to you? Have you received any information outside of these four walls?
No, I didn't go to a restaurant. I was in my car here in this building.
All right. State, do you have any questions?
No, thank you.
Defense?
No, sir.
All right. Thank you, sir. Good morning, ma'am.
just grab that first chair. And could you please remind me which juror number you were?
15.
15. All right, ma'am. The reason I'm bringing about jurors individually is that this morning I was provided a letter from a law firm in West Palm Beach that claims to represent a news reporter. And the news reporter anonymously has stated that during the lunch break yesterday, the reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing everybody out to talk about, have you seen any news coverage? Have you heard people discussing the case? Received anything outside of this room?
No, sir. I go home at lunch.
State, do you have any questions?
No, sir.
Defense?
No, sir.
Thank you, ma'am. Good morning. Just have a seat right there. And could you do me a favor and remind me of your juror number?
20.
Ma'am, the reason I'm calling out the jurors individually is because this morning I received an email, a letter from a law firm in West Palm Beach who claims to represent a reporter. And the reporter has anonymously stated that during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm asking everybody, are you familiar with that? Has that happened to you? Have you received any information outside of these 4 walls?
No, I have not.
State, any questions? Defense?
No, sir.
Thank you, ma'am. All right, good morning. Have a seat right there. That's just fine. Could you remind me of your juror number?
Original 42.
42. Thank you. All right, ma'am. The reason I'm calling out the jurors individually is because this morning I was given a letter from a law firm in West Palm Beach who claims to represent an anonymous reporter. And the letter says, during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So the reason I bring everybody out is just to say, are you familiar with this? Have you heard of this? Have you been approached by anybody? Have you watched anything on TV? Anything at all?
No, Judge. Yesterday, a couple of us chose to just not go to the restaurant area, and simply because we saw some people out and about, and we just figured it would be best to just stay clear of all of that. And no, I have not watched or viewed anything on media.
Thank you. State?
No questions.
Defense? None. Thank you, ma'am.
I got to stop for a second. I am so freaking disgusted at Eva. It's going to take me a minute to get everything transferred. I did some screen recording in case she deleted crap, but she did something that just absolutely pissed me off. This girl is not Why is my lighting so bad? Hold on, guys. I'm going to do the other light. It may help balance it. This girl doesn't give a rat's ass about the death of her father. She's all about the fame. I'm so pissed right now. If she was my granddaughter, I'd be, oh.
Good morning. Just have a seat right there. That'll be just fine. And ma'am, could you remind me of your juror number for Monday? 35. Thank you very much. Ma'am, the reason I'm calling the jurors out individually is because this morning I was provided a letter from a law firm in West Palm Beach. And they claim to represent an anonymous reporter. And here's what the letter says, essentially. During the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing everybody out to say, are you familiar with this? Did you see any of this? Have you done anything to look at or hear anything outside of this courtroom?
I have not.
All right. State?
No questions.
No question.
All right. Thank you, ma'am. All right, ma'am. Have a seat. And could you please remind me of your juror number?
Just from the day when I was here on Monday.
Yes.
Number 21, I believe.
All right. Thank you so much. All right, ma'am. The reason I'm talking to each of the jurors individually is because I received a letter this morning from a law firm in West Palm Beach. And they claim to represent an anonymous reporter. And what the letter says is during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing everybody out to say, are you familiar with that? Do you know anything about it? Or have you looked at anything outside of these 4 walls during this trial?
No, I'm not aware. The only situation I do know, one of the jurors, Ted, I believe mentioned he was out to lunch. And he mentioned that he did get it. He got up and left a restaurant. But that's all he mentioned. He said he felt uncomfortable and left.
Thank you, ma'am.
Mhm.
State.
No
Oh,
question.
hold on.
Oh, I'm sorry.
No, you're fine. They just like in trial, they get a chance to ask their questions
Yes.
too.
No
State.
question.
No question.
All right. Thank you, ma'am. All right. Good morning,
Good
ma'am.
morning.
Could you please remind me of your juror number?
My original one or here?
Originally.
29.
All right, thank you. Ma'am, the reason I'm bringing everybody in individually from the jury is because this morning I received a letter from a law firm in West Palm Beach, and they claim to represent an anonymous reporter. And here's what the letter says. During lunch on yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So the reason I'm bringing everybody out is to say, do you know anything about this? Have you heard anything about this? And also, have you viewed or seen anything outside of this courtroom?
No, I haven't. I brought my lunch yesterday and ate downstairs on the table.
State?
No question.
No question.
All right, thank you, ma'am. All right. Hello, sir. Can you please remind me of your juror number for Monday? 43. Thank you, sir. The reason I'm bringing all the jurors out individually is because I received a letter this morning from a law firm in West Palm Beach, and they claim to represent an anonymous reporter. And here's what the letter essentially says. During the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm calling everybody out individually to say, do you know anything about this? Are you aware of this situation? And also, have you been following the court's admonitions? Have you been influenced? Have you seen anything outside of these 4 walls?
Yes, Your Honor, that was me at the restaurant. I was getting my lunch to go, and I was keeping everything out of my view and wasn't looking at anything on the news. And I left immediately because I felt uncomfortable, and I haven't gone back to the restaurant. That's what I did. I ate my lunch in the park right out in front of the courthouse.
All right, sir. So when you said you weren't paying attention, was that to the television?
That's correct. I was not in view of the television at all, and I asked the business owner to pack my lunch to go so I could leave.
And did you overhear 2 individuals in that restaurant discussing a witness's testimony?
I did not.
State.
No question.
No question.
Thank you, sir.
Okay. I know I've been quiet. I want you to hear that, but I've been also looking up. There has been no televised interview at this time by Channel 8 of Miss Eva. I doubt there will be until after trial, now that this has come up. But guys, I am hot under the collar, and I'm trying to decide, do I wait and share it tonight or do I share it today? I'll let you know.
All right. Hello, man. Can you please remind me of your juror number from Monday?
38.
38. Thank you.
What was the number, Judge?
38.
Thank you.
Man, here's why I'm calling everybody out individually. This morning, I received a letter from a law firm in West Palm Beach, and I want to talk to everybody individually. And they claim to represent an anonymous reporter. And the letter says, essentially, during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So the reason I'm calling everybody out individually is just to say, do you know anything about this? Have you heard anything about this? And have you seen any news or anything outside of these 4 walls about this case? State? No?
No question.
Defense?
No question.
All right, thank you, Dan. All right, the jury's out. State, do you want to be heard on this issue? Defense?
No.
All right, the letter that I received from the law firm is going to be filed in the court file.
Oh, snap.
Okay.
I'm going to turn this up because I can sometimes gain more than you can.
Confirming his story. Okay. That he requested it.
Yes, sir.
Okay.
Oh,
The deputies
snap.
informed me that somebody in the audience was at the same restaurant. And again, this is hearsay within hearsay. Would confirm that the juror asked for the television to be turned off.
Does
Good.
anybody want me to find out who that is and have them brought forward? State?
Give me just a moment.
Oh, God. This judge had it.
No, Your Honor.
All right. So is there anything else we need to take up before we get started with today's case?
Okay, guys. It is very hard. Oh, crap. It is very hard when you live or are in a confined community. Why am I have? Hold on. Okay, wrong mode. I have different modes. Okay, when you're in a confined community or even in a big city, but in a small circle of places to go close to a courthouse to eat, etc., it is very hard to not be around the case when every restaurant now has TVs, etc. So I commend the juror for doing what they did, but it's getting harder and harder in today's time to keep jurors sequestered or away from this information if they leave a courthouse. It's just getting harder and harder and harder. So I appreciate the judge doing what he's doing, but sometimes it's just, you can't keep it away. All right, guys, I'm working on this other situation.
Okay. All right, let's go ahead and bring the jury in.
Y'all, this is getting much. Y'all, I am so pissed at this little girl. I'm trying so hard to keep my cool.
Welcome back, everybody, as a group again. Just need to confirm that, we kind of talked about this individually just a moment ago, but that no one has talked amongst yourselves about the case or began your deliberations. No one's talked with anybody outside of the jury about this case, and no one has done any research on the people, places, things, or legal topics we've heard anything about. Everybody says no.
When we left off yesterday, the state was still presenting its case. State, call your next witness.
State called Sergeant Brian Hewitt.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Hello, sir. My name is Judge Wine. I'm presiding over the case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It does adjust up, down, left, right. There you go. And if you just speak in a loud, clear voice right into it, it should be just fine. If we hear you breathing, you're too close.
Okay.
Good morning.
Good morning.
Please state your name and spell your first and last name.
Brian Keelis, Brianquilles.
Where do you work?
Manatee County Sheriff's Office.
How long have you worked there?
About 19 and a half years.
What is your current position with them?
I'm the supervisor of the technical services unit.
And I don't know if I said this, you're a sergeant?
Yes.
Okay. And what is the technical services unit?
It's a unit that gets involved in the technical aspects of criminal investigations. One of the responsibilities is downloading data from cell phones and analyzing that data.
And prior to your current position, what positions did you have at the sheriff's office?
Several. I started on the road, moved over to a cops unit, eventually moved over to the Special Investigations Division as an undercover detective for a couple of years. After that, there was a position involved in, again, technical aspects of investigations. It just wasn't called the Technical Services Unit at the time. And that's until I did that position for a number of years until I was promoted, and eventually the Technical Services Unit started, and that's when I started supervising that unit.
And what training and education do you have to do your current position?
I've had probably over around 800 hours of various technical training, some related to cell phones, some related to technical surveillance, but roughly 800 hours of total training.
Okay. And I want to talk about specifically cell phones and how you deal with those. So how much training would you say you've had in cell phones and analyzing cell phones?
It's probably a third of that 800. So around 250, 260, something like that.
Okay. When you do what I call a forensic examination of a phone, what do you do? Just briefly.
It's really a case by case basis. There's each phone is somewhat of a research project. There's so many variables, but ultimately that phone will get plugged into a forensic workstation. Software would be used to be able to download or extract that data from that cell phone, and that same forensic workstation will use software to be able to decode or parse that data to be able to review it.
When you download, I call it dump, a cell phone, when you dump the information from a cell phone, is it voluminous?
Yeah, it can be. Yes, it's quite a bit.
Okay. And is it easy to interpret without help?
No, you definitely need a certain expertise to be able to look at it. You need software to make it a little bit more of a convenience to be able to look at it, but definitely need some assistance to be able to do it.
And do you have programs, software that helps you with that?
Yes.
What are the names of the ones you use?
Our main state program is Cellbrite. It helps us extract the data. If it needs to
we know about
bypass encryption
Cellbrite,
and
don't we?
bypass locks, it'll help us do that as well. There's other programs that we use, Gray Shift, excuse me, as well, to be able to unlock the data and extract it. We have toolkits that I like to refer to of data or of software to be able to use.
And give me a general idea of how many phones you've done this with.
Me personally, hundreds. I want to say the unit as a whole has steadily done 200 to 300 leading up to about 2002, and that has increased probably closer to about 500 devices for this year alone, I'm pretty sure.
Okay, so the unit 500 devices for this year.
Yes.
And when you use software like Cellbrite or Gray
Shift,
does it allow you to put whatever data you want, for instance, pick out what you want and put it in an easily readable form?
You can filter the reports that the software displays, and if you only want it to include messages, you can create a report with just those messages. Sure.
So, for instance, on just your average cell phone, if you did a cell phone dump, you would get messages like text messages.
Yes.
And emails.
Yes.
Internet searches.
Yes.
And all different things that would be on your phone.
If those data transactions exist on the phone, you will typically get those.
Okay. So this software allows you to pare that down to what you want.
Yes.
In the instant case where you asked to do extractions on 2 phones.
Yes.
And I'm going to show you what's been previously entered into evidence as States Exhibit 11 and 12. You can take a look at both of those. Can you tell me what those are?
These are the two cell phones that I had done examinations on. One of them belonging to Doug Benefield, the other one belonging to Ashley Benefield.
And is that the evidence tag that's on there? Do you recognize that?
Yes.
And does it have your information on it?
Yes, it does.
Okay. So did you go through the process that you just explained with both of these phones?
There were differences in the process, but ultimately we were able to get a path to data and produce a report for that data.
Okay. And which one were you able to extract first?
Doug's phone, we were able to extract first.
Okay. And then were you able to extract data from Ashley's phone?
We were able to eventually. It did take quite some time.
Okay. Why did it take quite some time?
That phone, it was passcoded, or it had a PIN code. I want to say it was a 6-digit PIN code, and the software, it took a long time to actually bypass that encryption or that PIN.
Okay. So if you don't have the passcode or a way to get into the phone, your system can do that?
Yes, it varies in length of how long it could take to bypass, but yes, the system allows for that.
Okay. And you called one of those, Doug's phone and one of those Ashley's phone. When you do extractions of the data, do you get information about identifying who owns the phone?
Yes.
And can you just explain what that is?
Yeah, a lot of the times, especially with iPhones, you'll have an Apple ID that could be associated with the person that owns a phone. In the contact information, it'll have the owner's information, so it's pretty easily identify who that phone belongs to, especially with iPhones.
Okay. And the one phone, I'm not sure if it's 11 or 12 that you said was Doug's phone.
12.
12. Did that have identifying information?
Yes.
That identified it as Doug's phone?
Correct.
And then for Ashley's phone, same question?
Yes.
Okay. Did you prepare a spreadsheet for this case?
I did.
And what is on the spreadsheet?
It was communication between Ashley and Doug extracted from Ashley's phone from September 20th of 2020 until September 27th of 2020.
Okay. And when you say communication, what do you mean?
In that particular report, it was mainly text messaging back and forth. There were a few phone calls and I want to say at least one email, but mostly text messages.
Okay. And you said you prepared the spreadsheet from Ashley's phone. Did you also look at the information from Doug's phone to compare that information was on his phone as well?
Yes.
Okay. And was it?
Yes.
Okay. I'm going to show you what's been marked as States Exhibit 98. You can tell me if you recognize that.
I do.
And what is it?
This is the CD containing the Excel spreadsheet that we just talked about.
Okay. And when you said there's communications between the two, if there were any attachments to those communications, would they also be in your spreadsheet?
Yes, they would. Yes.
Okay. And you looked at this?
Yes.
Yes. And is it accurate based on the spreadsheet that you created?
Yes.
Statement entering the evidence, States 98.
Any objection to States Exhibit 98?
No.
Received.
So I'm going to publish the spreadsheet now. If we could turn down the lights and potentially, it's a little difficult to read, potentially shut the blinds.
Hello, everybody. I'm interpreting, so it's really hard for me to communicate in any other way.
So I know
I'm
this is
sorry.
very small, at least from where I'm sitting. I don't know if I have handed you an exact copy, a hard copy. So I don't know what is easier for you to read. I know that print is very small as well. Sure.
Good morning, everybody. Good morning, all my mods, Ronnie, Miss Morales. Sneaky side, first day modding. Sneaky side, I'm going to really need to depend on you with the comments. And Miss Andrielle, you're too. you too. No one is modding in StreamYard. We will get Miss Sneaky Side set up, but right now, no. So, Andrell, if you are able, that will help me. I am trying to interpret, so this makes it harder. I am going to withhold the videos. I'm sure it's going to be out there if it's not already, but I'm going to show it to Miss Jules tonight, and we're going to go through and all react together. Let me let her know that. I'm going to withhold the videos until tonight so we all get the same reaction. I know she won't see that until break. I'm surprised that it hasn't already hit the TV. We're not going to stay late. We're not going to do another night like last night. Not that I will if I need to, but girl, me tired. Okay. I know I'm ready for tonight. Let's see what spicy happens today. Yes, you're a West Coast girl, so this is early. Ah, yikes. Sorry. Oh, so is it 6 or 7:56 in the morning for you right now? I'm getting oh my God. I can't say this live. Y'all, that's okay. Y'all, you have to be on this in my live tonight. OMG. I've got some tea for you tonight. Everyone needs to be on tonight. Who is with RA? RA Mods, can you let him know tonight we're going to have another live and we got a lot of behind the scenes tea.
Are you going to read from the one in front of you or the one behind you?
I'm going to attempt to read the one in front.
Okay, because I can try and make this a little bigger once we get through what we're looking at. So I have a laser pointer for you. So the red button is yours. And I have one as well. I do want to talk a little bit about these attachments that are on the phone or on this spreadsheet. Are you able to tell when you look at one of these attachments where that image or picture or video came
from? It depends on each attachment. There could be metadata there that the attachment could have been from a screenshot. It could have been from the actual phone, taken with the actual phone. So it just, again, case by case basis.
Okay. So there is a video on this phone that, and I just want to draw your attention to it, that shows some people at a restaurant. Do you know which one I'm talking about?
No.
Let me hold on one moment and I'll let you know which one it is.
It's line number 25 on your spreadsheet. Can you tell from what you're looking at where that video came from? Or do you recall from your investigation before where that video came from?
Based on what I'm looking at, it's an attachment from a text message from Doug Benefield to Miss Benefield.
Okay. And when you looked at Doug Benefield's phone, could you tell whether this movie was taken on his phone or sent to his phone?
I don't have a recollection of the actual metadata of the video itself on either phone. This is just looking at it from the attachment perspective, not the specific video itself.
Okay. If we could approach Judge.
Okay, they're approaching. FYI, just so you know, my son is not feeling well, so I am having to do this and watch the shop. So I just kind of disappear off screen. I will be back. I just help our clients, so I'll be in and out. I am sorry, but that's life. And I really want to thank all of y'all for joining us today, but especially the West Coast people. This is an early morning. It's like 6, almost 7 in the morning now for them.
Okay, so let me hook this back up.
I got to do this to make it easier for me.
And let's talk about what we're looking at first. And then I can try and make this a little bigger so people can see it. All right, so the first column just has the number of the entry, correct?
Correct.
Okay, and the second column is what?
It's just the type of entry it is.
And give me a couple of examples of the type of entry that it is into the phone.
In this timeline, it's labeled as an instant message. If it was a phone call, you would see phone call. If it was an email, you would see email.
Okay, and what does instant message mean? Is that a text?
It's a text.
Okay. And then the third column is what?
It's the direction of that transaction. It's specifically dealing with messages, whether it's incoming or outgoing.
Okay, so that would be incoming or outgoing from Ashley Benefield's phone.
Correct.
All right, and then the next column?
It's whether or not that data transaction has an attachment.
Okay, and then the next column?
It's the date.
And the next?
And it says time, but it also has the date and the time in the correct time code and time zone.
Okay, you said correct time zone. Can you explain that real quick?
So if you see UTC -4, UTC is what's considered standard time for world clocks. The time where the prime meridian is in the world, you subtract from that and you come up with a time code or the time zone that you're in. We are currently in -4. We're technically -5, but because daylight savings times, we actually subtract -4.
Okay, so does your software do that automatically?
Yes.
Okay. So when it says at the first line, it says 8:20.02, and that says UTC -4, that is the current Florida Bradenton time.
Correct.
Okay, and then the next column. And I made it bigger on the screen if it's easier for you to see.
I can see it
Okay.
fine here. The party is the people that are a part of the actual message.
Okay. And are these the labels, the names that are entered into Ashley Benefield's phone?
Correct.
Okay. And the next column?
The description, well, in this case, the first one is blank, but ultimately we'll have the body of a text message. Sometimes it'll be empty depending on the nature of it, but that's where the body of the text messages would be.
Okay, so the next column.
The source is just the software's way of saying if it was if it was a native message or if it was taken with a third-party application.
Okay. And the next column.
The attachment is the actual file itself and the file name.
And then the last column.
The source file information has a lot of metadata where that file actually exists and the file paths and size. And if you look at the table, all this information comes from databases, and it explains where or what table the database that this message or this data lies.
Okay. So let me move it back over. So after we get through this explanation, we'll move much faster, but the first message is what? If you could just explain to us what that is.
Item number 1 is listed as a message. It's an incoming message with an attachment, and appears there's no body to it. In other words, there's no actually text string. It's just the actual attachment itself.
And who is it from and who is it to?
It's from Doug to, I'm just going to say the name that's on the actual.
That's fine.
It says Ashley Christina.
Okay. And is this the attachment?
Yes.
Okay. And if you could just read for the record what that says.
It says, am I now trying to win the favor and approval of men or of God? Or am I seeking to please someone? If I were still trying to be popular with men, I would not be a bondservant of Christ.
And then the next message is what?
Number 2 appears to be an outgoing message. It's from Ashley Christina to Doug Benefield.
And how much later than the first message is that?
About 2 hours, it appears.
Okay. And so from Ashley to Doug, and what is it?
The description says loved an image.
Okay. So she loved the image from before.
Correct. That's more of an action than actual writing something out.
Okay. She didn't type loved image.
No.
The phone is saying that she hit some button.
Correct.
To love the image. All right. And then the next message is from right about the same time. And that says what?
Same time, that says good morning. There's another little icon after it, but it just didn't come out on here.
Okay. And then if you could just continue to read.
The next message, number 4.
Right, the next message.
Okay.
If you can just say what time.
Okay.
To and from, and what the message is.
So the next message sent around the same time, 10:36 a.m. It's from Doug to Ashley Christina. It says good morning with a few emojis. And the next message after that, appears to be an attachment, and that's at 11:43 from Doug to Ashley Christina.
And what is the message right after that? Oh, I just went too far. Right after the attachment, I'm sorry.
Right after the attachment?
Yes.
It would be number 6. It's a message at 9:20, 11:43 from Doug to Ashley, and it says run baby run with a few emojis.
Okay. And so now I'll just play the attachment.
Run, baby, run.
Run, baby.
Run, baby.
Okay. So Doug says run baby run to Ashley, and then what does she do?
That would be number 7. It's a instant message right after. It's at 12:16, and it just says laughed at a movie.
Okay. And if you can just keep reading.
Number 8 would be an outgoing message. It's from Ashley to Doug. It's on the same date at 12:16 p.m. It's just a few emojis. They appear to be laughing emojis.
And you don't have to mention the times right now until it switches a large time span. So go ahead.
The next would be an incoming message from Doug to Ashley asking ready to rock and roll. The next is from Ashley to Doug, give me a few LOL, trying to round up the cats. It's like trying to teach a ballet to squirrels. The next is an incoming message from Doug to Ashley. Says ha with exclamation points. The next is,
And we've established that it's all either from Doug to Ashley or Ashley to Doug.
correct.
So if you can just say who's speaking and then the message from this point.
Number 12 from Doug. He says, "That's funny." After that, it's from Doug. Says he's liked, give me a few. It's basically liking a previous text message and it just repeats.
Okay.
The next is an outgoing from Ashley. Says, "OMG, I'm exhausted, LOL." The next is also from Ashley. "You can come over now."
Now, I didn't ask you about the color coding on this, but what do the colors mean?
It was just to make it easier to read which one was outgoing, and on all the outgoings, which is Ashley's phone, are Ashley's phone, and the incoming is the other color.
And so the outgoings are what color?
The outgoings are the blue gray.
Okay. Or
I'm sorry, blue gray. The outgoing is the orange.
the orange. Okay. So if Ashley's speaking, it's orange. If Doug's speaking, it's gray.
Correct.
So I believe we ended it. OMG, I'm exhausted. LOL. Go ahead.
I believe I had stated the outgoing message. "You can come over now." Number 16 from Doug. "Hot. Need to video the rodeo. Okay, headed that way." From Ashley, she responds, she liked what he had said earlier and just repeats. Incoming from Doug, "I'm walking around to back." The response, "I could let you in the front," or which, and then adds to that, "whichever." He responds, "Okay, front good." She responds with a thumbs up. He responds, "Me and excess boxes arrived." She responds, "LOL." He responds with a message that includes an attachment without a body. Then there's a call log, which is number 26. It's an outgoing call log to Doug for, I believe, 11 seconds.
Okay. And then let me scroll down on here. After the phone call, what happens? Oh, let me back up just a second. What time was that phone call?
Same date, 9/27/24 in the evening.
And then at 8:58 in the evening, that next entry, what is it?
It is a message from Doug. It says, "Good night, sweetie." Theta waves with a couple emojis. "I'll be done by 1 tomorrow and plan on joining the party." And then there's an outgoing, and then again, another action of just loving that previous text message. And then there was a response at 9:23 that says, "Good night," with a couple emojis. "Ha, you sure you want to come hang out with the slum?" ? And 9:23, he responds, "Yep, be smeshin' at the slummin'." 9:24, there was again an action of laughed at the previous message.
Okay, so that was at 9:24 p.m. and it looks like the next entry is at 7:36 a.m.
Correct.
And what is that?
That is believes to be an attachment without a body. Long string of characters, JPEG image.
And that came from Doug or to Doug?
That was from Doug.
And I'm going to display the attachment. You don't have to read all of this, but what is this?
Just another Bible verse.
So after the Bible verse, what is the next thing that happens?
She appears that she loves the image and then responds with "good morning." He responds back with "good morning" with several emojis, and hours later responds with or says "headed that way in about 30 minutes."
So that's approximately 3 hours later. He says headed that way in about 30 minutes.
Correct.
Okay, go ahead.
There's a response from Ashley that says, "Oh, hey, wow, you done for the day? Don't rush because of us. We are out for a walk now. Not in a rush to get started today. LOL. We'll have to round up the cats when we get home anyway." There's a response from Doug. "Oh, nice. A little breezy, which helps. Getting early start so can finish up early to come over and be with y'all and play W Emerson," typically shorthand for with Emerson. "Free y'all up some. Just ping when good to head over." And Ashley responds with a like of that previous message, and then responds with "will do," and also adds in a new text message, "Want to grab a can opener at Publix on your way over? LOL. I of course packed the one we had." He responds, "Ha, too funny. Yep, we'll get one." She responds, "Thank you. Trying to get the cats. LOL." And after that, there's an incoming message. Appears to be an attachment as well. That was that.
Go ahead. Some of these attachments don't open on this computer. Can you explain kind of why that is?
I think that one of the previous videos that you had, sometimes it's a codec issue. The files are actually not necessarily embedded in the actual spreadsheet itself, but I can take this same file and bring it over to another computer and it might open. It just depends. It depends on the computer how it's set up to open that particular file.
Hi, kitty, kitty.
So after the attachment, I'm trying to slide this back over. Let's see. Let me try to open this. Okay, so this is one that will not open. So I slid it back over. If you could tell us again, starting at 46, I believe it is.
Well, after that attachment, it's 45.
Or 45. Sorry.
And it's an incoming. It says from Doug in the crazy loop at Gay, Gaye. And it's probably a misspelling because he corrected himself and put gate in the next message. There is a call log that has 0 seconds to it at 3:17, and then an incoming message walking around back, and then.
So the walking around back is approximately what time?
3 o'clock in the afternoon, or
And
3:21.
The next message is approximately what time?
9 o'clock at night.
And that message is?
Good night. And she responds at 9:22 with good night and looks like a sleeping emoji.
And the next communication?
The next would be an incoming message from Doug to Ashley. Appears to be an attachment, some type of JPEG image.
And you don't have to read this, but what is it?
It's another Bible verse. I believe we're on, after that attachment, we're on 52.
Yes.
It is incoming message from Doug. Says good morning with some emojis. Hope you slept okay. She responded at 9:28. Loved the image, or loved an image, and also an additional good morning. Doug then emphasized the good morning, just another action that he took on a previous message. And the next communication was at 11 o'clock a.m. with a wave emoji, looks like. Now 11:22, he responds again with how's morning. She responds with also a wave emoji at 11:26, then says, good, the scramble to get all the loose ends tied up, LOL. He responds, no kidding, I'm done. Around 1, we'll head that way. Been going since like 3 a.m., LOL. She responds, OMG, 3, why is that? He responds, just to get work done so can pack. Love mornings, all quiet. She responds, "Ha, okay then." He responds, "Spark is best friend, LOL." She laughed, another action for that message. And another response from Doug, "Finished up here, yay, headed that way."
And what time was that?
That was at 1 o'clock in the afternoon, 1:17.
And then after that?
At 1:19, she says, "Oh, take your time. No rush in, not in a rush today." And at 1:20, a response, LOL, with an emoji. "Think we all are getting pooped from the efforts." She responds with liked a previous message, and it just repeats. There's also a laughed at LOL, again, laughing at a previous message. Then another message at 1:36 says, "Can you think of anything we need at Lowe's or anywhere?" Then there's actual call log at 1:42 that lasts about 49 seconds. And that was from Doug too, actually. And then at 3:30, there's a message from Doug, "Headed that way in a few minutes. I'd nothing need." And a message from Ashley, "Alrighty, we are just out for a walk. Still can't think of anything needed at the moment." There's an action liked already, and the message repeats from a previous message. Doing front gate, I'm assuming circle, but CIRCL. And a call log from Doug to Ashley with 0 seconds. Incoming from Doug, "I'm here." And it looks like another call log for about 20 seconds.
And that's
that's it.
about, I'm sorry to interrupt. That's about what time?
That was at 3:56 in the afternoon.
And the next message is at about what time?
9:26 p.m. It's a message from Ashley Christina to Doug. It says "good night" with an emoji. And then after that, Doug responds, "Good night, precious girls." And after that, Ashley, again, an action of loving that previous response. And the next several messages appear to be related to attachments.
Okay. So the next attachment I'll put up. Who were these attachments sent from?
These were from Doug to Ashley Christina.
And then in the middle of this, so it would be, I'm not getting the lines correct, but I think it's line 87 maybe, at 9:29:35.
9:29:35 is line 86.
Okay.
And that's another action of loving an image.
And there's one more attachment, I believe. Possibly one more after that. Two. So all of these attachments were sent from Doug's phone to Ashley's phone.
Correct.
Okay. And then there's a series of responses from Ashley. Can you tell me what those are?
It's the previous action that we've referenced where she physically takes it's not word that she's typing, it's just physically within the operating system of iOS, it allows you to take an action on an image. In this case, she loved 1, 2, 3, 4, 5, 6.
Okay.
6 images.
Okay. Let me get it back centered again. So after she loved the images, there's an entry where she types a message. What is
Yes.
that?
That's at 9:31 at night. She responds, "All these are sweet, thank you." And he responds with an action that he loved the previous message, and then responds with, "Y'all y'all rock my world with a heart emoji. And she responded again with an action of loving that previous message and with it's a very small emoji, hard to tell what it is after the action.
And then what's the next entry?
The next is an instant, is a message with an attachment, and that's from Doug to Ashley at 6:47 in the morning.
I'm going to pull up the attachment. And again, what is that?
Appears to be another Bible verse.
And if you can continue.
So after there's a message from Doug, says good morning with emojis. And then also an additional message at 9:28 that says, got an email from Stephanie after she talked to Faith. Since order to meet, mediate will meet for 1 hour tomorrow to stop court next week. You dismissed injunction. We sign joint stipulation to dismiss dissolutions and hold until Moreland signs. Order for report. As soon as she signs order, we file dismissal and we're done. Looks like praying hands emoji and a heart. And then there's an additional message after that. And we have joint session with Dr. Q Friday to wrap up our adventure in Florida, FL, and leave with understanding of double knots and red-blue inversion. After that, there's an action by Ashley Christina that said, loved an image. And it continues with a good morning. And there's an emphasis by Doug of good morning. Ashley Christina responds, oh, okay, I'll reach out to Faith to follow up on all the above with a thumbs up. Doug takes an action about and liking that previous image and then says, and we're done. Again, praying hands emoji. And also responds, and all in first 10 days of Jewish New Year, LOL. It continues with an action of laughed at the previous message. And then at 9:57, Doug responds, you gotta laugh. September 18th was first date of Jewish New Year, 3 years to date of your Odyssey starting day of ballet launch, Rosh Hashanah, the first of the Jewish days of awe. We can call our Odyssey the days of all, LOL. At 10:13.
Was he Jewish?
It says from Doug, so perfect outside. Looks like a sun emoji. Ashley responds with an action for those previous messages, which just repeats. And then writes, oh yay, we should do Selby today. He responds, oh yes, with a multiple M's and yum. She responds with a few emojis. He emphasized the emojis and then adds, Stephanie just sent Faith joint dismissal of everything except injunction, which Faith has to do, just one pager, and also responds, what time thinking Selby? Ashley Christina responds with the action of liking it, and then says, maybe 1:30-ish. I'll text you when we're headed that way with a thumbs up.
Hello, it's Britt. Thank you for joining.
Come pick you up too. Then adds more time with my baby. Then adds mediation tomorrow by Zoom 10:30 and be quick. Ashley responds with the action of liking that. Then added, sorry, just looking at my phone. You don't need to drive all the back to LWR to get us if you are already downtown. But if you want to, that's fine. Just let me know either way. Doug responds, I'm at apartment. Adds, so pretty, enjoying pool area, finally to work, LOL.
Sneaky side, I'm not understanding that last comment.
From Doug.
That is from Doug to Ashley Christina.
And I'll pull up the- I don't know why.
Coffee is
Close
hot
that.
and
Let
good.
me open it again.
Hi, Jules.
And what number were we on?
132, that was the attachment.
Thank you.
Oh yeah, Ashley would look better in jewel tones. Yeah, I got it now. That color is washing her out along with the,
So after the
it matches all the benches.
What's the next communication?
Why is the courtroom? Oh, because of the film. That's why it's dark.
It's a message from Doug to Ashley Christina. I'll just head your way at 1:30. Ashley Christina responds, hot, nice, okay, just getting our things together now. Maybe head over in like 10 minutes, 10 MIM. Doug responds, okay. And then after that is appears to be an email from Doug to Ashley.
And after that?
After that is incoming message from Doug. Do you want to get together tonight or in morning before mediation and unify the instructions for Faith and Stephanie? Think we are going to need to keep involved until this is done or will drag out. She responds, ha, okay, thumbs up. He responds, thumbs up. Prefer tonight, maybe run over Pandera or in AM, question mark. And she responds, sure, can do Panera tonight.
Okay, so I want to back up a little bit. We were talking about the entry that was the email before that. Does it have the content of the email in this spreadsheet?
It appears there's quite a bit of metadata involved, but the actual content from what I'm looking at is not actually in there.
Okay, does it say any names associated with the metadata?
There's an email address of Stephanie Murphy. It's at murphylawsarasota.com. There's an email address related to Doug Benefield. And there's, I believe those are the two names that I see that are associated with.
So we left off at sure can do Panera tonight.
Yes. And adds 8 question mark. She responds with a thumbs up. And that was at 7:27 p.m. And she responds with at 9:55 p.m. with a good night and a sleeping emoji. And he responds also with a good night with another emoji. He adds sweet dreams and then also sends an attachment. Correction, the sweet dreams was the last one at 9:56 p.m. The attachment I just referenced was actually 7 o'clock in the morning the next day.
Okay, so the next day I'm clicking on that attachment. And what is that?
Looks up here, a Bible verse.
And what are the messages after that?
All right, so attachment. After that, there's a good morning with a few emojis. If you want, you can come over here for Zoom. And adds, we can grab bagel in CHI. It's 10 a.m. BT, by the way, BTW is for short. And then there's a phone call at 9 o'clock, 9:07 with no seconds. There's a 151. It says there's an incoming message with no body. And then after that, there's an incoming message with an attachment that appears to be related to connection to a Zoom meeting, possibly. And then
I'm going to click on that attachment to see if it will come up. It's one of those that will not come up. So go ahead.
The next after that appears to be an ID number and a password typically associated with Zoom meetings, and then a phone call with no seconds. And then 9:38, it continues where Ashley Christina loved an image, then liked the message. It's 10 a.m. by the way, and then added, ha, oh man, okay, thanks for the heads up. He responded by liking that, and then added set up here if easier for you. And she responded, that's okay. I guess I should brush my hair and change out my PJs. LOL, I think I can just do it from my phone. He responds, LOL, you can. She liked LOL, you can, and then added quick and easy LOL.
And what was the time difference between the like of LOL you can and the quick and easy? Approximately.
About 15, 20 minutes.
Okay. And then what was the next entry after the quick and easy?
So it was another action by Doug for that quick and easy, and then added, so nice to experience quick and easy. Finally, LOL. Then adds smeshing good. Then adds PS, you looked great for just rolling out a couch. LOL, and added an emoji. He added, I'm working on brief, head over soon as get to stopping point like one. She responds with the action of loving the previous message, or one of the previous messages. So nice to experience quick and easy. Laughed at also the PJ, the PS, looking great comment. And then added, ha, thanks. Figured I should put a clean shirt on even if I had PJs on the bottom half. LOL. She adds, and okay, just let me know as you're finishing up. He adds, just to ponder while I finish up, thinking about getting all the cars up here, and I thought was to ship the Cherokee up there by transport, which is 900, and either tow my truck or tow to your Jetta. The U-Haul plus the car trailer is about 1,000. That's for the biggest truck, which gives us plenty of room. The option is another pod and tow one of the cars behind my truck. Overall price about the same. U-Haul, more flexibility, like taking things straight to storage. She responds, okay, things to think about. Maybe best to have you drive the U-Haul and tow your truck behind. Mom and cats will go in the Jeep and I'll drive with Emerson in my car. She added, LOL, the Beverly Hill. He added, LOL, the Beverly Hillbillies, coming from dem slums. Forget about cat courier requirements, LOL. She laughed at the Beverly Hillbillies comment, added LOL, then added, I believe, several cat emojis. He laughed at the emojis, then added, headed over shortly, brain approaching short circuit. She added, ha, okay, well, give me a bit longer, finishing up mom's closets now so I can get the cats locked up. He added, he liked.
How many cats
the previous
did they
message.
have?
And then there's a
Sounds like they had 30.
outgoing phone call to Doug for 38 seconds.
These are boring. Right, sneaky side.
Outgoing message from Christina says, headed that way. He responds, or he took the action of liking it. Added, we done good, LOL. We have Dr. Q at 10:30. Good night with an emoji.
Okay. So the liked headed that way was at what time?
That was at 2:00 in the afternoon.
And then the good night was at what time?
It's 8:27.
Okay.
At night. Saw two of them. Apologize.
And then after the good night.
After good night, there's an outgoing indeed LOL good night from Ashley, and then after that there is an attachment at 5:45 in the morning from Doug.
Okay. And I'll click on the attachment. What is that?
Another Bible verse.
Yeah, Jules is sitting directly behind her with the black jacket and the gray shirt.
Appears to be
That's
another
Jules.
attachment roughly 15 minutes later.
Okay. And if you could read what this says.
Live a life filled with love. Another Bible verse, Ephesians 5:2.
Yeah, she's directly behind her.
At 9:26, there's a message from Doug. It says, good morning. Minute later, there's an action of loving an image. Second, loving a minute image. And he responds with Dr. Q's at 10:30. Do you want a CHI? Question mark.
I think that's chai.
Correct, Andrea.
At 9:27, there's a response from Christina, says, good morning. There's a repeated response, previous message. Dr. Q is at 10:30. Do you want a chai? And then Ann Bagel, he added to it. She responds, "Ha, that's okay. Thank you. If I do that this early in the day, I'll be done for the day. LOL. But thank you." He added, he liked that message. And then the next appears to be an attachment from Doug related to possibly a YouTube video. And that was at 9:56 a.m.
And it's another one that won't open. And then the next entry.
It's at 9:20, correction, 10:40, 35 a.m. From Doug, are you able to make it? Are you able to make Dr. Q okay? She responds, yes, LOL, be in a minute. He responds, no rush. He's still not out, LOL. She responds, I know, LOL, waiting for mom to come out so we can swap.
Wait.
There. And then after.
Whoa. The doctor never said, nor was he asked, but he was seeing her mother and both of them. That's a conflict of interest, is it not? Even if you're doing marital therapy, you could not. Oh, that's not good. I think what they're trying to show with these messages, there was not any abuse or fighting. There's nothing bad. But if I'm correct, and I'm not a licensed therapist, but I remember we had to do some counseling, but I don't think it's good for the doctor to be seeing the mom and the two of them all at the same time. That's just wrong, right? Am I right about that? What the heck? Conflict.
There's 10:42:35. There's an LOL from Doug. There's a phone call. It's
Now the LOL was at 10:42 a.m. and then what's the next entry?
correct. 10:42 a.m. was the LOL, and then the next is at 5:39 p.m., which is a phone call from Doug, and with 0 seconds. Then adds after the phone call, I be here, and then another phone call for 15 seconds at 5:40.
This is read yourself.
PM. Then,
Your Honor, not to attack Sergeant Kibis because he's been reading for a while, but it's a little tough.
I know they can have good moments. I'm not saying it didn't happen.
That's fair.
And I don't know why, but I think your numbers may be off.
off different from this.
They might be. Can you look?
IB here is
Okay. Well, they kind of sort that out. I want to say this. In no way am I saying that because they're having nice texts that abuse can't happen. I'm just saying I don't think it was to the level, because I'm not hearing or seeing anything that would make me feel like both of them were not trying to reconnect again. And I'm not seeing any arguing. Now, at the same time, I fully understand that the DA could still happen. DV can still happen. I'm just surprised. I expected to see more arguing back and forth. It makes a doctor too entrenched to patient life, plus a doctor no multiple sides of the same situation that can lever against each other. If the doctor is a weirdo, sometimes they are. Yeah. Okay. So while they're doing this, I'm going to go to little girl's room. I'll be back.
Well, we're not using the numbers that are built into Excel. I want to say
Okay.
the
That's
numbers
what it is.
are an actual column. So technically IB
Haley
here,
Mouse, Hattie girl.
That's what you're looking at.
correct. IB here
Okay.
would be 212.
If he gives you that number, are you okay with that?
Can you show him?
These numbers here match what he's saying. There's numbers on the Excel spreadsheet showing that's what was confusing. But the numbers he's saying are the numbers on the sheet.
So
We're on 215, correct?
Correct.
Okay.
Okay, so if you, Sergeant, if you could just call the number out.
Sure. Not a problem.
Thank you. Thanks, Judge.
Of course.
So we left off of 215, which is at 9 o'clock. It's a good night with an emoji. 216 is an attachment, a JPEG. And that was at 6:43 a.m.
And that is on the next day, correct?
Correct.
9/26.
Correct.
And I pulled up the attachment. What is that?
That's like a Bible verse.
And then you can continue from there.
All right, so moving forward, 217 is from Doug with a good morning. 218, she loves the image. And 219, she responds with also with a good morning. 220, Doug sends ready to start with a thumbs up. 221 is a call log with from Doug with 0 seconds. 222, there's a message from Ashley Christina. Okay, I'll text you in a bit with an emoji. I can't tell what it is. Pretty small. Next record is 223. Just one of those action messages, liked a previous message and it repeats. 224, want to come pick me up and we can go get the truck.
And that's from Ashley.
And that's
correct?
from Ashley. Okay. And Doug responds, sure, with 225, sure, headed that way. 226, IB here. And that's at 12:41 p.m. And then 227 is all the way at 9 o'clock in the evening. And it's from Doug, and it's a good night, sweet dreams. Then at 228, 9:23, Ashley responds with the action of loving the previous message and also responds with a good night. 2:30, there's another attachment at 6:42 from Doug to Ashley.
I'll pull up the attachment. What is that?
It's the Bible verse. After the attachment at 2:31, Doug sends good morning. 2:32, she responds, loved an image. And 2:33 with a good morning. 2:34, he responds with looks like a strong fist up emoji. And 2:35, there's also an incoming from Doug with just a little rectangle. 2:36, she responds with LOL. 2:37, he responds, what y'all working on? And that's at 1 o'clock in the afternoon. 2:38, about 15 minutes later, she responds, last cram, LOL, using big boxes and getting the last loose stuff packed up and ready. And also responds on 2:39, how's it going over there? Making progress? He responds at 2:40, number 240 at 1:18 in the afternoon. Loose stuff should be a chapter in our book, LOL. Got everything out and in garage ready to throw on truck except couch, AKA bed. pretty much emptied, taking solely to get his shots, then to doggy spa to get groomed and stay until ready to go. 241, he adds, I'll come there after drop him off at 3.
Protein drink.
242, she responds with the action of laughing at a previous message, and it just repeats. Another action of liking a previous message, then adds, 244 adds, great, could you run by Lowe's before you come over, grab a few large and mediums. 245, he responds, sure, I need a few too, which is at 1 o'clock in the afternoon. At 2:35, number 246, which is at 2:35 in the afternoon, it's just a like by her, sure, I need a few, which just repeated from earlier, and then adds, just to be safe, let's do 10 of each just for the last bits here. 248 from Doug, he likes the previous message and adds,
I have Jolt. It's like a coffee shot. Makes it palatable. But I need to start. I'm having some tummy issues.
and 249, okay, let me know anything else if think of. 250, she responds, tape. 251, and also adds LOL. 252, he responds, ha, K. 253, just finished vet, headed to spa, LOL. 254, she laughed at that previous message. 255, he says, headed there. 256, she responds, okay. The next line, 257, I'm here out front. She responds, okay, 1 minute.
Now, when he says, I'm here out front, and she responds, okay, 1 minute, about what time is that during the day?
That's about 3:54 in the afternoon.
Okay, and the next message, is it about what time?
3:55 in the afternoon.
And the next after that?
After that, it's 5 o'clock in the afternoon.
So there's an hour and several minutes in between these two.
Correct.
Okay, so after okay 1 minute, what is said?
Then 2:59, about to head back from Doug. And the message after that appears to be an attachment at 5:11 in the afternoon.
And I'm clicking on the attachment for the record.
Yeah, appears to be
Go ahead, I'm sorry.
it appears to be maybe the U-Haul truck that they're loading up.
And that was sent from Doug.
That was 5:11. Yeah, that was incoming. Yes, from Doug to Ashley.
Okay, and then the next message?
The next is from Doug, and this is number 261. Everything in except couch and 10 medium boxes and tutu cab, LOL. 262, she laughed at the image. 263, she responds, ha, OMG. 264, he responds with trucker on the way, and that's at 5:32 p.m.
At 5:32 p.m., was that the last communication between these two?
I believe so, yes.
Thank you. Judge, can we approach just a moment?
Yes.
Before.
Sidebar. Hey, beautiful Jules. Quite boring, isn't it? It started with a bang, but now it's pretty boring. Oh, these drinks are nasty. Almost got it down. I can't look at Cindy Arian's message because the emojis are going to make me with this. Well, I need to lose weight. Oh, it's okay. I'm just kidding. I need to lose weight, but That's not why I'm doing this. Just my stomach hasn't been happy lately. So I'm trying to be gentle. Hallelujah, I'm done. Get rid of that taste. Makes the coffee taste even better.
One legal issue that I need to resolve before we finish up with this witness's direct. So I'm gonna excuse you in the back. It should take about 10 minutes, my best guess. So please don't begin deliberations amongst yourself. You can communicate outside, send and receive texts, emails, telephone calls, but just don't talk about the case. But don't do any research on the people, places, things, or legal topics you've heard anything about. I'll get you back out here as soon as I can.
Oh, I love you, but no. Mama Belly from hell. Yeah, Miracle Coffee Chaser. This reminds me, guys, gotta do it. My wonderful sponsor. Thank you so much. Hey, y'all. I am so excited we have our very first sponsor, and I'm wearing this hat to honor them. Who is it? Well, it's coffee, my favorite thing. This coffee is from Hitchman Homestead Coffee. This is the Shooter Shack Coffee Pioneer Nicaraguan Roast. This coffee is so delicious, y'all. It is so smooth. It does not leave a chemical taste on the back of the tongue. It's not overly bitter. And I have to tell you, it is my favorite. And I am now getting rid of all my other coffee. I kid you not. They have a monthly subscription available. You get 4 12-ounce bag a month, either whole beaned or ground. And then you can also get a Keurig option as well. The other thing they have is wonderful gift boxes that you can send to your loved ones. So you want to support a fabulous home business and people here in the Hill Country, go to hitchmanhomestead.com and let them know I sent you, and grab yourself some of the best tasting coffee we have here in Texas Hill Country. July has been an amazing month, and to end the month, we're doing a subscription campaign. And if you want to win a free Starbucks tumbler, just click the subscribe button. That's it. It's easy. Then leave in the comments, I sub, so we can get you in the drawing. The winner will be announced July 31st. Good luck, everyone, and thank you for subscribing. One more. Well, guys, it's that time. We need a logo, we need merch, and a website. So I decided to have a competition. The person who creates the winning logo will get a t-shirt, hat, and a $50 gift card. And the logo will be featured on everything that we have: Facebook, YouTube, Twitter, Twitch, the website, my email, all the merch. So if you're interested, deadline's August 15th. The winner will be announced on the 1st of September. Thank you so much and good luck. Yay, we're done. Actually, we're not. This is something y'all want to see. This is good. Welcome to our newest mod, Sneaky Side. I have to say, without people like you, I wouldn't be where I am today. Over the last 2 months, we have been growing so fast, and mods are my right and left arms. I can't do it without you. First, I want to thank all my current mods, and Sneaky Side, thank you for joining the team. I look forward to creating with you and us just laughing and growing this channel together. Again, welcome and thank you so much for joining us, Sneaky Side. Okay, we're done. I just felt like we needed a cleanse. We needed a kind of. Do you know what put all the weight on me? Because I was skinny most of my life. What put the weight on me? Prednisone, methotrexate, other meds for rheumatoid arthritis. And I was on it for 10 years. Prednisone weight is hard as hell to lose. Oh, you're welcome, sneaky side. You're welcome, beloved.
Detective, I don't know to what extent we're gonna be talking about the testimony you may have. So I'm gonna go ahead and excuse you for right now, just to be cautious. Please understand the rules of sequestration, the rule of sequestration has been invoked. You're not to discuss your testimony or the answers you've given or the questions you've been asked with anybody outside this room. You're not supposed to talk with any other witnesses about the testimony they've given, the questions they've been asked. And to my understanding, this may be online, you're not to watch or view anything related to this case until you're released from your subpoena or the jury's returned a verdict in their discharge. Understood. All right, so just step outside and get you back in as soon as we can. No, I think it's fine because I think they're still going to meet them down. I can see all right. Okay, the detective is out of the room. We can have argument on this video.
Thank you, Judge. And thank you for rehearing the issue. I had a chance to research it. We obviously weren't.
If you've got case law,
Well,
contrary to what people may think, I want to make the right decision. So if you've got case law, I want to hear it.
Thank you, sir. I actually just sent one to the printer because I didn't know if you'd rather have it, but it's called Lumark. I don't know, LUMARQUB. It's 44 Southern 2nd. I'm sorry, Southern 3rd, 171.
Say that again.
Sure, 44 Southern 3rd, 171. There's a yellow flag, but it's for a different reason.
Woman, get on the dang
This
mic.
case was,
Get on the mic.
are you looking it up electronically or would you like a hard copy?
No.
I can't interpret it.
I'll take a copy if you have one.
Give me 1 second. Sorry.
Oh, that's all right.
It would only
Is
let
that the
me
only
print-
one you've got?
it
No,
would
you can
only
have
let me
it.
print one at a time. I can do it, Judge.
Sorry, I can't interpret this. 2K got it. Too echoey. Cindy, RN, what did they change you to? This is what I'm on. That's my new med, and I'm liking it.
We're not going to do anything until you get a copy. Of
It should come in.
course, I can't blame their decision.
Oh, okay. I am trying to avoid infusions is my issue. I'm not wanting to go through infusions. That's last resort. Last resort.
All right, go ahead.
The part that I'm referring to is on the second page. It's a short case, luckily, where my reading of it is there were text messages and photographs, which I think videos and photographs are treated the same in most case law.
Are y'all understanding this?
In my feeling, but that there were images and text messages that could not be authenticated by an ex-wife on the defendant's phone. And the trial court did not allow them into evidence. The third DCA here said the court erred. The
Sorry.
text messages were found on the defendant's cellular phone.
Can you slow down just a little bit for the court reporter?
I apologize. The images and text messages were found on the defendant's cellular phone, seized pursuant to a search of the defendant's home through a warrant shortly after the alleged incident. This fact was testified by the state's forensic expert and is sufficient to authenticate.
Is that better?
Here, those phones have been in evidence since the day before. The contents of them were admitted.
See, Morales, is that better?
Trial exhibit today, and not objected to. The only thing is this one video was objected to, this attachment. And the state would argue based on this case that we have established this phone was properly searched
properly downloaded, and the material was found on the defendant's phone, the video found on the defendant's phone, and therefore the state argument should be admitted.
All right. Mr. Taylor?
Just 1 second, Your Honor. Okay, I distinguish it on 2 bases, Your Honor. They quote U.S. versus Caldwell 11th Circuit decision, holding that authentication of evidence merely requires a finding that the evidence is what it purports to be. Well, that's the exact issue. Sergeant Keyless cannot do that. He can only say this is a video, it was on the phone. He can't say it's a true and accurate reproduction of what took place on that morning. He doesn't know, for example, who was there that might not have appeared in the video, what the motivation was that brought them there. He wouldn't be able to say whether it was under coercive circumstances. I don't think he qualifies to be able to lay that predicate. And second reason why I don't think this case is applicable is in this case, they held that it was admissible because it constitutes evidence of motive. Judge, this is a second-degree murder case. As the court knows, motive in second-degree murder is not an element. There is no obligation that murder be proven. I don't think they can lay the necessary predicate for it.
State rebuttal.
Just that I think defense counsel's arguments go to the weight, not the admissibility. I think this case stands for the fact that we've entered, without objection, cell phones that contain this video, and then now without objection, the trial exhibit with the attachments and the CD. The objection was just to one after, which I think is also an issue, but I think we don't have to get there. But I think this case stands for the fact that once we laid the predicate that this was a properly searched phone and that the data on it was properly removed and the detective testified that everything was in order, then we've laid the predicate for the contents of the attachments to also be admissible based on this case that I can't say the first name of.
What was the date and time of this particular message?
The message was, I don't know that you can read the small print on that, but there's a copy, but it is, if you're wondering if it was before the Panera conversation or after.
I want to know the day and time that this attachment was sent.
It was sent 9/20 of 2020 at 6:40 p.m.
What number are you referring to?
of 25.
And the Excel spreadsheet, which is the data dump from the defendant's cell phone, shows it's in blue. So it's
From the
from,
defendant's phone. So it's from the defendant's phone to, I'm sorry, from.
Correct.
the
It's
victim's
from-
phone to the defendant's phone.
right, it's from Doug Benefield's phone
Yes.
to Ashley Benefield's phone.
Yes.
All right. Any further argument? Because I wanted to ask that question, know specifically when. Anything else?
No judge.
All right. No objection or no judge?
I thought you said, do I have any further
Anything
argument?
else? And you
Yeah,
said no?
And I don't, no judge, sorry. Yeah,
Okay, well, as I said, if there's case law out there that is contrary to a prior ruling, I think it needs to be brought to my attention. And what State versus Lumarque, Lumarque, 44 Southern 3rd, 171, at 172 to 173, Florida 3rd DCA 2010, states pretty unequivocally, the images and text messages found on the defendant's cell phone seized pursuant to a search of the defendant's home through a warrant, which it wasn't here. It's my understanding, the testimony that I heard was that they were provided to law enforcement. Shortly after the alleged incident, this fact, testified by the state's forensic expert, is sufficient to authenticate these exhibits. So the issue is authentication, and that's where I had initially sustained, because obviously there was got to be no witness, this Keyless, sorry.
He says keyless entry, that's how to remember it. It helps me.
Keyless certainly could not authenticate the video. And just to be clear, I'm not sure, I think it's on the record that it's going to be a video of the defendant and her mother that's taken by a third party. I outlined it pretty in depth in my order denying the stand your ground.
Thank you.
And like I said, certainly the
Phillips
technical
and
services
Victim,
unit
thank you
couldn't
so
authenticate it, saying that it's the traditional way, that it's a fair and accurate depiction of the events of that day. So then I had mentioned that the bench, perhaps the state could lay the silent witness predicate. However, I don't find that the silent witness predicate was sufficiently laid by the detective Keyless. However, apparently, according to this case, it is authenticated by the fact that it was found on the defendant's cell phone that was seized shortly after the incident. And at this point, it's been sufficiently testified to by the state's witnesses and the forensics expert that he did find this video on there. In fact, in addressing the defense arguments, the third DCA goes on to say, regardless of how these images and text messages might have found their way onto the defendant's cell phone, the state has presented sufficient evidence at this stage. Certainly, they met the admissibility that these exhibits constitute evidence of motive. As we've discussed, motive is not an element. But the state has made the argument in the past and makes today that the entry of these items is not for the truth of the matter asserted, but to show the relationship and interactions between the parties in the days leading up to the homicide, and the normal texts and banter and communication of a married couple that is in the middle of a divorce. So for those reasons, I will reverse my prior decision, and the video would be admissible under this case.
Wow.
So we did that specifically so you could finish with your direct, and the ruling is made, so then it's available on cross. I know we talked about different options, but I'm glad we did it that way because I think it makes a lot more sense.
So we can recall him and play it, and then we'll send it.
Correct. So when the jury left, he was on the stand.
Oh, I'm sorry.
Right. So I'm just going to put him back on the stand. The jury won't know any different. All right. So if we can bring.
Can we take a quick restroom break?
All right. 5 minutes.
Just 5
Sure.
minutes.
Okay.
Thank you, Judge.
Can y'all hear the fan on my microphone? I gotta confess, guys, I'm not feeling all that great. So if I disappear for a few seconds, kind of figure out why. Oh, yeah, I'm not feeling all that good. Why didn't Jules? I didn't hear her phone. Are we that far? Are we behind?
Your call has been forwarded to voicemail.
Shoot, Jules called and I missed her. My phone didn't ring.
Good morning, Sergeant Keeler.
Good morning.
I want to make sure that we can establish the contours of your testimony.
There, I got that done.
Technical Services Unit,
Fixed it.
you're capable and authorized to extract this information from the cell phones of both Doug Benefield and Ashley Benefield.
Yes.
You don't know the context about the message.
If I have to step away.
Just are able to read what's printed.
I can read
I will leave this up.
what's printed from the extraction, yes.
Right. But for example, there were quite a few Bible verses. You wouldn't be able to necessarily tell us that Doug Benefield's a very religious guy. You just can tell us, here's the Bible verses that he posted.
Yes, I could tell you that he sent a Bible verse.
Okay. And you can't tell us the reason that either party may have had for sending a particular text. You can only tell us this is what the text says.
Correct.
You can't tell us whether the text is true or false. You can only tell us what the text says.
Correct.
You can't tell us if the text is genuine or motivated by fear. You can only tell us what it says.
Correct.
I'd like to pass you what we've marked as Defendant's Exhibit 3 and ask you if you can identify it.
I would object to be on the scope.
Okay, I don't know.
Come here, Brett.
Yeah, guys, I'm sorry I have the fan on me. Just feel weird. Don't know why I do, but I do. I'm just making sure we're caught up. I did take my medicine on an empty stomach. That's why I went and got that protein drink. So that may be the reason why. I apologize. I should know better. I just couldn't get up when I needed to this morning. Didn't get breakfast. I didn't go to sleep until like 4 this morning. So, yeah. Jill said, I tried, but back in court now. And I'm like, I'm sorry, I fixed it. My bad. Are you kidding me? I'm so tired of this crap.
I'm going to pass to you, Sergeant Keyless, what I've marked now as
Where'd you see that?
Exhibit 3. Those would they not, text messages that you also extracted?
I believe these were the text messages that you may highlighted during a deposition, and
Yeah.
we
and
confirmed that these came from, I believe, Doug's phone.
Correct.
Yes.
And that we requested.
I apologize, Judge. I do think it's referred to that.
Mm. I'm on her page, but I don't see it. Hmm. Y'all, this is bad. It is getting to be mayhem. And, no matter what's happening, you don't have to go and destroy historical monuments and historical. Oh, I got somebody. I missed. Isn't it showing it? Oh, it was a cat. Okay, God, I thought I missed somebody. I'm sorry, guys. I'm trying to hang on. I really am struggling here. Let me just get some gentle music going. Sorry, I muted myself. Guys, I am really not feeling well. I don't know if it's the protein drink or the medicine. But if I'm quiet, please forgive me. Yeah. I am. Yeah. So I think what I'm going to do is just come off the screen for a little bit. I'm going to let the video go and just try to get myself together. But I'm going to just have that up there so people know we're live. And I'll be right back. Okay.
All right, members of the jury, this is going to take a little bit longer. So what I'm going to do at this point is it's about 11:30. I'm going to let you go to an early lunch. So if you could be back downstairs in the jury assembly room at 12:45, that gives you a little bit extra time. That'll give us time to take care of what we need to take care of. And we'll get you back up here as soon as we can right after your lunch break. Please remember, don't discuss the case amongst yourselves. Don't discuss the case with anybody else, and don't do any research on the people, places, things, or legal topics you've heard anything about. All right, thank you.
Okay, well, now I got to be ready in case Miss Jules calls. Thanks, guys. I'm just.
Okay, Detective Keyless, we're going to let you go also for lunch. Just remember the admonitions from earlier. Don't discuss the case with anyone. Don't let anyone discuss the case with you. Don't talk with any other witnesses. You can't talk with the attorneys about your testimony. Don't do any research or watch anything online. Understood. If you could be back here at 12:45. Sure. All right. Thank you, sir.
Yeah, y'all, I'm feeling pretty green.
Okay, we'll see you back here at 12:45.
I will start a second. No, I'll just keep this live going. No, I'm afraid to eat anything. That's why I did the little protein drink. I'm kind of at the point right now of think if I eat something, it's not going to be a good thing. I'm going to see if I can get through the thing with Jules whenever she calls, and then I will leave the court thing up and take a break and try and eat. And if something happens, I have time to recover. Well, maybe I can try some of this. But yeah. Actually, I think I'm starting to feel a little less green. But man, I don't like it when I feel like that. That's the worst feeling. What is happening? I'm going to see if Jules called. She probably called RA first, which is what she's supposed to be doing. I'm glad she did. Mm. What? Oh, it's relieving. Mods, you may need to hold down the fort. Yeah, hold on. I'm listening. Jules called RA. What is a heads up game? I'm listening. Hold on. Oh, I'm listening because she bolted in the middle of a phone call. Something happened. I'm waiting for her to call me too. Well, um, give me a second. Oh, oh, okay. Jewel just saw somebody she recognized. Something happening with Sarah Boone. Hired an investigator. Okay, I'm not going to worry about any of that right now. We're going to talk about us. Okay, I'm feeling better. It's passing. Thank you guys for your love and your understanding and your willingness to um, just work through this with me. I'm starting to feel the relief. Ooh, that was bad. I thought I was going to have to really have a problem. Okay. Jules has some skinny. I'm hoping she calls me. No, she hired an investigator, not a lawyer. I would love for Uncivil to take her, man. That would make good entertainment. My mouth is dry though. I'm good, but my mouth is like cotton. So the thing about the text messages for me was I really have no problem with them. It I'm confused. It shows a loving couple. It shows sorry. The TV just I mean the feed just put music on. To me it shows a loving couple. To me it doesn't show anything like what's been described. I'm confused. I don't understand the difference between them. It almost sounds like a couple that oh kitty kitty a couple that recently got to. I mean they're moving. It sounds like they're just moving. It doesn't sound like anything that's been presented. So I'm very confused. What about you guys? And the other thing is this morning's drama. What do? I share it or do I wait for Jules? Let's see if Jules calls me. If not, then I'll share it. But let's just say, what are you doing? Hellion! Attacking me. Attackingly. Let's just say there's some Jules involvement of this morning's episode. What are you doing? What are you doing? I love it when they don't want to kiss. They look, got you. She's like, you got me. Look at this. Look at this look. And that tail is just a going. She's very tail expressive. What's up, baby girl? But I know how to calm her down. Watch. That right there, instantly. Look at the face change. Oh, Samantha. Oh, last night was incredible. Oh, thank you so much, Samantha. Thank you so very much. Airplane ears. Yeah. Jules, spill the tea. Well, I'm hoping. I'm waiting. Oh, look at her. She's all like, thank you, guys. Lazy and Samantha, thank you for coming on. I really, really appreciate it. It's been a very difficult morning. Yeah. I love it when they're like this. We like it. Oh, let me love on you. Let me love on you. Let me love on you. Come here. Let's get the position. Okay, now she likes this. She loves this. Yeah, look at those eyes. She's all like, oh, mama loves me. So anyway, I will say there was Jules' involvement of this morning. There was Jules' involvement this morning. Yes, there was. You want to tell them something? You want to tell them something? Meow. Meow. Y'all gotta see this. Watch. Meow. Meow. She's like, I'm out. She's a little unusual. Oh, now you're going to talk to me down there on the floor. Oh, hi, you guys. Oh, what? Oh, gosh, all of a sudden I'm feeling better. It's like, whew. Okay, back to this stunt. There is a lot of tea going on for those who may have missed it. Oh, she's playing. For those who've missed it, we had a lot of going on this morning. All the jurors got questioned this morning in court because one of the jurors was in a restaurant. The TV was playing something. I don't know what she's playing with, but she's got something. But what is it? What? Oh, she's curling. Do you know how they roll on their backs and flip and she's meowing? She's jumping at spots on the wall. She's going crazy. So anyway, a juror went to lunch and walked in a restaurant, and then all of a sudden the trial news came on. They got their order and left. Another juror was in a restaurant, or it may have been the same. I don't know. I think it was another one. And they asked for the TV to be turned off. So none of the jurors were dismissed. We still have the original jurors. But the big thing was, well, we'll go back to there. Somebody reported that witnessed the juror asking for the TV to be turned off. So that was reported. Then we had Eva the daughter of the victim. Oh my God. No, she didn't get into catnip, but boy, she's acting like it. Psst. She's acting like it. Good morning, Sinbad. Oh, we just love you and appreciate you. Thanks for hopping on. I don't know what this girl's got, but she is going underneath the dog bed. She's going ape nuts in here. We really appreciated you last night, Sinbad. We love you. And I am blessed that you have connected with us, and I look forward to getting to know you better. It's been a crazy morning. Thank you, Karen, but not Karen. Thank you so much. So, one of the things is that the girl, the daughter, has been, well, was talking to news media. She says she was caught off guard and she was under emotional distress from the trial, and she didn't say anything about her testimony. ... But she absolutely looked scared crapless. I mean, petrified. That little girl is hell on wheels, y'all. I have video I personally downloaded. We are going to be sharing that tonight. Please come on we're going to start at 7:00 and go to about 8:30. But that's 6:00 Central, and we will have Miss Jules, so that will be happening tonight. And I need to, in a minute, make a little thing about that. But we're going to discuss what happened with some of the witnesses. I will be showing the video I have of this young lady. Now, I could not find or locate any of my mods. If you can, let me know. Channel 8 in her town, they have not played her interview yet. I couldn't find it, but doesn't mean that it's not there. I just couldn't find it. Because they showed the TikTok. Yeah, well, Melanie showed her TikTok. Okay. I have a problem with one of them. They're not bad, but there's something in there. I don't know which TikTok she showed, but really, Jules? Let me see what's going on there. She has almost 4,000 people watching her. Holy crap. So, yeah. Yeah. I'm looking to see what videos she showed. Oh my God. Jules is counting the air conditioning vents. I can't. Yeah, she did show it. Well, for me is that yes, any have a connection? I'd love to have her on with me. I think that would be fabulous. So for me, the situation I'm having with these videos is the way she's behaving, not what's said. We'll talk about that later. I'm not gonna share what she said. I'm gonna let Jules share it. That's her story. But but I hope Jules will give us a call during lunch. Definitely. I've got to go get the door. I'll be right back, y'all. Right back. Okay, y'all, I'm back. So, with the situation with Jules is that she is hopefully will call me because I want her to share her stuff. I think it's important for y'all to hear it from her. I really do. She's an amazing lady and I want her to be able to share. Wait a minute. Oh, Sinbad, you're so funny. Thank you. Oh my gosh, it is so funny. Thank you, Sinbad. He just told Sinbad. Sinbad said, "Don't talk to them, Notorious Jules. By the way, AdaKay says stop by her channel while you're making the rounds." Sinbad, you're precious. Okay, I'm not gonna share her stuff. I'm gonna leave it. Sinbad. Snipping it is so fun. Thank you, love. I appreciate you. Cat? Seriously, are you on catnip? I was gonna say another word, but I don't want to get in trouble. By the way, y'all, last night was crazy in a good way. In a good way. So if you're watching and you weren't on, I'm going to be going live at 7 Central. Well, 6 my time Central, 7 East Coast. And then we've got West Coast coming in. But we're going to go live with Jules for the inside tea of what's happened in court today. And last night turned into a very precious time with all the people that were on and the mods and everybody. So if you guys want to hop on tonight to get more of the inside tea, oh my gosh, this cat. Oh my gosh. Really? Get. She's knocking everything over. It's like the dog's not here. I'm going crazy. Doing well. Need to find some breakfast. Yeah. I didn't get in time this morning I normally come in an hour early. I have everything set up the night before, and I didn't this time. Get the makeup on, scramble me some eggs here at the shop. We have a little kitchenette. And do my makeup, eat breakfast, and ease into my morning. And that didn't happen this morning. I only had 4 hours sleep about that. So, yeah, it's been a rough morning. It's lunchtime here. I picked up some McDonald's. Kids asked for fries. Yeah, I need to get off this fast food, y'all. It's just so convenient. But the thing is that we just had a rough morning. And, y'all are so kind and precious. Thank you. Okay, Jules, are you still on her? Yep. Jules is still on. I need to do this. Um, okay, I got it set up so she gets to come in. Okay, she's still talking to her. I think this is the first time she's talked to her. She's going to take a hot minute. Yeah, McDonald's fries are addictive, but do you know what's even more addictive for me? The Freddy's shoestring potato fries. Oh my God. Love those. And I have a great memory attached to those. My father and I used to get shoestring potato fries at a restaurant or drive through. I don't know. I think it may have been Freddy's. I don't remember. I was too young. And my mom would go shopping or do something, and my dad would say, "I'm going to take little one, and we're going to go get a little soda or something." And my mother would say, "Don't you get those fries, Curtis Lee? You don't need all that." Well, we got us an order, and we ate it and threw away all the evidence. Oh, you're welcome. You are so welcome. You are a warrior, and you are to be celebrated. All of us are to be celebrated. So anyway, I have a great memory attached to those fries. My father passed away almost 2 years ago, but yeah, that and saltine crackers with mayo, Miracle Whip actually, saltine crackers and Miracle Whip, and my mother would get mad because in the middle night late. Oh God, please don't tell me we're going to get rain. My sunroof is cracked. We would be watching a movie and she'd doze off in the chair and I'd sneak into the kitchen and quietly get the crackers. That girl my mother had like radar ears, and I got really good at sneaking out the crackers and a Miracle Whip. And Dad and I would sit Indian style on the floor, on the carpet in front of the TV and eat as quietly as we could. Oh, I know I am too. And I need to go to the ladies' room. And the moment I get up to go to the ladies' room, she's going to call. You know that, right? We shouldn't be getting rain. It's close, but I'll go later and shut my sunroof. Oh, I know delivering in the rain sucks. Okay, Miss Kevin, why was your chicken the best chicken? I've heard that in Africa, that when they cook chicken, they boiled it and it was like leather. Please tell me it wasn't that. I have a funny story. My spiritual parents have a ministry, and my spiritual father and mother have been in Africa many, 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 many times. And they went one time, and mom wasn't feeling so good, but they got in a car, and their cars are little. And they're 5 people crammed in a car that barely 4 could get into. And they go down the road, and then it goes to dirt, and then there's no road, and they're driving through a field, and it's just barely wide enough for the car to get through the field. And then they go on forever in the middle of nowhere. And then they get into this clearing, and there's a makeshift, what we would call just the roof. That's it. Building, and bunch of bricks and buckets turned upside down with wood on them for benches. Most uncomfortable. It was hot. It was miserable. Well, when you're there in Africa, the guest of honor gets the first of everything. And so they were serving lunch, and they brought this big pot, and it had boiled chicken. Now you understand, when they cook chicken, they don't take the claws off, they don't take the head off. They just defeather it and remove the innards, and it all goes in chopped up. So my mama wasn't feeling very good, so she thought she would pick the littlest piece of chicken. She knew she had to go first. And so she picked up this littlest piece of chicken, and it had a claw on it. The foot was on it. Now, you don't refuse it. It's very poor taste. And guest of honor, so my papa went next and picked out a thigh piece, a little piece of thigh, and he nonchalantly switched plates. But he ate that meat off of the foot. Oh, ew. Yeah, let's see. That's called village chicken, and their meat is tough. But in the city, we have fast food places called Hungry Lion, and they have the absolute best fried chicken. I bet. We ate brown sugar sandwiches. Yep. When we didn't have bread, we ate on crackers. And yep. Mm-hmm. Yep. It's very true. We ate nothing. We waste nothing. We eat it all. Yeah. Yeah, they don't. Mm-mm. Mm-mm. And then there was very few people had houses. And when I say houses, it's not like what it is today. Here, it's just 4 walls and a thatched roof, and the walls are made of dirt and dung. And mom and dad were being hosted in one of those houses. And just before their arrival, the host got a toilet installed and a wall to divide the bedroom from the rest of the house. Mind you, understand, the walls don't go to the ceiling. They leave space for the airflow. And you had, in order to get to the toilet, you had to go through the bedroom. So the whole family, you're in there sleeping, and the whole family's just traipsing through to get to the bathroom. But it was one of the old toilets where the tank was hanging on the wall. That's all they could get. And this was a huge deal. It was the only house in the entire village with a toilet, indoor toilet. And Papa helped them get the toilet, I think. And no one told mom that you don't flush that toilet at night, because it took forever to fill. And you know the saying, if it's yellow, let it mellow. If it's if it's brown, flush it down. Well, here you didn't even flush that because it took forever. During the day, you're out and about. They have bathrooms out and about, no big deal. So you could let that one in the house sit. Well, she got up in the middle of the night about 3 a.m. and it was whoo. So she flushed it. Americans, just instinct, not thinking. Oh, they were so mad at her. She has dug the pit in the ground. Yep. This is a very classy put together. Remember the doctor? Remember the lawyer yesterday, how refined she was? That's mama. Let's say there's a saying, I'm Zambia. Outside is the best. We only go inside to sleep. Yeah. My mom worked, so my dad did the cooking and he had a crock pot. If you ever knew what he was cooking in it, I think it's best thing I ever ate. It was beaver. I hear beaver is good. I hear beaver is real good. Let me see if she's still on. I think she is. See, I guess I was right. I think I was right. Remember we were talking about the rule about the confidentiality and privilege. And the lawyer got on the stand and was discussing everything, and people thought, "Wait a minute, isn't that client privileged? Why is she sharing all this?" Even though the client has passed away, the privilege still remains. Anybody, whoever's in the estate of the deceased person, I think in Florida, can give permission, and that may have happened. Yeah, a lot of things. It's like ASL doesn't translate. Yeah, it's super weird. But I know in some states, if the deceased if there's a trial or something happening, and a doctor, counselor, lawyer, or anybody has a client confidentiality privilege, the executor of that estate can waive that privilege. So that may have what's just happened. Guys, I will be right back. I'm going to go to ladies' room, and how much you want to bet Jules calls while I'm there. So hopefully I'll get there and get right back. I'll see you in a minute. Okay, me back. Yay, she didn't call. That is super weird. True. A lot of languages are that way. A lot are. I apologize. So, with this morning's thing, I wanted to talk about was the I touched on it. The juror overhearing. That's concerning. Maybe she's just getting something to eat. Jules is still on with Attorney Melanie Little. They're still chatting. So I would love I'd love to get on with Little Jewel. That would be awesome. So, no, I'm not. I'm not. I'm fighting this big time. Yeah, she's on with Melanie Little. But, and I think this is the first time she's talked to her, so she's saying some of the things she said yesterday. This case is, I don't want to say creepy strange, but this is strange. A juror and about the TV. In our little town, let me put it this way. We're about 25,000, same size as Canton. And when we have a big case here, there's only so many places you can go for lunch. Our town is about 8 miles, if that, in length. It's long and narrow. And there's only so many places you can go have lunch. And if there's a big case, it's virtually impossible not to go somewhere and not hear something. That's why I'm surprised that they're not making the jurors stay there at the court and ordering them lunch. I understand it's a financial expense on the court, but it's a bigger expense for a mistrial. I think that if you're on a juror, they should be able to bring lunch in, or you bring your own lunch. There was one juror said, I brought my own lunch and I ate at the park, a picnic. I ate out, I guess on park or grounds or somewhere. But I respect the fact that the jurors actually told the truth, and the fact that they requested the TV be turned off, or they got their lunch to go and ate elsewhere. That is respectful of them, but it's so hard in a case that's so public like this to avoid hearing something if you're in public, especially if they have TVs and they have it on the trial. But I'm not surprised it happened, I guess is what I'm trying to say. Not surprised at all. And Rio, I'm going to talk to Braxton and see if there's any way y'all two can connect. If you want, if you need it, let me know. Let's see if we can get something going on with Braxton and see if there's something that can be helped with your computer. Just FYI. I know, Karen, not Karen. I love that. And I feel bad for all the Karens out there to have that stigma attached to your name. So, wouldn't surprise me if there's any other issue that the judge didn't say, y'all got to stay here. In my humble opinion, they should have stayed. This should not have happened. They shouldn't be out in public. It's one thing if they say you want to go home, you can go home, but you got to be back here. Yeah, we need a different term. Hi, Toy. Hi, bless you. Thank you for being here. And the other thing that happened was a reporter had approached Dr. Quintel, whatever, Dr. Q. He did not accept the business card. I think the judge misunderstood that. He said that he refused the business card and did not answer any questions or didn't say anything. That was smart, very smart on his behalf. But what concerns me is why inside the courthouse is media approaching people. Media should not be approaching people in the courthouse. That's inappropriate, and they know better. What pictures are they showing? Oh, they got pictures of I guess this is his. Hold on, I'm looking. I have not pulled up his Doug's Twitter account. Okay, I'm going to pull it up. That's a good idea. I'm pulling up, see if I can pull up Doug's Facebook page. Yep, there it is. We got it. Let's see. Photos. See all photos. Aww. These are great photos of them. How? Okay, I'm gonna share screen. I'm gonna share screen. Let me share this. Okay, here we go, y'all. Okay, I'm gonna move this over here so I can scroll through. And let me embiggen this as much as I can. Let me get this as big and wide as I can for y'all. That's about as big as I can do, guys. I apologize. Let's see if I can reshape this. And then I can't do that, so let me do this. Let's see if I can get it to embiggen. Nope. Whoop, didn't mean to do that on that page. Whew, not what I meant. Come on, work. Do what I ask. Nope, won't let me do it. Okay, sorry guys. All right, here we go. Look at that precious little girl. Aww. This is one of the pictures that they are showing. There we go. That's better. Yeah, the judge gave her a slap on the wrist, but that, oh, Eva, oh man, there she is with her dad. I think these are Florida Beach. I don't know where all this is, but he's definitely buff. They definitely love the beach. Oh, kitty, kitty. Oh, that's a sweet picture. That really is a sweet picture. Oh, my dad used to sing that to my mom. He definitely was in love with her. Oh. Wedding. I know, isn't it? I guess it's when they got married. I don't know who all these people are. Military. Okay, we're back at the beginning. So this is his Facebook. Let's go on it and see. This was last posted on March, my birthday, March 26, 2020. Well, I guess we can't say anything because we can't be friends, but yeah, definitely. He had a 9-pack, let me tell you. He really did. Share. Okay. So, yes, I'm an Aries. I agree, Ronnie. I think the jurors should be sequestered. I really do. I think at least for lunch. And, you can say you can go home if it's close enough. Otherwise, you need to stay here. Okay. So I really want to replay that section. She was snippy as hell. She knew she was in trouble when she walked in. But he basically admonished her and made it clear that she may not be able to be recalled, but she's still under the sequestration of she can't talk to anybody, she can't all of that stuff. So yeah. Gorgeous sand, I know. Gave her a slap on the wrist, but she was terrified, man. Do you know what? I think what we'll do is I'm going to play that part again. I want you to see what she said is what got me. She knew the crap was hitting the fan with her. She had this plan. This comment was pre-thought.
The deputies in the courtroom that saw the conversation late yesterday afternoon. Do you know which deputy it was?
As I said, it was reported to me that some unidentified person told the deputy.
What, Miss Kevin?
Are you the one that they told? Yeah. Okay, right here. Mr. Taylor. Apparently it was reported to Deputy Racky. Of course, State, you want to be present?
That's 2-year-old text. This is the best part. You didn't miss anything much. Just hours of text. Listen to her first response. Look at that face. You can tell she's a tanner. I'll let this play. I'll be right back.
Ms. Benefield, I'll remind you that you are under oath. You can just get a little bit closer to that microphone and just answer the questions in a loud, clear voice.
Good morning.
You appeared yesterday and testified before Judge White in this case, did you not?
I appeared on Tuesday and testified.
Tuesday. Time flies. At the end of your testimony, do you recall Judge White instructing you about having contact with anyone because you were to remain under subpoena? Do you recall that?
I recall.
Okay. And you are here today because the state requested that you remain as a potential rebuttal witness.
Correct.
Now, what did you think Judge White's directions to you meant?
Well, I was told I wasn't allowed to speak on any of the witnesses in my testimony while in the courtroom.
So, I'm sorry, did you finish?
I'm finished.
Did you realize that when you decided to have a conversation with the reporter?
Yes, sir.
All right. Tell us, if you would. I'm just trying to get an explanation. Tell us, if you would, what you were thinking that.
Objection.
Overruled.
That's for what she said.
What you were thinking that
Hello, everybody. I don't know what's going on, but I'm gonna fill in for a second. How's everybody doing? Uh, yeah. I think she's a young girl who lost her mother and her father. Um, so there needs to be an understanding, just like how we have for our victims, an understanding and some grace. Hi, Haley Mouse. Hello, everybody. Hi, Zach. Say hi, Luke. What are you gonna say? What are you gonna say? You gonna say something? Stop following me. Oh man. Yeah. Well, I'm not sure if she's having internet issues or what's going on, so I just thought I would step in and hold down the fort for a little bit. I'm gonna pull cord up here. Okay. I mean, they're still at lunch. What am I gonna do? Here comes Ada.
I don't know what the hell happened.
Well, I thought I better get on there and hold down the fort while you're having trouble.
It just went down. Yeah. Just boom, the whole area. The whole area just went down.
Yep. That's crazy.
I am so sorry.
You're fine.
Hi, Swan. Okay. Do you know what I was talking about when we disappeared?
I don't. We were just talking about the daughter and how she lost both her parents within a short span of time and just kind of talking that over.
Well, what I was talking about was the attitude and the way that Miss Little Thing answered the juror and I mean the questions and everything when she got on the stand. I'm getting everything up again. I'm sorry.
No, you're
But
good.
do you know when the daughter came in and testified and her verbod, she knew she was in trouble.
Right.
I mean, what's your thoughts on that? That was kind of the way she answered to me was a little bit.
Yes, but she's young. Let's put it that way. And I feel like a lot of that generation, they don't have a ton of respect for the court system. Not to say that that's a blanket statement for all of them, but definitely it seems to be a theme and kind of like Colin Albert. I felt the same way about him, that he had zero respect for the process. So I don't know. It's just my personal opinion.
Well, I think everybody's been showing the videos. Do we show them or wait for tonight?
I mean, you can show them if you want to. I was just thinking we can hang on to them till Jules is here, but I don't know. Jules,
I think we will. I think we'll do that. We'll hold on. Yes, dear. I'm going to mute for a second.
Sure, no problem. Yeah, exactly, Amanda. They don't have respect for anyone, pretty much. They're just, they're doing their thing. And, my parents always told me that every generation thinks that it's smarter than the generation before it, and that we can learn nothing from each other. But that's just not the case. I think my best lessons have come from people who are older than me and who have lived more life than I have. And not in like a respect your elders type of way, but more in just they have a well-rounded perception of the world and what's happening around them. And they're able to take that and turn it in to I don't like waiting, Karen. They're able to turn that into teachable life lessons that are applicable in lots of situations. There are some things that I remember my grandpa saying to me that I still remember to this day when I was like little. I'm like, oh yeah, these are truths. What do you think?
Yeah, exactly. And, I think every generation it changes. And I think that, but what bothers me is the lack of respect across the board.
Yes, and that's what I'm saying.
And
They don't even have respect for like their people in their lives, their parents, their grandparents, and aunts and uncles and teachers, and it's just really bad.
it is. It's really, really bad.
Yeah.
Um,
Amanda, I'm so glad. I am so glad I have an 18-year-old and mine knows better. Yeah. I mean, one of the big things we like to say in our house is that we teach our kids the same way we were taught, only better. And so I'm like, I was taught to respect the court system and respect those who were older than me, but you know, I grew up in a different culture entirely where the life expectancy was a lot younger. So to be like in Zambia, this might scare y'all. In Zambia, age 45 is considered a senior citizen. So if you're 45 and above, you're in the elderly of the population.
So I'm ancient.
Yeah. Well, and like when my grandparents came to visit us in Zambia back in 2003, they had like their gray hair and everything. And they were just like highly regarded and super highly respected. Uh-oh. I think she froze. Ada? I'm going to take it down for a minute. Man, must be having problems with the internet. Yeah, exactly. Yes. Yeah. Taught pre-K for 11 years and it was horrible. The disrespect from the kids, but from the parents as well. Oh no, that's terrible. I love my daughter's pre-K teachers. I would kiss them on the mouth if that was appropriate, but it's not. So I don't. But they are amazing. They're miracle workers. Oh, kisses for the baby. Do you want some kisses? What do you think? Do you like kisses? Oh. He's tired. He's ready for a nap. We went running errands this morning, so he's like, oh, I'm going to be a floppy. Well, my husband calls this a 60s protest baby. They just flop. They don't just flop on the floor and don't do nothing. No shape to them. Melanie is on a break, so maybe Jules will call now. Well, hopefully Ada's stuff is working. Yeah, we all are mama bears when we need to be. That's the most important thing. And I think that's the thing that bothers me the most about this case is that it's like her mother bear instincts either misled her or they were extremely heightened. Okay. And I don't know if that's from trauma, from being a young parent, a young mother, a first time mom married to an older man who is more experienced and I don't know, already had kids, helped his previous wife raise her 2 boys from a previous marriage, and then they got pregnant years later and had this other daughter, Eva, and I don't know. I just feel like her mother bear instincts over that child, whether she like I guess she believed it. She believed the fact that he was hurting the baby. But I mean, to me, it's like we looked at the pictures last night, and if you guys were there, we looked at the website last night. That's just normal toddler stuff. Like my toddlers, they cover me in bruises and themselves in bruises. So I don't know. You have to go soon, Karen. Oh no. So I don't know. I can't. I have a hard time trusting your judgment. I'm not sure why. All right, let's see if I'm going to pull up the trial really quick. You still having trouble, Ada? Can you hear us, Ada?
Glorious, horrible background I have.
Oh no.
My gosh, you get to see the whole mess
Well, I've got the trial pulled up
Yeah,
so we
I'm
can
still
have
having
that up.
problems. Can you hear me?
Yep, I can hear you. Let go, please, sir. Yeah. Whoa. Here. We'll just distract everyone.
I have the court feed up right now on my computer. I'm logging back into the main. There we go. We're back.
I'm going to leave mine up in the background. We don't have to put it up. Just in case you go down, I'm able to pull it up really quick.
I'm sorry, guys. I don't know what's happening. It's driving me crazy.
Mr. Buddy. He's the star of the show, truly.
It really is pissing me off.
Yeah. Oh, you're muted on that one. I have no sound.
Okay, there we go. It's the internet in general in the town. It's the whole building. It's not my computer.
I was gonna say, is it from the bad weather y'all had? Maybe
they may be doing some repairs. We had some really bad weather the other day.
Yeah, lots of people having issues, and a lot of people are still struggling from that CrowdStrike stuff. Trying to come back from that.
Yeah.
Mr. Buddy, you are a wiggly worm. What am I going to do with you?
I don't know. What are you going to do with him?
I don't know. He's crazy. Look at him.
Oh. Cancel. Oh my gosh. Many people are having a hard time today. Okay. Okay. I want to talk about those little bruises on the neck that Sinbad brought up. The beads that child is wearing, believe it or not, I've had those kind of stuff on my kids. Do you know the color Mardi Gras beads? A lot of those beads, when the kids are playing outside, they get sweaty. It leaves a little dye on their neck, a lot of them. And that could have been because if you look at the colors, the same colors in the beads are the same colors in a bruise. I'm not saying it's not a bruise. I'm just saying the little bruise on the back, that could have happened on a playground. We don't have any context to exactly what those bruises were connected with. They're just pictures of bruises. And I'm sure you have 3 children and your kids have bruises. If I came and just took pictures of your kids' bruises and post them on a website, what do you think people are going to assume?
Right, and that'd be even at a worse disadvantage because my daughter has cerebral palsy and she falls all the time because she can't, her legs give out and she gets bruises all the time from that. But the biggest thing for me is that where they took the photo of her neck and yeah, I feel like they are. And the ones on her neck look to me like they were caused by the necklace. And the necklace that she was wearing is an amber teething necklace that a lot of parent advocates that I follow because I am in that space right now. I have little kids, so I'm keeping up what's dangerous, what are the things that parents are trying to get taken off the market. And Etsy stopped selling amber teether necklaces and allowing people to sell them because of the strangulation hazard. So I have a hard time feeling like that those necklaces are safe and you're letting your child wear those necklaces and then you're showing bruises and you're being like, look, he did this. I'm like, okay, well, I know for a fact, and I'm not even an expert in child safety. I just know from what I've read online, what the FDA has put out and what Etsy's policies are, that you can't buy amber teething necklaces anymore. Yeah, and if they have low iron, they will bruise easily. And if they have low iron, they'll also eat non-food things. Like my kids.
Well, and the thing is that I'm not saying he didn't harm those children, but at the same time, there's nothing to show he did.
Yeah.
He doesn't admit to harming children. He admits to getting mad, and I've seen it happen with children. Children will do this. They're mad. The dog is next to them. The dog is barking because they're mad, and they kick the dog.
Yeah.
Not right by any means.
Yeah.
We teach our children not to do that.
Yeah.
Grown-ass man shouldn't be doing that, okay? I don't disagree with that.
Right.
Did he have a problem, anger issues? He said he got help for it. At least he acknowledged he was getting help for it. A lot of guys won't even do that. A lot of women won't even do that.
And he
But
even
the
is saying
pictures
that to
with
her.
the child,
Yeah.
the bruising in the mouth, my children have fallen and hit in their mouth on the tile floor
Oh, yeah.
and had bruising like that because their
Mhm.
teeth hit the inside of their lip.
Oh, I
Other
think
parents' children have done that. So for me, oh, your injunction today. Oh, cool, Zach. So for me, it's like alarming if he did it, but where is the confession? Where's the proof that he did it? You can flip that coin and say, this is typical child. What?
Oh my gosh, Sinbad. My oldest fell on a step up one time when she was 3 and it knocked her teeth up into her gums and she had to have lots of dental work growing up. Oh, and it looks like it looked just like Emerson's mouth minus the teeth. Exactly. Okay, and my kids, like, we wear the footy pajamas, put the footy pajamas on the kids, and then their feet are slippery and they go running through the kitchen and they go flap fall backwards.
And here's the thing, a good manipulator, if that's what she was, could have easily pushed him.
Yeah.
And guys, women and men do this to each other all the time. When you know you want out of a relationship and you see, all right, let's look at Amber Heard. Yeah. She manipulated Johnny into fits of anger and then recorded them.
Yeah. And recorded situations in their home and took them out of context.
Mm-hmm.
Like him banging cabinets and stuff like that. Hey.
I thought those were cordless.
I'm charging them. They're
I
dead.
figured that, but I was just being facetious.
I need ones. I told my husband, I'm like, I need some new headphones that are better charged. I've had these for a long time.
He very may well have. I'm playing devil's advocate on both sides of this coin.
I agree. And he admits that he had anger problems. So, I mean.
But there's a difference between somebody who admits it and is getting help for it than somebody who doesn't admit it and stays in it.
Yeah. And I mean, how do the texts come in? Can the texts come in at all? If he's not going to take the stand, she's going to take the stand?
Well, the texts have come in, and with the text, you don't see any evidence.
Yeah.
Any.
And it's not like, okay, you guys, we all read the text last night. I don't see her saying, you hit me, you hurt me, you hurt the baby. She's like, so you kicked the dog, so you threw the cat. I mean, okay. Of course, never okay to harm an animal, but if you're going to call those things out in a text, why would you not be calling out if he hurt you? You know?
Well, you're true about that, but we do have evidence with 2 therapists that they were getting help individually and collectively. But once again, we do not have his side of things. We won't. And, once again, this is, if he truly did harm those animals, then why didn't she call animal control? She could be making it worse than it was. He could be making it less than it was. But other situations that concern me more is what happened to cause her to feel that she had to defend her life. Yeah. And why is she not talking about that? Why has she not given a deposition to that? Why has she not shared with anyone what specifically happened that night?
I think she's following the advice of her attorney, but I also think, and lawyer, said this, and he's a Florida attorney, and he says, I just don't think you get to self-defense unless she takes the stand.
That's the way I feel.
Yeah.
You can't get to self-defense unless you take the stand. And it does seem like a toxic relationship. But
I think it was toxic all the way around.
I do too, but I think he wanted a young thing. She wanted an older man. She had ulterior motives. Yeah. I just think he wanted to love somebody, and he was still I don't think they were right for each other, but
I mean,
it
he was
doesn't get
still
to it doesn't get to being it doesn't get to the point to where you're 6 feet under.
right, and he was still mourning the sudden passing of his wife. His wife passed very fast and very unexpectedly. He was out of town, and Eva was the one who found her when she came home from school. And it
How did
turned
she
out
pass? Heart?
a heart condition that was undiagnosed. Yep.
Yep.
Hey, what's
Well,
going
guys, I'm going to tell you, I appreciate y'all's love and concern. I stayed on live against advice of certain people, and I understand that, but I am starting to really feel better. I did get sick, and now I'm starting to feel more normal. I think it was my medicine that upset my stomach. So I apologize, but I just wanted to keep this going for you guys. Oh, yeah, you talking, baby? Are you talking, little one?
He's like, I'm ready to lay down. What are we doing?
I thank you for hopping on because apparently in my community, I'm hearing from several people in my community that there is some connection issue that's beyond my control. So we are waiting for the court. They should be back any second.
Yep, any minute now.
Yeah. Ooh, I love those little noises, even the fussy ones. You're welcome. You're welcome. I know I looked like hammered crap this morning. Yes, I know you can tell in my eyes. I still am not 100%, but I think after relieving my stomach, that was what I needed. So I'm doing better.
I will leave my court feed up, and
Okay.
I'm just gonna go in the background. But if you, for some reason, something happens again, I'll just pop in here real quick and throw a cord up.
You know what? That's great about StreamYard is that even if my internet goes down, y'all are still up.
We are. We're still live, and we're still here. I was like, I think I'm just gonna hold down the fort for a little bit while we're
Thank you.
figuring this
That's
out.
why you're my mod boss. Court is coming back, guys.
Yes.
Okay. I'll remove you, or you're gonna remove you.
I'll remove me.
Okay. Thank you. All right, guys, let me share my screen. We'll get mine up and going, and that way we'll have a backup. What I'm going to do, you guys, is I am going to once court gets going, I'm going to put myself on a blackout. I'm going to take a few minutes, try and get something in my stomach, and just, I'll be monitoring, but I am going to take a little break once court resumes. Okay, guys? I appreciate your kindness and understanding. I really do. It's been a morning, but court is now coming back. There we go. Let's see what the sound is. Good. Sound's back on. Yes, you are so kind, Haley Mouse. She's got a great laugh, doesn't she? Oh, thank you for understanding. Yeah, I'll take some time. I'll just leave the court feed up so y'all can watch. And I'll just be listening in my ears, getting myself in a better place. But I appreciate y'all hanging in there with me. While we're doing that, I do need to. Can I do this and still? Oh, I will. I'm going to go sit in my chair, watch it on my thing. I'll be texting in. I'll probably take about 30 minutes, and then I'll be texting in if I need to comment or do anything. But I am going to wait for Ada. I'm not going to wait. I'm going to go ahead and do that. Y'all are awesome, and I'll be monitoring. I'll be back.
All right, good afternoon, everyone. We're back on the record in State versus Ashley Benefield. We finished the lunch break, and before we bring Deputy Keyless or Detective Keyless back in, we had left off a bench conference with the defendant seeking to admit and then question Detective Keyless on Defendant's Exhibit 3, which I will describe as, and it's been told to me that these are from Ashley Benefield's phone. And the printout is from Cellbrite, which the detective testified is one of the software packages that they use to extract and organize data and then put it in a readable format. I will note that in looking closer at Defendant's Exhibit 3, the report, the Cellbrite report, has a start time of August 29th, 2016, and a last activity of April 19th, 2017, and lists 319 attachments. However, Defendant's Exhibit 3 only encompasses August 29th, 2016 through December 3rd, 2016. And the page numbers are not sequential. That is, it's page numbers 1, 786, 222. I'm sorry, 222. 2,222, 2,224, 2,233, 2,237, 2,240, 2,263, 2,264, and 2,266, although I'm assuming that's just because that's the relevant portions that the defense wants to get into. Certainly, State, I'm sure you have these as well, and may.
Well, I guess one of the issues, Judge, is that we aren't being shown anything from the defense until Mr. Taylor's at the podium, and we have to ask. So I don't know what they're using because they've never filed a discovery in this case. The only thing they filed is a defense exhibit list, which had the 391 things on it. I have something called WhatsApp AB texts, but they're not all the same. There's some of the same. And so I don't know what's in that exhibit because we've never seen it more than a few seconds before we had to give it over to Your Honor. And I think we're kind of being sandbagged here because this continues to happen. What happened yesterday with Ms. Murphy, those were items never turned over. May I approach? You don't mind. Thank you.
You've raised a much more fundamental issue. There was no defendant's exhibit, witness list and exhibit list pursuant to the rule?
No, there's a defendant's witness list that was filed on June 21st. There's then something called a defendant exhibit list, which does not cite any rule. It's not listed as a discovery. It was also filed on June 21st. So there's no there's never been a formal discovery filed in the case. And we didn't receive any of the names of the witnesses or the 391 items we got about a month before trial. And in those items are things that aren't clear of how to even deal with them. And I know that's hard to describe, but there's emails. There's a million IAs that would never be admissible. There's a lot of things.
A million
IA report, internal affairs report from the sheriff's office, things like this. So I did my best to go through it, but because we're not being shown it until he's standing at the podium with it already marked, I don't know what any of this is. And it feels a little bit like trial by ambush, which certainly under the rules, much of this should have come to us way earlier than it did. But if Your Honor checks the court file, which I have thoroughly, there's never been a formal discovery filed by the defense. And the original witness lists were filed in the late June.
that probably would have liked to have addressed that well before trial. Could have also filed a motion to compel after the the defense has 15 days. So, all right, please.
They attended a deposition of Sergeant Keyless where we had the specific text messages that the court has seen. They were clearly aware of them. We responded, what we received in our discovery, among other things, was what we refer to as a phone dump, D-U-M-P. Thousands of documents. We have to go through that, searching for what we believe is anything relevant that may impact the trial of the case. Our response was to send that phone dump back and put the state on notice that anything in what they provided to us was fair game, that they should do the same, search it. We treated them no differently, Judge White, than they treated us. It's not realistic, and I understand why we received the phone dump like that. It's not realistic to require them to go through such a massive amount of data and single out specifically what they intend to use, because I know the court well knows this is a fluid process, and as the trial date approaches and it's finally carved in stone and it actually begins to happen, then the attention begins to turn to the nuances of all of the subtleties that comprise a trial of the case. We did the same. We did not know specifically what we needed, but at the deposition, I clearly presented these to Sergeant Keyless, and he acknowledged that they were part of what came out of this extraction through the Bright Line program.
All right, final thoughts. I'm considering this somewhat of a Richardson hearing. Go ahead.
Judge, I think Your Honor is well familiar with the rules of discovery, but the defense obligation is different than the state's obligation. The state's obligation is to turn over everything in the possession of the state. The defense obligation, as it says directly from the rule, is any tangible papers or objects that the defendant intends to use.
Can you slow down a little, please?
I keep forgetting. Any tangible papers or objects that the defendant intends to use in the hearing or trial. It is disingenuous for this defense team to say they are using 391 items, many of which are inadmissible at trial. So, and obviously they didn't follow the dates. We're trying to move this trial. We do not want this case to be continued. We're continuing on the best we can. But now we've come to this point where there are things being offered for evidence that have never been provided to the state, that I can't even find at the same copy in what they provided. They never provided this, anything that looks like this. So that's the problem we're having. And the obligations are different, as Your Honor knows. And I think that they have not, in this situation, that's part of the problem the state's having, that we feel like we're a little behind the eight ball because their obligations are not the same.
All right, thank you both. So certainly the obligations under the Florida Rules of Criminal Procedure are different for the state and the defense. The state is required to list all information or witnesses that are relevant or material being calculated to lead to the discovery of admissible evidence. They've got to categorize witnesses A, B, and C, provide defendant statements and substantive statements. The defense requirements are different. The defense requirements would be turning over or identifying those witnesses that are expected to be called at any hearing or trial, and disclosing any documents that are expected to be used at any hearing or trial or introduced at any hearing or trial. It sounds to me like the defense got the phone dump and provided it to the state. Certainly, I think the defense is required to notify the state what portions of that evidence that they intend to use at any trial or hearing. But I'm not going to find that there was a willful violation of the discovery rules because it sounds like the defense provided. I haven't heard specifically. It may not be in the format that we're looking at, but according to the defense, they provided the dump from Cellbrite.
Well, and also, Judge, here's a copy of Sergeant Keyless's deposition of May 31st of last year, and these exhibits, proposed exhibits, are attached in his deposition.
All right.
Judge, can I just clarify real quick? The defense did not provide us a phone number. We provided it to them. They listed it and said it's in our possession.
So they did not provide us.
Okay, so she already had it.
And they never specifically stated this document from the phone dump will be used in trial.
All right. I do think the defense, you have that obligation though, under the rules to identify witnesses and tangible objects, documents, things that you intend to use. It's very specific in that regard. So I'm not going to find a willful violation because this has been in the state's possession. But defense, you need to let the state know what you intend to use at trial or hearing. And that's also includes your list of witnesses, which I understand has already been done. I don't think I have enough information in front of me to determine whether it's trivial or substantial or willful or inadvertent. Well, the willful or inadvertent, I think I can find because the state had all of this. I'm just going to require defense from here on out. You need to identify the exhibits that you intend to use at trial or hearing. All right, so
if we could just request that be done before we're in the middle of examining.
and copies need to be shown to the state prior to showing them to a witness.
Of course.
All right, so let's get going on what we were talking about. That being Defense Exhibit 3. And we had an objection. So go ahead as the proponent. The objection's already on the record. Go ahead as the proponent.
Yes, court wants to take up now the admissibility as it relates to specific instances.
Of Exhibit 3.
Yes. Okay, so we think the predicate has been established by virtue of the 9/11 call and the testimony that was offered by Mr. Sand, especially including the spontaneous, excited utterances of Miss Benefield that could be heard in the background, that my husband attacked me and I shot him. Now, as the court well knows, I provided Your Honor on May 16th, 2024 with a memorandum use of discovery depositions as substantive evidence in criminal trial. I also had previously filed on July 10th, 2024, a defense request for clarification of court's amended omnibus order. And without beating it to death a second time, I cited the court to Smith versus State, where the defendant was awarded a new trial because the court's refusal to allow various witnesses other than the defendant to testify about specific acts of violence allegedly committed by the victim. The Florida Supreme Court held that specific act testimony of third parties may be admissible as corroborative evidence if it is first shown that the defendant knew about the very same act of violence. So I know that the court is familiar with that, but in addition, I have for the court the following opinion. The Smith case is a pretty good evaluation of this issue, Judge. It's a first district case, September 4th of 1992 at 606 Southern 2nd, 641. It said as follows. Consequently, if there is the slightest evidence of an overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. So I think clearly Mr. Sand and the 9/11 call qualifies, and I'll tell the court specifically why. In the matter, Your Honor, of Henry versus State, which is a second district court of appeal decision found at 290 Southern 2nd, page 73. goes back to February 1974, Your Honor. What was particularly interesting about this case is the second DCA reversed and remanded for a new trial because the trial court refused to allow the defendant to introduce specific acts of violence. And this is what the court said. The necessary predicate for the admissibility of either the dangerous character or individual violent acts of the victim is some evidence of an act on his part which would reasonably suggest the need for self-defense. They cite several cases and then they say the following in that same footnote. That prerequisite was satisfied here by evidence that Barrow, the victim, thrust his hand into his pocket, whether for a car key or, as Henry, the defendant, said he thought for a pistol immediately before the defendant shot him. I have to say, Judge White, respectfully, if thrusting one's hand into the pocket is enough to satisfy sufficient evidence so that it's resolved in favor of the defendant when it relates to specific act evidence, a 9/11 call capturing an hysterical Ashley Benefield saying and the witness repeating, "My husband attacked me and I shot him," clearly beats the pants off of thrusting a hand into a pocket. So I think we've established the predicate, respectfully, Your Honor.
Do you have a copy of that case?
Absolutely.
Could I hear the citation again?
And I might remind the court, in addition to that, Miss Benefield had the scratches on her side and the swollen eye. Here is the Henry case, Judge. May I?
Yeah.
Do you mind?
290 Southern 2nd, 73.
Thank you. And I have one as well. I don't know if they want to keep it up now. I'm waiting.
Okay, guys, I'm a little lost. I apologize. I've been a little occupied. What's happening? What are they fussing about now? That's a good point, Miss Swan.
Yes.
All right, I've reviewed Henry.
You want me to comment on Britain?
What are they fighting over now?
I haven't read it yet. You can if you want, but I'll probably let them go first. All right, go ahead, Steve.
Judge, to be honest, we are still going through what they're trying to introduce because this.
Oh, this is that information they got.
Exhibit that they were talking about. So we don't have, I can't even speak to exactly what's in that. So I apologize if I get it wrong, what they're trying to introduce. First, Judge, there has to be an overact, yes, regardless of how that's proven. I believe once that is proven, Other acts of violence can come in to show that the defendant's apprehension was valid at the time she had to use self-defense. The only way we know that any of these things added to her apprehension is if she says it did. And the case that I just handed up, the Britton case, is an example of that, where there were prior acts of violence, but because they were so attenuated, they were, I believe, 4 years before, and I will read, it's a highlighted portion on page 2 of the case. With respect to the excluded evidence, however, the trial judge found that the unfair prejudicial effect of the evidence substantially outweighed its probative value, considering the prior incidences, remoteness in time, the lack of connection of intent and the crime charge, and the speculative nature of any real connection whatsoever as far as any apprehension in Britton's mind. I do believe that even if the 911 call substantiates some sort of an overt act, which I still believe the defense has to put that in, but even if it does make an overt act, that these items that the defense is trying to introduce are still not admissible because we have not been informed by the defendant or otherwise that any of these things that the defense is trying to get into went into her apprehension and caused her fear and caused her to react the way she did. Additionally, at least from what I could tell from what I think is in the exhibit, I don't believe there are any acts of violence even spoken about in the exhibit. There's language, there's defendant saying to think of you with anybody else makes me crazy. I don't know that those are acts of violence. All of these cases talk about acts or threats of violence. And I don't find that there are any threats in any of this, or there are certainly no acts that are described in this that have happened. So I would say it doesn't meet that requirement anyway as a prior act of violence. And even if it did, I think we have to have some evidence that this, being so many years ago, played into the defendant's decision to use deadly force. So we would object at this point.
Sir?
We expect to call and testify a domestic violence expert. That domestic violence expert is going to educate the jury, that he should educate all of us about how domestic abuse is cumulative. It builds and it creates this overwhelming anxiety. As the court knows, this entire case revolves around a 4-year relationship. This is the beginning of the insight that Ms. Benefield gains that ultimately and very shortly thereafter leads to her leaving Doug Benefield. And the court may recall, because I shared a letter with the court, that Ms. Benefield left Mr. Benefield when she left him, describing and explaining how she feared for her safety and that of her child being with him, that he was controlling, that he did the following acts, from shooting the gun to punching the dog. The domestic violence expert is going to say all of these things remain in an abused person's mind, so that on the day of the incident, September 27, 2020, despite the fact that it was at the end of the 4-year relationship, that is why the reaction of Ms. Benefield was appropriate or was not unreasonable given all of this prior history. And that's also why the case law that I provided, Your Honor, says domestic violence expert testimony should be admissible for exactly that reason. So here's what's happening, Judge White. The state just introduced 363 text messages and played a video. Why did they do that? They did that to show, because it's the central theme of their case, look how well they got along in the week prior to the shooting, smiley faces, they're having lunch at the restaurant, everybody looks happy. The domestic violence expert's going to confirm what Dr. Broder told us and what Dr. Quintal told us, is that in the face of an abusive relationship, getting along and going along is always the best course of action that these women embrace, especially when a child is involved, because it is the safest manner to keep the beast at bay. I believe those were Dr. Broder's exact words, keep the beast at bay. So here is the beginning, where she looks at these messages and she doesn't quite realize the significance of them. But shortly thereafter, once he starts firing the gun into the ceiling and putting it against his head, punching holes in the drywall, punching the dog unconscious, now it's beginning to dawn on her, oh, the guy that I married is not the guy that I thought he was. And now you begin to enter that mentality of abuse, and you begin to develop a survival instinct for it. So that's why you employ the get along, go along. You do not want to do anything to antagonize the abuser for fear of reprisal. And Dr. Quintal told us exactly that Ms. Benefield's concern, and the court may recall it was the state that asked this question. Dr. Quintal was actually Benefield concerned about the release of the Broder report. Remember, Judge, I served it up on the head of a pin. The theory of the state is that Ashley Benefield killed her husband because the Broder report was going to be released 3 days later. Question, Dr. Quintal, by the state. Was Ms. Benefield concerned about the release of Broder's report? Yes. Why was she concerned? She feared a reprisal from Douglas Benefield when and if he learned what she had to say about it. So this is consistent with that syndrome. I think it should be admissible. I think we've established that in the record, she says she was attacked and she shot him, and she doesn't just say it. The court's ruled it was a spontaneous statement. She's hysterical. Even the cops described her as hysterical. In fact, one said he thought she may have been in shock.
All right, thank you both very much. Let me clarify. I'm pretty sure the ruling that I made regarding the 911 specifically revolved around Mr. Sant's statements. I found that they weren't excited utterances. I found that they were, some people call them present sense impressions. Some people call them spontaneous statements. And therein lay the order. I had specifically, I recall saying that I had not heard about or argument as to the defendant's statements in the background. I remember I said if those were going to be introduced as excited utterances, they would have to be through the witness when he was on the stand. Here nor there was no objection. You could hear certain statements being made in the background of the 911 call. I think both sides are really talking about a macro issue, whereas this issue is much more refined than that. In order to, because I looked as well over lunch to try and find an answer to this particular question, because I think the argument being made by the defense to allow specific incidences of violence or aggression by the victim is new and novel. I think it's fairly unique in arguing that.
Thank you for calling Angels.
That occurred during the state's case in chief. And I'll start my analysis because I think this is a unique issue. I don't know if it's a issue of first impression here in the state of Florida, but I can say I didn't find a case on it, and neither side has presented a case to answer this question. And so I start my thought process by saying that self-defense is an affirmative defense. So generally speaking, the state must prove its allegations beyond a reasonable doubt. If the defense then wants to assert an affirmative defense, the burden shifts to the defendant to prove, using competent and substantial evidence, that is admissible evidence, by a preponderance of that competent substantial evidence, that she acted in self-defense or acted under duress or necessity or whatever affirmative defense is being asserted. Then the burden shifts back to the state to disprove self-defense beyond a reasonable doubt. And as has been noted by both sides and the court as well throughout, that the case law, and I also start with Smith, which I quoted in a prior order. And this is, again, Smith, 606 Southern 2nd, 641. And this is at 643. Before a defendant may offer either type of character evidence, which is specific act, of course, we know that the defendant has to have knowledge of that, or the reputation, which the defendant doesn't have to have knowledge of. And again, I'm reading from Smith at 643. Before a defendant may offer either type of character evidence, he or she must lay a proper predicate demonstrating some overt act by the victim at or about the time of the incident, which reasonably indicated to the defendant a need for action in self-defense. And then we get into if the defendant lays that predicate and there's the slightest evidence of an overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. There's also Warren that we have been discussing, 577 Southern 2nd, 682. And in that situation, the evidence was kept out and the trial court was reversed on that. There, the defendant sought to introduce evidence that Taylor, the victim, was a cocaine user whose habit had grown progressively over time. The defendant proffered, so the defendant testified that when the victim was unable to obtain cocaine, he became violent and argumentative, picked fights. The defendant also testified in that proffer that the victim appeared to be in the throes of cocaine withdrawal and that he was afraid of her. And the proffered testimony was excluded. And I use that as an example, again, to show my line of thinking that, yes, the homicide defendant can get into these things, but there must be that burden shifting and the defendant presenting evidence affirmatively, competent substantial evidence to prove by preponderance that she was lawfully justified in using force likely to cause death or great bodily harm, or not likely to do so. Finally, there was one other case in Hedges, which is another case I think we've talked about, is 667 Southern 2nd, 420. And this is at 422 and 423. It's first DCA 1996. And it talks about exceptions to character evidence not being admissible, where evidence of the victim's reputation for violence or specific acts of violence are admissible when the defendant knew of the victim's violent acts or of his violent reputation at the time of the alleged offense. This case is from 96. I think there's other case law now that establishes the defendant doesn't have to know about the reputation for violence, but here nor there. That evidence of prior specific acts of violence by the victim is admissible if it is relevant, because it is relevant to reveal the reasonableness of the defendant's apprehension at the time of the incident. However, even Hedges says, before the defendant may offer this type of character evidence, a proper predicate must be laid by evidence of some overt act on the victim's part at or about the time that reasonably indicated a need. So the reason I wanted time over lunch to try and find some cases, if there was any cases that had said that predicate can be laid during the state's case in chief, and I was not able to find it. And I looked at Henry, I was reading Henry that the defense produced, to see if it explained factually how the information came in regarding the hand in the pocket, and it doesn't say. It just says that the trial judge excluded evidence and unfortunately it doesn't give any indication about whether that was during the state's case in chief or the defendant's case in chief.
May I make an inquiry of Your Honor?
I'm sorry?
May I make an inquiry of Your Honor relative to what the
I guess you can ask, but I'm in the middle of a ruling.
Well, I think it may be relevant, helpful.
Okay.
The court's ruling. I think what the court is saying is it's looking for some guidance as to the procedural aspect of whether or not this evidence can be introduced during the state's case as opposed to the defense case.
Correct.
Okay. So.
Right, and that's what I'm making my findings about.
Yeah, and the only thing I would say to the court, directing myself exactly to that, is I don't think any of us, would dispute that self-defense is a recognized justification. I don't think any of us would dispute the 9/11 call, he attacked me and I shot him. The only thing I would say to the court is, to the extent Miss Benefield is presumed innocent, wouldn't the court rather want a case that says it cannot be introduced during the state's case in chief, rather than assuming it can? I think the defense is entitled to the benefit of the doubt. And in the absence of case law that says the defense may not introduce this during the state's case, I think we should be entitled to it.
All right, thank you. So I did think it was an interesting issue. So I did the research. And this may be the case that ultimately, if it gets to the second DCA or the Florida Supreme Court, where we get the answer saying that unobjected to statements or excited utterances by the defendant on a 911 call played during the state's case in chief would be sufficient predicate for that overt act to raise self-defense and allow prior acts into evidence during the defense cross of the state's witnesses during the case in chief. I'm not prepared to make that ruling today. So I'm not saying that the WhatsApp messages are not admissible. I'm just saying that I don't think they're admissible at this point. So that's my ruling.
Just, Judge, for the future, if in fact these WhatsApp messages do come in another way, we would also be asking for the rule of completeness, the rest of what was taken out.
Well, that's why I mentioned earlier, because you certainly, there may be other ones that you want to introduce.
Right. So I just to put defense on notice that may be an issue.
So we're going to bring the witness back in, and you can resume your cross.
Run the jury in and out for naught. I've shown Suzanne the remaining aspect of my cross, anticipating there may be some objection to it.
And I would have an objection.
You do?
Yes.
Okay, can you step back out?
Sure.
Same rules.
Judge,
Yes, ma'am. The witness is out.
I'm trying to interpret this as fast as I can, but this, and maybe the defense can confirm, I believe these are supposed Google searches or internet searches for certain subjects
Yes,
that are on
yes,
Ms.
that are on
Benefield's
the phone,
and
that of which was extracted by this witness.
there are things like, ask Amanda, how do I co-parent with an abuser? Co-parenting versus parallel parenting with an abusive ex, the Good Men Project.
Did you give the judge the date of those?
The first one was, I'm sorry.
2020, Your Honor.
The first one was 5/11 of 2020. That was the ask Amanda, how do I co-parent with an abusive, or the parent with an abuser. The next one was the same date, and that was co-parenting versus parallel parenting with an abusive ex, the Good Men Project. Same day, 6 tips to help you co-parent with an abusive ex. And then there appears to be what I would assume is one of the Bible verses that was sent
Yes.
by Judge Benefield, which says, for the wages of sin is death, but the gift of God is eternal life in Jesus Christ our Lord. Romans 6:23.
Yeah, that one was shown by the state. They just moved past it a little quickly.
So Judge, I have several objections to this. First, what is the relevance of her searching for these things? Second, she cannot just put on information that she was looking for abuser information without taking the stand and saying that she thought he was an abuser. And also, by her entering this on her own behalf, it's hearsay that she's typing in these things as she's searching. So I would object to any of this coming in.
Okay, relevance. Let's see, Your Honor. These are 5 internet searches on the phone that Sergeant Keyless extracted. First of which is on May 11th of 2020. And the subject is domestic parenting with an abuser.
Yeah, I'm sorry, it's a search or it's an article?
It's a search, an internet search. This is Ashley Benefield, who, according to the state, as the court knows now, killed her husband to stop the release of Dr. Baroda's report. A few months before the shooting, searching the internet for how to co-parent with an abuser. And then again on 5/11/20, ask Amanda, how do I co-parent with an abuser? On 5/11/20, co-parenting versus parallel parenting with an abusive ex, the Good Men Project. And 6 tips on 5/11/20 to help you co-parent with an abusive ex. So the relevance, I think, is acute. Our whole theory of defense is that Doug Benefield was an abusive spouse. We have been denied the opportunity to introduce any evidence of that at every turn based on 2 rulings by the court. The first being the prejudice. Once the 9/11 tape came in which said my husband attacked me and I shot him, together with the swollen eye and the scratches. As the case law says, I think that may certainly qualify for the slightest evidence.
I just ruled on that.
All right. Then we find ourselves now in the same position as the ruling that the court just made, excluding the text messages of Doug expressing
Hold on.
a murderous.
You said I excluded them? I did not exclude them.
You're not allowing me to introduce them.
I said not now,
No,
at
that's-
this point.
Okay, so that's excluded, at least at this point.
Okay, go ahead, sir. I'm sorry for interrupting. Go ahead.
You're admitted. Now I find myself in the same position, except now the evidence is much more acute and much more corroborative of an abused woman's fear. Here we have, in her quiet, most private moment, what is she doing 5 months before the shooting? She's searching the internet about how she is to get along with an abusive ex-spouse. If that doesn't go to her state of mind about fearing Doug Benefield because he's abusive, I don't know what does. Now, procedurally, I can't provide the court with a case that says you're not allowed to introduce such persuasive evidence in the state's case. Again, I take the position, Your Honor, that the state should produce evidence that says I can't. And if they don't produce that evidence, then I think at worst, it's within the court's discretion. And I think it would be an abuse of discretion to not allow me to introduce this evidence when the state's whole theory that they just spent an hour and a half with this witness was establishing how well she and Doug Benefield got along in the week prior to the shooting. I've told the court several times now, that's the whole MO of an abused woman, is to get along and go along and act like everything is okay. That's why both Broder and Kittal have told the court and told the jury, yes, Miss Benefield was different. She acted differently when she was here and she saw me with Doug. At that time, she would always act deferential, but when she was by herself, she let me know, I don't want anything to do with this relationship anymore. So, Your Honor, I think in the interest of justice and fundamental fairness, I should be entitled to ask this witness to identify this information, which came in the same extraction he did for the state for the last hour and a half.
State response?
Judge, the reason this should not come in is the exact same reason that you just ruled on last issue. There are other reasons if it becomes relevant, if it becomes admissible, but that would be my reason.
Could I please see the exhibit?
Of course. Yeah.
And the purpose of offering defense exhibit 4A is to prove that Miss Benefield actually made those searches?
It's not being offered for the truth of the matter any more than the state's exhibits that Sergeant Keyless went through are being offered for the truth of the matter. It's being offered for the identical reason. This is part of what was on her phone. It shows her state of mind prior to this incident, and it is relevant to the defense. In fact, it's the backbone of the defense.
Previously, I had made the ruling that the text messages were admissible not for the truth of the matter asserted, and I was not asked to give any sort of limiting instruction, but I believe I had previously either I expressed that or during a ruling or put that in a prior order. The admissibility of those items and documents was established through the state's case. Let me start here. 3 things for admissibility of evidence: authenticity, relevance, and admissibility. So the authenticity for the text that we're talking about, the potential internet searches and so forth, the state provided that case. It came, the testimony is that it came directly from either Ashley Benefield's phone or Doug Benefield's phone. And the case provided by the state, I don't have the site in front of me now, the authenticity was established by the technical services officer explaining when and how he downloaded them. But authenticity doesn't automatically mean admissibility. They still have relevance and admissibility. Relevance, I understand what the defense is saying and how it's relevant to their case. And we've had this discussion on a number of pieces of evidence that the defense is trying to get in. And I understand how they're relevant. I understand the arguments, but I cannot blindly disregard the third prong, which is admissibility. And just because it helps a case or hurts a case doesn't make it admissible. I'm trying to think of, I know you're saying you're not offering it for the truth of the matter asserted, but I can't think of any other reason to put that information, these internet searches, in front of the jury, but to show that Ashley Benefield made these searches on a
DJ7 or Jig Ninic A time G1 are L Alif O03 SPX 5 Iconin B5s.
I'm happy to consider case law if you have some that says that I'm wrong, but that's the definition of hearsay. So at this point, I'm going to rule that they're not admissible.
I have no further questions of Sergeant Keyless. I would like to make a proffer if I could for the record.
Of course. Do you want me to call him back in for the proffer? Or you're just going to proffer?
No, yeah, I'm just going to read defendant's exhibit 2, or anticipated exhibit 2. These were text messages that were downloaded by Sergeant Keyless.
Can you just copy that and put that into evidence?
Yeah, can you show a copy to the state?
He did.
Oh.
If we could just make a copy and enter it.
Oh, we already have an exhibit 2, the clerk says.
Yeah, it didn't make it. I had marked it as exhibit 2.
That's the text messages.
The concealed weapons permit?
No, sir.
That's in.
Oh, I'm sorry, exhibit 3. I had marked it as exhibit 3, the text messages, and it did not make it in.
Okay, got it. Yes. These are texts from Doug Benefield's phone to Ashley Benefield's phone, downloaded by the officer. Right? So you want to put it in the record?
Yes, sir.
All right. You don't have to read it. I mean, it's going to be in the record. So that's 3. Did you also want to do 4A?
Yes, composite.
State, for purposes of the proffer, do you believe that Detective Keyless would testify that he downloaded Defendant's Exhibit 3 and 4A from Ashley Benefield's phone?
I believe he would, Judge. I don't know specifically with the second exhibit, specifically because I haven't investigated that, but I would assume yes.
All right, is that sufficient for your proffer?
Yes.
Do you want Keyless to stay under subpoena? Because I want to give him the right instructions.
Yes.
All right, can you have Detective Keyless come back in? I'm so focused on getting his name right, I keep forgetting his title.
Judge, if it makes you feel better, it took us about 2 weeks to get it.
It just looks nothing
spelled
like
so
that.
different.
That's why I did it.
Sergeant, I'm sorry. Just right in front of me. Sir, at this point, the defense has no further questions for you, so I'm going to be able to let you go for today. However, you have not been released from your subpoena, so all the instructions I gave you regarding sequestration of witnesses still apply. You may not discuss your testimony or the questions asked of you with anyone, including the attorneys or other witnesses. You can't discuss with other witnesses what their testimony was or what questions were asked of them. And to the extent that this trial is out there on the internet, you are not to watch or listen to anything related to it, including news reports. Do you understand? All right, sir, you're free to go now. If one of the parties calls you, you need to respond. Thank you. Oh, hold on. But I want to the clerk needs us to be clear on your proffer. Mr. Taylor, we have Exhibit 3, which is the
Text message.
the What's Now apps. WhatsApp messages. All right. That's document 3, but it's got multiple pages.
Yes, sir.
4A is not just 4A. It's 4A, 4B, 4C, and 4D. So we have
4A is a
composite 4 with A, B, C, and D. And then actually you had 5 was the Bible verse.
Yes.
All right. Well, the Bible verse, that's already in.
Yes.
I'm not denying that at all.
Thank you.
Do you want?
Well, I'd like to have it on there because
Stip.
they showed it, but they showed it very
Stip.
quickly.
Oh.
Defendant's Exhibit 5, which is
Sorry. Yes.
one of the I think this might have been the last one or one of the last ones.
Yeah.
All right. So there's a stipulation to the admission of Defendant's Exhibit 5. So that's in. Thank you, Madam Clerk, for catching that.
Well, it's
Right. 5 is in. 3 and 4 are proffers.
when you say, Your Honor, that Exhibit 5 is in for purposes of proffer.
No, for evidence.
Yeah, it's not going to do me any good as a single exhibit, Your Honor. I'd rather it be part of the composite. The court's ruled that it's not admissible.
No, I'm ruling 5 is admissible. Because it was shown. State, you showed it.
Right, it was shown.
So this is just a printout of.
Okay, but I think he hasn't.
Diane P. Riddick, EPR, HQMOU, DJ7 or Jake Minnick.
So maybe 5 should just be with the composite number 4 and not entered. Just give the as a problem.
All right, so I'm saying I would receive 5 in evidence. There's been a stipulation to it, but I'm not receiving it?
Correct.
Okay. I don't know what its status is then. All right. All right, Sadie, you ready to call your next witness?
Yes, Judge.
Ready to bring the jury in?
Yes.
All right. Let's bring him in.
And I think we are going to use.
Okay, guys, I'm sorry I was out of pocket. Y'all want to let me know what just happened? Oh, so what happened? While they do that, guys, let's do this. We're going to take a pause. Our interpreter is on her way in, but I have something I want to show. Is Braxton in the house? Is Braxton? Oh, hi, Braxton. For those who are just hopping on, I really didn't feel well this morning. Took some medicine, made me really green, so to speak. So I am just now recovering. I want to thank my mods for holding down the fort. Braxton, pay attention. Hey, y'all, I want to give a shout out to my mod tech, Braxton. He is fabulous. He has helped me straighten my computer out and get it running at its best. And he's also helped me with cords and all kind of good techie things. And if you are in need of any kind of tech assistance, please reach out to him. He is absolutely amazing. And Braxton, we are so blessed to have you here. And we really do appreciate you. And we also enjoy having you hop on live with us and share your comments. And you are just a fabulous member of the team. And we bless you.
Begin deliberations amongst yourselves. Talk with anybody outside of the jury.
Miss Kevin, can you send me a quick rundown of what just happened, or one of the mods in StreamYard? I mean, in
testimony.
Discord.
We'll let the state call the next witness.
Oh, what's going on with my computer? Good morning, Miss Diane, or afternoon. Thank you for hopping in. I know you've been a busy little soul. Ah, what? What happened to all my oh, there they are. Oh, I'll show it again. Where's Braxton? Braxton.
As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It just does adjust up, down, left, and right as you need. Speak in a loud, clear voice. We should hear everyone.
I will. Thank you, Your Honor.
Good afternoon, Doctor.
Good afternoon.
Would you please state your full name and spell your last name for the record?
Certainly. My name is Russell Scott Vega, last name spelled V-E-G-A.
And how are you employed?
I'm the Chief Medical Examiner for the 12th District of Florida, and that includes Sarasota County, DeSoto County, and here in Manatee County as well.
And how long have you been a medical examiner?
I finished my training in 1997, so more than 25 years.
And how long have you been the Chief Medical Examiner?
Here, so October 1st will be 21 years.
And you said here, were you a medical examiner somewhere else before?
I was an associate medical examiner in Hillsborough County for 4+ years.
And what kind of education do you obtain to become a medical examiner?
Well, I mean, it's different from person to person a little bit. I can tell you my own personal experience.
Yes, please.
Is this Sean Cornell?
So I did my undergraduate studies at Florida State University. I majored in physics and biochemistry. After my undergraduate, I went to medical school at the University of South Florida. I graduated from medical school in 1990. Following that, I did 2 years of training in general surgery and then 4 years of training in anatomic and clinical pathology. Pathology, it's a specialty of medicine that focuses on how to diagnose diseases based on looking at cells, fluids, tissues, biopsies, organs, and by doing autopsies. Finally, after all that, I did a 1-year fellowship in forensic pathology. That's the subspecialty which really focuses on performing autopsies and doing death investigations.
Thank you, sir. And what are your current duties as a chief medical examiner, or at least, yes, as a chief medical examiner?
So as the chief medical examiner, I administer the office here. So I manage the staff, I set policy, do procedures, and I do some of the casework myself. So I do some of the autopsies and death investigations.
So you do still conduct autopsies regularly?
I do.
And do you know how many approximately autopsies you've conducted in your lengthy career?
I don't know exactly. I suspect it is getting close to 4,000.
And of those, can you have any involved gunshot wounds?
Very many of them.
And so that was my next question. The percentage, you think it's a lot?
Yeah, I can't tell you the percentage, but I've examined many hundreds of gunshot wounds.
Thank you, sir. And I'm gonna draw your attention back to September of 2020. Did you conduct an autopsy on Douglas Benefield?
I did.
And when did you do that?
The autopsy was performed in the morning of September 28th of 2020.
And can you explain how your procedure for conducting an autopsy?
Certainly. And I don't think my procedure is greatly different from other medical examiners or forensic pathologists. But the procedure starts with the examination of the body in its state as it arrives, at our facility where the autopsy is performed. That includes documenting the condition of the body with photographs and diagrams and written notes. Following that, if there's reason for evidence collection, and typically that's going to be in concert with a law enforcement agency, then evidence collection ensues. After the initial part of the examination and the evidence collection, then there is a more detailed examination looking for identifying characteristics, changes that might represent natural disease, and then any injuries that are present. After all of that, then I think what many people might consider the traditional part of the autopsy begins, which is the internal examination, where the body is examined internally for, again, the same kind of changes of injuries and natural diseases.
And is that the process you followed in the autopsy of Mr. Benefield?
It is.
Thank you. And during your autopsy, are photos taken to document injuries found, if any, on the body?
Yes.
And in this case of the autopsy of Mr. Benefield, were pictures taken?
Yes.
Your Honor, may I approach the witness?
Yes.
Dr. Vega, I'm showing you what's been pre-marked as states 86 through.
Can I see the photographs, please?
Yes, the same as the one you just looked at.
So there's 3 photographs, Your Honor, that I have an objection to.
Okay.
Wow. Okay. What's happening? Oh.
Well, she
Wow,
said put them
that's
back in
loud.
order for me while we do that. During your autopsy, did you determine the height and weight of Mr. Benefield?
I determined the height and the body length, as that's what we measure with the body reclined on the table. I think it's a very close approximation to height. It might not be exactly the same.
Yes, sir. And what was Mr. Benefield's weight at the time of his homicide?
It was 169 pounds.
And the length?
The body length was measured to be 69 inches or 5 foot 9 inches.
Thank you for converting it for me. And during your external exam, as we discussed, those
Little man,
injuries
well,
are documented in these photos as well. Is that correct?
Yes.
Okay, and I'm going to now show you.
Wow, y'all. You got the job. Yay! Oh my gosh, Braxton, that is wonderful. Braxton got the job. When do you start, babe?
Dr. Berry, we're going to try this one more time. I'm going to show you 86 through 97.
The daughter.
Look at those photos and telling me if you recognize them.
So they're playing around. Braxton, since you're here, I'm going to redo this. Hey, y'all, I want to give a shout out to my mod tech, Braxton. He is fabulous. He has helped me straighten my computer out and get it running at its best. And he's also helped me with cords and all kind of good techie things. And if you are in need of any kind of tech assistance, please reach out to him. He is absolutely amazing. And Braxton, we are so blessed to have you here. And we really do appreciate you. And we also enjoy having you hop on live with us and share your
Yes, I do
comments. And
recognize
just you are
And are
just a fabulous member of the team. And we bless you.
And what are they?
These are photos taken at the time of the autopsy of Mr. Benefield back in September of 2020.
And do they fairly and accurately depict some of the injuries and some evidence that was as they were in September of 2020?
Yes.
Thank you, Your Honor. Thank you, Your Honor. At this time, I'd ask to enter states 86 through 97.
No objection. Received.
Thank you. And generally, when you examine Mr. Benefield's body, I'm going to display them up here in just a moment. Did you find injuries on the outside of his body?
I did, yes.
And where were they? And we'll talk about them in detail, but generally, where were they?
There was an injury to the right side of his chest. There was an injury to his right shoulder, and there was an injury to his right leg.
And did he have any injuries to his face or head?
No. Well, he did have to his head. Yes, I'm sorry, not his face.
And what type of injury was that?
The injury to his head was what we would typically call in medical terminology, we'd call an abraded contusion. That's a swollen and scraped bruise. And it was on the very back of his scalp at what we'd call the occipital protuberance or the lump at the very back of the head.
And what would that type of injury be consistent with?
Typically, it's from falling backward and striking the head.
And when you were looking at his external injuries, did you have some opinion as to what had caused them, specifically the chest and the leg?
Yes,
And what did you feel that they were?
they were gunshot wounds.
And did you then conduct an internal exam?
Yes,
And did that internal exam confirm what you felt about that they were gunshot wounds?
yes.
And I'm going to display behind you states 86. Oh, and I believe this is generally what we call an identification photo. Is that correct?
That is correct.
And is that Mr. Benefield as he was in September of 2020?
Yes.
Thank you. And then let's first talk about the injuries you said he suffered to the chest. You said that was a gunshot wound?
Yes.
And how many defects in his body were associated with the chest wound?
There was one defect, and that was on the upper right side of the chest.
And is that what we see here in states 87?
It is, although we're also seeing the injury to his right arm area as well. Actually, that's the one that has the marker on it. The chest injury is just above and to the right of that, at least according to the viewpoint of the viewer of this photo.
And for orientation purposes, this is his right side of his body?
It is, and I'll use the laser pointer to indicate this is the arm injury, and that's the chest injury, just to the right side of his right nipple.
And was there, you said there was only one injury. Does that mean this is an entrance wound?
That's correct.
Was there any, and there was no corresponding exit?
That is also correct.
And did you locate a projectile that was associated with this chest wound?
I did.
And where was it?
It was lodged in the tissues of the left side of the back.
I'm going to show you states 88. I believe that's a close-up of the injury we saw on his chest.
It is.
And then can you kind of orient the jury as to what we're looking at in states 89?
Yes, this is the back of Mr. Benefield's body. He has been rolled up onto his left side. So what we're seeing here is his back, the head here. So this is the left shoulder. The right shoulder would be up here. This is the left side of his back, and it's this purple area right here that represents where the projectile was lodged under the skin and the tissue.
And did you remove it?
I did.
I'm going to show you states 90. Is that the removal process for the projectile from Mr. Benefield's body?
It is. In order to visualize it and then remove it, I made an incision in the skin, which you see here. And then just for documentation purposes, I reflected the skin with the tip of the scissors so that we could photograph the projectile in place in the tissue prior to its removal.
And Dr. Vega, I'm sorry, I'm going to go back to states 89. Where you described his body, but there's some skin discoloration. Can you explain to the jury why his skin looks red or darker?
Certainly. That is what we call lividity. Lividity is the settling of blood in the tissues that occurs after death when the heart's no longer pumping, and the major force acting on it is gravity. When somebody's lying on their back after death, which is typically what we see, we are of the usual process of putting somebody on their back in a dignified position after death. And so the blood typically does settle into the back, and we see this purplish coloration here, which is a result of that. There's some here as well. This area here where there isn't any discoloration, except where the bullet is because this is where the table was pressing up against the skin, and that pressure kept the blood from settling in those areas. So most of this purple discoloration is lividity, with the exception of this area right here, which is due to a little bit of bruising associated with the placement of the bullet there.
And Dr. Vega, I'm going to show you what's been marked as states 14. Would you take a look at that?
She's not looking, y'all. Not looking at all.
Yes, I do.
And how do you recognize it?
This is the projectile that I recovered from the back that you could see in the photograph you had up previously.
And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's back?
It does, yes.
Your Honor, at this time, the state would ask to enter states 14.
Objection received.
And Doctor, I'm going to show you states 95. Is this the same projectile that you have there in states 14?
Yes, it is.
And what, if you know, is that red part that's next to the projectile?
This is a small rubber plug that is occasionally found in certain hollow point type but it's part of the process of creating this hollow point that allows the projectile to expand and deform, as we see in this case here.
Thank you. And so going back to the location of the projectile, based on where the entrance wound was and the where you found the projectile, did you determine a path of travel that projectile took through Mr. Benefield's body?
I did.
And what was the path of travel?
So the path of travel was one of entering the right side of the chest, striking the fifth rib on the right side, the right lung, the 10th vertebral body on the in the middle of the spine, then the left lung, the 10th rib, and then the soft tissues of the back until it stopped where it is. And that path then, if one were standing upright and straight, would be from the right side toward the left, from the front towards the back, and essentially horizontal. In other words, without angling upward or downward. And again, that's relative to a standing upright position.
Yes, sir. And would you mind, would you be so kind as to stand up and kind of point on your body to where the entrance would be?
Certainly.
Thank you, sir. And where would the exit would be?
Well, no exit, but
I'm sorry, the projectile.
The projectile.
Yes, sir.
My mobility is a little limited, but essentially would be in the back over here, where the tip of my thumb is.
Thank you. And would you just turn back so we can see the entrance again?
Yeah.
Thank you, sir.
You're welcome.
Is that a downward angle? So she's above him.
And you said that the
From right to left, front to
wound
back,
was front to
top
back.
down.
Was it, and from how you showed, you said it was essentially horizontal.
Yes,
Was it? It wasn't front to back like it went straight through. Can you describe it?
certainly. I mean, it went through an angled path through the body, and that angle took it from the front toward the back, but at a greater angle from right to left.
Thank you. And you said that it struck his ribs and his lungs and his vertebral.
His vertebral body.
Thank you.
The spine.
His spine.
Yes.
And would that injury have been immediately fatal?
Probably not.
And would it have incapacitated, if you can say, incapacitated Mr. Benefield quickly?
I think it would have incapacitated him quickly. Whether or not it was immediate, I don't think one can predict.
Thank you, sir. I'm now going to take you to the arm wound. Was this wound different from the wound we saw in Mr. Benefield's chest?
Yes.
And how so? And this, for the record, states 91.
Yes. What one can maybe not clearly appreciate just from viewing the photo, but was clearly evident at the time of the examination, is that this is only a surface wound. So what you see as the mark on the skin here is the full extent of this injury. So it's an abrasion or a scrape on the skin, but outside of the effect on the skin, nothing deeper was involved with this injury.
Thank you, sir. And then you said, finally, you said he was also shot in the leg. Is that correct?
That's correct.
So I'm going to show you states 92. Can you orient the jury as to what we're looking at on Mr. Benefield's body?
Yes, and this is a little bit of a tough one orientation wise, but the injury is to the back of his leg. So what we're seeing here is the back of the leg, and it's excuse me, the calf area here, this is a perforation of that calf. Yeah, I think that's the best way to describe it. The calf
Good point,
area.
Miss Kevin.
The chest wound we saw entered and did not
Good
exit.
point.
Was this wound the same or was it different?
It was different
And how so?
because this injury did indeed have an exit.
And where did you locate the exit?
The exit was on the right side of the knee.
And Dr. Vega, how can you, and I have a picture of that, but before we move on to that, how can you tell the difference between an entrance and an exit wound?
It's not always possible, but typically entrance wounds have more of a well-defined defect in the skin. Frequently,
It's a
that
smooth
defect in the
circle
skin is
versus a
paralleled by
torn and
defect in the
shredded
tissue that one
circle.
can appreciate underneath. Many times, the edge of the skin perforation or the edge of the skin defect will have a ring or at least an arc of abrasion or scraping as the bullet passes through. Exit wounds tend to not have those features. One way that I like to think about this is it's like a very fast moving awl or punch, in that it goes in and it almost drills a hole into the skin. But when it exits, what it does is it tenses up the skin until the skin tears. That's how a bullet exits. So typically the tear doesn't have the same well-defined drilled appearance that the entrance wound rather does. And in this case, that's exactly what we see.
And I'll show you 93 that correct me if I'm wrong, but that is the exit wound associated with the entrance we just saw.
That's correct.
And so, and I have a close up. This is states 94. And so can you kind of show the jury how you knew this was an exit wound?
Yes. So this injury does not appear to be a round or drilled type of defect, but rather a tear in the skin that occurred when the skin was stretched until its breaking point by the bullet trying to exit.
And were you able to determine the direction, the wound path for this injury?
Yes.
And what was it?
So the wound path started at the back of the leg and went through the musculature of the calf. And then I couldn't tell for certain if the path actually went through the bones or if it passed right next to the bones, but because of blast effect, injured them, causing fracture. The amount of tissue damage can make that part difficult to separate out. And that was the case here. After doing that and fracturing the very top part of the leg bones, the tibia and the fibula, it then exited through this exit defect on the lower right side of the knee.
And I hate to ask you, but would you mind stepping down and showing us on your leg where this entered and where it exited?
Certainly.
Thank you. If you're more comfortable, you can. It's easier. Yes, sir.
Mr. Taylor, if you need to reposition so you can see, please feel free to do so.
Thank you, Judge. So on me, the entrance was here.
If it help, I can put my finger there.
Okay. And the exit here.
So here to here.
Yes.
And so that's, you said slightly up or up.
It's upward from the right toward the left, and from back to front. Yes, largely all three of those components.
Thank you. Well, you know what, Dr. Vega, while you're down here, just for clarification, would you show me again the chest wound? Just because I think you're easier to see now that I made you get off the stand.
Entrance. Lodged bullet.
Would you just spin one time? Just turn so they can see. Thank you. Thank you so much, Dr. Vega. I appreciate that.
Mr. Taylor, were you able to see both of those demonstrations?
Yes, Judge White, thank you.
Dr. Vega, was there any physical evidence associated with this injury that was recovered from Mr. Benefield's body?
From the leg injury?
Yes, sir.
Yes, there was.
And I'm going to show you states 15. You'll take a look at that and tell me if you recognize it.
Yes, I do.
And how you recognize it?
This is the lead fragment which was recovered from Mr. Benefield's leg just deep to the exit defect.
And how does this differ from the projectile? Like you're saying fragment, what does that mean compared to the projectile?
Well, as we've already discussed, we have an entrance and an exit here. So essentially, the projectile exited the body. Before it did, a small piece of it broke off and remained in the tissues. This is that piece, and that's what I recovered at the autopsy.
Thank you, sir. And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's body?
It does.
Thank you. Your Honor, the state would ask to enter states 15.
No objection.
Received.
Thank you. And Dr. Vega, I have a photo of states, this is states 97. Is that the same item that is in states 15?
Yes.
Thank you. Did you find any, I'm going to go back to the, well, Dr. Vega, what is stippling?
Stippling is a term we use to describe certain changes that occur in association with gunshot injuries. It refers to the pattern on the skin or any other target of unburned gunpowder fragments that strike that target and create a pattern.
And did you find any stippling associated with the gunshot wound to Mr. Benefield's leg?
I did not.
Did you find any with a wound associated with his chest?
I did not.
And what, if anything, does the absence of stippling tell you? Specifically, we'll talk about the leg first.
Well, the absence reflects the same principle in either injury, and what it means is that typically when the weapon was discharged, it was far enough away so that the unburned gunpowder fragments, which are ejected with the bullet, had a chance to lose velocity and fall away prior to striking the skin. In general, typically that means that the muzzle of the weapon was more than 3 feet away from the target or the skin in this case. But any more precise determinations require, the test firing of a weapon, same weapon or same style of weapon with the same ammunition to try and get more specific information.
And for the chest wound, if he were wearing a shirt when he was shot, would that affect what you would find on his body?
Yes.
Okay, that was why I was asking separately. And so to be clear, you said the muzzle. So would that mean that if it's not necessarily the body of the shooter, but if they have their arm extended or even here, it's the end of the gun from Mr. Benefield's body?
That's right.
And I know you determined a path of travel for, and we're still talking about the leg injury, for this leg injury, but does it tell you this path of travel anything about where the shooter would have been standing?
All it really tells me is the relative position of the weapon to the leg at the time that the weapon was fired.
Yes,
and trying to come up with the relative position of the shooter at the time that the weapon was discharged is much more complicated because both the shooter and the victim, and specifically the victim's leg, can be in multiple different positions and still end up with that required relative position of the gun to the leg and still create this same injury.
And Your Honor, may I have just one moment?
Yes.
Sorry, this is not sounding fully self-defense to me.
Hypothetically, Mr. Benefield were falling, would it make sense that his legs would flip up in the air enough for this path of travel? Does that make sense?
If this injury were sustained while he was falling,
Yes.
then the injury would be sustained while his body is changing its position and in motion. But regardless, at the time the weapon was fired, the muzzle of the weapon would still have to be, relatively speaking, below, to the left of, and behind the right leg in order to get this particular angle of path of travel through the leg.
Thank you. And can you tell when you conduct an autopsy, and specifically in Mr. Benefield's, which of these wounds occurred in what order?
I cannot.
And once you completed your autopsy, did you order toxicology testing?
Yes,
And was that done in this case?
it was.
And were there any drugs or alcohol found in Mr. Benefield's body?
No, there were not.
And finally, based on everything that you did during your autopsy, did you determine the cause of death?
I did.
And what was that?
I determined the cause of death to be a gunshot wound to the chest that caused perforation of the lung, or the lungs, both lungs, with hemothoraces. It's a fancy word for bleeding that occurs in the chest.
And I didn't ask you this, but I guess, could you explain, so once this bullet entered Mr. Benefield and started to travel through his lungs, what would have been happening inside his body, or what would happen right after?
The primary things that happen there are that very rapid bleeding starts to occur. The bleeding is rapid because the lungs are very vascular. And so when they're damaged, they bleed very quickly. And also there's no impediment to the bleeding. The cavity around the lung can expand very rapidly to accommodate bleeding. So the bleeding that happens as a result of a gunshot wound to the lung is very rapid. In addition to the bleeding, when the lung gets a hole in it, it no longer holds its shape and its anatomical arrangements, and it collapses to some extent. That collapse is made worse by the accumulating blood pressing on the lung as well. So the combination of physiological effects of bleeding and lung collapse are the primary things that are occurring in the body at the time that, or immediately following the bullet passing through the lung.
Thank you. And did you determine the manner of death in this case?
I did.
And what was that?
I determined the manner of death to be homicide.
Your Honor, may I have just one moment?
Okay, I'm going to put my 2 cents in. Someone has a medical degree can argue me, and that I'd accept, but he did not pass instantly. I have seen wounds like this in the chest before. You can hang on for a while. It is a suffocating. Your lungs aren't functioning. The spinal column or the spine was injured. This was not something he would have passed in 1 or 2 minutes, maybe 5, maybe 10. And don't forget, even though your heart stops beating, it takes 3 to 5 minutes for your brain to start dying. So all that time she sat on the neighbor's steps, and the time she was over there, and the time it took for them to get there, he was in the process. But when the police showed up, and the sheriff or whomever, they said he was cold. That means he'd been there for a few. This is why I'm starting to get a little bit on the side of not self-defense, because if it was, he would have been still warm when they got there. Yeah, I'm interested to hear more. Exactly.
I don't have anything else, Dr. Vega. Thank you. The defense may.
Mr. Taylor Cross.
Am I right, sneaky side?
First question is, do you need this? I do not.
All of you nurses and medicals, am I not right?
Afternoon, Dr. Vega.
Good afternoon.
Haven't seen you for a while. How's that new facility that you're in?
Very nice. Thank you.
Just a few questions, if I may. I think you told us that the deceased was 169 pounds and stood 5 feet 9 inches tall.
Correct. Yes.
Muscular build.
I don't think I used that terminology. I think I just talked about the weight and the body length.
I want to ask you, you mentioned about hollow points. You know, the public perception about hollow points is that they are more lethal. The fact is it not true that the hollow point is designed to expand when it goes through tissue?
Yes, that's right.
The theory being it's to stop a bullet from exiting and harming someone else.
That's certainly part of the philosophy or utility of having a hollow point projectile.
And when you tell us that the wound was probably not fatal, within a reasonable degree of medical science, and I think you made it pretty clear, you really can't say one way or another that upon being shot like that, he would have dropped immediately, that he may have continued for a couple of seconds.
Yes, that's right.
Even a minute.
The stippling issue about gunpowder, it's from a distance of approximately, you told us, 3 feet.
Roughly, yes.
Okay, that's, so when you exceed more than 3 feet, you would not expect to find stippling.
That's correct.
Okay, and you didn't find any stippling on his shirt?
I didn't examine his shirt.
Okay, so
She was not right on him.
if somebody
Stippling wasn't there. She wasn't
away
super close.
while they were firing and they got beyond that 3-foot range, there may not be any stippling.
That's correct.
All right. You said that the wound to the scalp was indicative of, you traditionally see it, of somebody falling backwards and hitting a hard surface like a tile floor.
Yes.
I want to ask you just a couple other questions. Are all homicides crimes?
Objection, Judge, beyond his expertise.
He's not a police officer.
I'll allow that the witness has the knowledge to answer.
In my experience, homicide, as determined by a medical examiner, has a certain medical legal significance, which does not necessarily imply criminality.
Okay. In simple language, it could be excusable,
I'll sustain.
justifiable. I think if it's within his knowledge, Your Honor.
No, I'm going to sustain because that's asked for a legal conclusion as opposed to a medical conclusion.
All right. You mentioned, Dr. Vega, that you could not determine the order of the shots.
That's correct.
Okay, there is no medical method of being able to say which shot came first, which shot came second.
In certain cases, the physiological findings may help you with that, but in this case, no.
Would it be a fair statement for me to say that for the chest shot, the weapon would have had to have been pointing at his chest from the front?
Yes.
Let me just check, Your Honor. I think that might
Yes, sir.
conclude. Last question with respect to the leg. You've told us that the gun would had to have been lower than the leg to get that upward trajectory.
Yes, although I would say that, lower is a relative term.
Yeah.
And legs can be put into various different positions. And if we're going to say lower, then it needs to be clear that lower means with respect to the leg in an upright position. And if the leg were horizontal, for example, then we might be talking about a position which is above the leg, but pointing up towards the head of the body, for example.
Okay, so let's try to be clear here. If Mr. Benefield fell backwards and his legs went up in the air, might that injury be consistent with that?
Given that scenario, it's possible.
I believe that's all I have, Your Honor. Thank you, Dr. Baker.
State, any redirect?
Dr. Vega, I don't want it to be unclear. The gun would have, for the chest wound, the gun would have had to have been in front of Mr. Benefield's body. That's what you said.
Yes.
But it didn't enter his chest. It entered, or the front of him. It entered through the side.
Yes. So the weapon did have to be in front of him, but even more so, it had to be to his right side.
And based on your training and experience, is it typical that if somebody were to fall backwards, that their legs would go above their heads when falling?
No.
Without the intervention of something to fall over, an ottoman, a chair, or something like that, it seems unlikely.
And if Mr. Benefield were running or his legs were up in the back, could the angle have also been accomplished?
Yes.
Thank you, doctor. I don't have anything else.
Ooh, recross.
That's all.
All right, can the witness be released?
Yes, sir.
Yes.
Sir, you're released from your subpoena. You're free to go.
Thank you, Your Honor.
Yeah, he ain't gonna hang around. He got work to do. Busy man, busy man.
Deputy Pass 14 and 15. Would you mind?
Oh,
FY guys, I am feeling better. Thank you so
pass mean,
much.
Yes.
To the jury.
Sorry,
Wasn't
publish.
quite sure what you meant. Publish.
Sorry, I meant pass through the jury. Yes, sir.
If the jury,
Good
as
witness.
yesterday, would have passed these around, these will go back with you during your deliberations. All right, state, your next witness.
Daniel Hausdorff.
Yeah, that was miserable this morning, y'all.
Madam Clerk,
I had 2 worried children.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
yes, ma'am.
Is the sound okay for y'all? Or is it too soft?
My name is Judge White. I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. Scoot up just a little bit. I'd like to have you about 12 to 15 inches away from that microphone. It does adjust up, down, left, right as you need. And if you just speak in a loud, clear voice, it should become better.
Yes, sir. Thank you.
Good afternoon.
Good afternoon.
Could you state your full name?
Hold on one second.
Oh, I'm sorry.
Go ahead. You all finish up. So you're gonna wait a second.
Yeah, I apologize, Judge.
I don't want anybody to feel rushed. But like I said, everything will go back with you all during the deliberations.
Thank you.
All right, Ms. Friel.
Thank you, Judge. Please state your full name and spell your last name for the record.
My name is Daniel Hausdorff. Last name is spelled Hausdorff.
And how are you employed?
At the Florida Department of Law Enforcement, also known as FDLE.
And how long have you been with FDLE?
It'll be 11 years in September.
Did I hear that right?
And
What was the
is
last
your
name?
title and position?
I am a crime laboratory.
Sorry, I got to do it. They always mumble the last part.
But like I said, everything will go back with you all during the deliberations.
Thank you.
All right, Ms. Friel.
Thank you, Judge. Please state your full name and spell your last name for the record.
My name is Daniel Hausdorff. Last name is spelled Hausdorf.
And how are you employed?
Got it.
Pete Florida Department of Law Enforcement, also known as FDLE.
And how long have you been with FDLE?
It'll be 11 years in September.
And what is your title and position?
I am a crime laboratory analyst in the firearms section.
And how long have you been in that position?
I've been in that position out of training since August of 2018.
And what are your official duties as a crime lab analyst in the firearms division?
My main duties include microscopic comparisons of fired ammunition components, such as cartridge cases and bullets. I also perform firearm function testing, which means I test fire the firearms as well as check the safeties. I perform distance determination, serial number restoration, and imaging cartridge cases into our database.
And when you say cartridge, well, we're going to get there. I'm sorry. What kind of training did you receive to become a firearms analyst?
I have a bachelor's degree in biomedical science from the University of South Florida. I was hired at FDLE in September of 2013 as a forensic technologist in the firearms section. That had 6 months of training, and I was in that position for about 3.5 years. I then was promoted to analyst and completed the 18-month training program to hold that position, and have been out of training since August 2018.
Thank you. And do your daily duties include the analysis of firearms?
Yes, ma'am.
And have you previously testified as an expert in the field of firearm analysis?
Yes, I have.
Thank you. And can we just talk about ammunition first to kind of get the basics? What do you call a complete item of ammunition?
A cartridge.
And someone might refer to that as a bullet, but that an intact live round.
Yes, ma'am.
Okay, so you use the word cartridge.
Yes, ma'am.
And what are the components of a cartridge?
A cartridge is comprised of 4 parts. There's the cartridge case, which is the body of the cartridge. There's also the primer, the gunpowder, and the bullet.
And the bullet might also be referred to as?
A projectile.
Thank you. And does your analysis also regularly involve the analysis of semi-automatic firearms?
Yes, ma'am.
And can you tell me what a semi-automatic firearm is?
A semi-automatic firearm is a handgun that is going to fire one shot every time you pull the trigger, and the gases for firing is automatically going to cycle the firearm, extracting and ejecting a cartridge case and automatically loading another cartridge.
And so the cartridge case leaves the firearm every time?
Yes, ma'am.
And that's opposed to a revolver, is that right?
That's correct.
And I want to draw your attention to FDLE case 311227, the case you're here about today. Did you have the opportunity to examine evidence submitted to your lab under that case number?
Yes, ma'am.
And when you receive evidence into your lab, what's the normal procedure?
The normal procedure is the agency will submit the evidence to our lab where it's given a unique FDLE case number, and then each item has a unique FDLE item number. It's given a case tracking form, which I receive from my supervisor when I'm assigned the case, and that has all the details of the case, and everything is tracked in our computer system called LIMS. It's the Laboratory Information Management System that just keeps all the information about the case and the evidence for the custody of all the evidences being held at that time and things like that.
And when did you conduct your examination of the items in this case?
I started working this case on March 9th of 2021.
And I want to first show you states number 13. It's already in evidence. It's open. Would you take a look at that and tell me if you recognize it as an item you received in your lab?
Yes, ma'am.
And what is it?
It's the Springfield Arm Rate 45 auto pistol that I received.
And how do you know that it's the same firearm that you received in your lab?
It has the FDLE case number, item number, and my initials and my handwriting on both the pistol and the magazine.
Thank you, sir. And what type of analysis did you perform on this firearm?
So whenever I receive a firearm, I'm going to perform a function test on the firearm to make sure that it does fire, in fact, and also check the safeties on the firearm. In this case, there are 3 safeties on this firearm. There's a trigger safety, a grip safety, and a firing pin block. All are designed to make sure there's no accidental firing.
And was this firearm found to be in proper functioning order?
Yes, ma'am.
If Your Honor and the deputies don't mind, is it okay if he removes it to display it to the jury so I can ask him some questions?
It's empty.
I was gonna say there's gloves here if you need them.
It's okay.
Again, Mr. Taylor.
Oh,
if you
no
need to
gloves?
Reposition so you can see exactly what's going on. Please feel free to do so.
Mr. Hausdorff,
Yes, ma'am.
would you mind just standing up so the jury can see and telling us the parts of the gun that you just talked about?
Yes, ma'am. So this is the top portion of the firearm called the slide. There's the trigger, where the trigger safety is right in front of the trigger here. There's the grip safety in the back, which is depressed by normal operation of the firearm. There's the firing pin block, which is housed in the slide that is deactivated when the trigger is pulled. And the way that this firearm works is there's ammunition loaded in the detachable box magazine. It's inserted in the grip of the firearm. At that point, I would release the slide and load one round into the chamber of the firearm. I would pull the trigger, which is going to cause the firing pin to release, striking that primer on the cartridge, causing a spark to go through the flash hole, and then the gunpowder, which is going to cause those rapidly expanding gases to propel the bullet down and out of the firearm. But it's also going to cause the slide to move rearward. The fire cartridge case is going to extract and eject out the side. As the slide moves back, it's going to recock the firearm, and then it'll go back forward again, pulling another cartridge from the magazine and into the chamber of the fire, ready to fire again.
Thank you, sir.
I'm sorry. Can you put it for a moment?
Of course. Mr. Hausdorff, if we heard testimony that when this firearm was found, the slide was not totally seated, does that make sense to you? Am I saying the right words?
Are you basically saying that it wasn't in battery, that it wasn't all the way forward?
Yes, in battery, that's what he said.
Okay.
And that there was a live round still in the shape.
I'll allow it to set up the scenario.
And the deputy testified there was a live round that was still in the chamber.
Okay.
Is that something you're familiar with occurring in firearms?
It's a possibility if the extractor is really tight, if the spring is very tight on that, it's possible that it would not go around the extracting groove on the cartridge.
Yeah.
If that happens, it could get stuck back just slightly. I mean, a quick jar to the back of the firearm could knock it over that. But normal operation of the firearm.
Case one, no. No. As fast as your finger will pull the trigger, it will release a piece of lead every time. It could be pop, 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 or it could be pop, pop. You don't have to. It automatically redoes it himself. Semi-automatic. Not like some revolvers.
It should cycle properly. And since I test fired it 3 times, I didn't have that issue when I was firing.
Say, go lay down. Lay down.
Not seated and that live round was
Please.
not in a completely normal position, would that prevent the gun from firing?
Yes, ma'am. It won't fire when it's out of battery.
Thank you. I'm now going to show you states 4 through 7, which I believe are your items 3 through. You take a look at states 4 through 7 and tell me if you recognize them as items you previously examined.
Yes, ma'am.
Thank you. And how do you know these are items you previously examined?
They all are marked with the FDLA case number, item number, and my initials and my handwriting.
And what are these items?
These are the fire cartridge cases that I received in this case.
And what is the caliber of these casings?
They're 45 auto plus P, and the plus P just stands for higher ammunition pressure.
And what does that mean, higher ammunition pressure?
It means they're loaded to have higher velocity.
And velocity is the speed in which they travel?
Yes, ma'am.
And how do you know the caliber of these casings?
It's written on the head of the cartridge, which is right back here.
And is there a name for that end of the cartridge?
That's the head.
Thank you. And what type of examination or testing did you conduct on these cartridge cases in states 4 through 7?
So these cartridge cases, I performed an examination that I was trying to compare these cartridge cases to the test fires that I created from this firearm to determine if they were fired in this particular firearm.
And how do you accomplish that?
So when I test fire the firearm in our indoor laboratory range, I used laboratory ammunition that's similar to the evidence that I received in this case. So I test fired 3 Hornady rounds that were 45 auto, which is the same brand that I received in this case. After I get done test firing it, I take the cartridge cases and the fired bullets that I received back to my office where I compare them under a comparison microscope. It's 2 microscopes joined by an optical bridge that allows me to view 2 objects at the same time under the same magnification. So what I'll do is first look at my test to test, and I determine what's the repeating pattern that's coming from the firearm itself that's being transitioned to the cartridge cases and bullets during the firing process.
Can I stop you there just
Yes,
so we
ma'am.
can talk about that part?
Yes.
We're really going. And so you said you first look at test to test. And can you explain slowly
Yes, ma'am.
what you're looking for to compare those to see your test and what you're looking for to determine?
I'm looking for the reproducible pattern that's coming from the firearm. So what happens is when the cartridge case is fired, or the cartridge is fired, the cartridge case will expand back and make impressions from inside the chamber of the firearm, as well as this end of the firearm, which is known as the breech face. And this is where the firing pin comes through and strikes the primer. All that pressure is going to push the cartridge case back against those areas, and all the microscopic imperfections within the firearm are being transferred to these cartridge cases during firing. The reason is the firearm is the harder object, the cartridge case is the softer object. The same thing is happening with the bullet. The bullet is going to expand, also known as obturating. It's going to seal all the gases in the barrel, and there's rifling inside of the barrel, known as the lands and grooves. It's going to seal all those gases. The impressions are going to be transferred from the barrel to the bullet.
And when you looked at your test fires, you said there were 3?
Yes, ma'am.
Did they all have consistent patterns on them?
Yes, they do.
And so once you determine that they in fact received consistent patterns, what's the next step?
The next step is to take the one that has the best representation of that firearm. It's essentially, if you think about it, you're making like an ink stamp on the ground. It's the same stamp, but depending on the pressure, the angle, it's not going to look exactly the same. So I'll pick the one that has the best representation of everything from the firearm. And when I do that, I'll place one of those test fires on the right side of my scope. and I'll take one of the unknown cartridge cases on the left side of my scope. And when I look at them on the oculars, I overlay the images on top of one another, and I can see the patterns repeating between one another.
And once you compared your test fires to the cartridge cases in states 4 through 7, did you make a determination about their relationship to this firearm?
Yes, ma'am. All 4 of these were in fact fired in this firearm.
Thank you. I want to now show you states 8, 9, 10. And 14.
Y'all, this is very techy.
Take a look at these items.
Thank you.
And tell me if there are items that you previously seen in your lab.
Wonder where our lovely Jules went. Maybe she moved again.
Yes, ma'am.
And how do you know?
They all have my markings on the base of the bullet with the FDLE item number, case number, and my initials in my handwriting.
And how are these items different from the cartridge cases we just talked about?
These are the bullets that are fired from the firearm.
And are you able to determine the caliber of fired
Okay,
bullet?
sneaky side.
Yes, ma'am.
And how do you do that?
So what I'll do is a couple different ways. I'll measure the base of the bullets as well as the weight. And if I have both of those, that'll already give me my answer like that. And in this case, all 4 of these projectiles were intact. So I was able to tell the caliber just based off of that.
And what was the caliber you determined these bullets to be?
They're in 45 caliber class.
And that's the same caliber as the casings and the firearm, is that correct?
That's correct.
And what type, other than the weighing the measurements, what type of examination or testing did you conduct on these projectiles or bullets?
So I did the same thing as the cartridge cases. I examined the test fires from this firearm to the bullets here, determining if they were or were not fired from this particular firearm.
And once you did that comparison, were you able to, did you determine?
Yes, ma'am.
Okay, thank you, sorry. And I got distracted. And what was your finding?
That all 4 of these bullets were fired from this firearm.
Now, I think the first time you said fired in and then you said fired from.
The reason I just say in is the cartridge cases are technically in the firearm, and I say from because the bullets leave.
And so there's really no difference other than it's tech.
Yeah, let me explain that part. People don't get it. The projectile, including the cartridge, goes into the lead shooter. The part that expels from the lead shooter is the actual bullet, lead. The cartridge ejects. That's why he said in, because the whole projectile goes into the weapon, but the lead is projectile. It goes through the weapon. That's why the confusion.
Technical.
Yes, ma'am.
Thank you, sir. Finally, I want to turn your attention to states 15, which is a fragment. Will you take a look at that and tell me if it is also something you previously examined?
Yes, ma'am.
And how do you know that is something you previously examined?
On this one here, it was too small for me to mark on the evidence itself, but on the container, I have the FDLE case number, item number, and my initials in my handwriting.
And were you able to conduct any analysis of that item?
On this one, my only analysis was that it was no value from microscopic comparison because it was too small and there was no individual characteristics to rifle and seam.
So you can't make any determination. Could you make any determinations in comparison to the firearm or any of the other evidence?
No, ma'am.
Thank you. Does your work at FDLE also involve the chemical analysis of some clothing or other items?
Yes, ma'am.
And can you kind of describe what that entails?
So what that entails is what we're trying to accomplish is if there was a max distance to the discharge of the firearm to a garment that we receive. In this case, I received one t-shirt, and what I will do is I will visually, microscopically, and chemically test the t-shirt to see if there's any presence of gunshot residue or any vaporous lead from the firing process. So what happens when a gun goes off is there's a cloud of smoke that comes out of the gun. That's the vaporous lead that's caused from the primer material. What that is it will create viscous sooting around the hole, and it's indicative of a close shot. There's also gunpowder particles that can get left behind on the t-shirt as well. And some of those you can't see visually or microscopically, so we have to do chemical comparisons. In this case, I didn't see anything visually or microscopically, and I also did chemical testing to test for those burned gunpowder particles as well as that vaporous lead, and I was able to determine anything.
You got ahead of me.
I'm sorry.
But it's okay. Does this states too, is this an item you previously analyzed in your lab?
Yes, ma'am.
And I just want to slow you down a little bit and back up. So when you analyze this, you're looking for microscopic particles of
gunpowder.
Thank you. And when you examined this shirt, did you find any of that?
No, ma'am.
And did you make any other observations? Any observations that indicated to you that this shirt was involved in a shooting at all?
Just besides the hole, no, ma'am.
Thank you. And what might explain the lack of gunshot powder on this shirt?
There's a multitude of reasons. Some of the common ones are going to be, it could be poor evidence handling. It could have maybe shaken off some of the gunpowder particles. It could be an intervening object. If there's something in between at the time of discharge, obviously those gunpowder particles or residues cannot make it to the actual t-shirt. It could be that there was either blood or debris that could have inhibited the chemical processing or masked any of the gunpowder residue that was on there. And then finally, it could be too far away to actually produce onto the shirt itself.
And what distance might you expect to find stippling on a shirt if those other factors were not involved?
It's various, but with a pistol of this nature, the gunpowder particles will typically fall off around 5 to 6 feet, and the vaporous lead will fall off around about 2 to 3 feet.
Thank you, sir. Judge, may I have just a moment?
So she was at least 5 feet away when she fired the weapon.
I don't have anything else for this witness, the defense may. Thank you, sir.
Thank you.
Cross.
Very briefly.
Yeah, right.
Your testimony.
Get on the microphone.
Today is basically that the ammunition was fired from that gun in this case.
Yes, sir.
And you found no evidence of stippling or gunpowder residue.
That's correct.
And there's all kinds of reasons why that might be.
Yes, sir.
Thanks very much.
You're very welcome.
Juror,
No, sir. Thank you.
can this witness be released?
Yes.
Mr. Taylor?
Yes, sir.
Sir, you're released from your subpoena. You're free to go.
Thank you, Judge.
Thank you. State,
Your Honor, at this time, the state rests.
all right. Members of the
Did they
jury,
say rest?
The state is rested, so there's a couple of legal things we need to speak about. So I'm actually perfect time for your afternoon break. I'm gonna give you 15 minutes. So remember, please don't discuss the case amongst yourselves. Please don't do any research on the people, places, things, or legal topics you've heard anything about. Don't speak with anybody else outside of the jury about this case at all. All right? Leave your notes. All right, you all can have a seat.
Okay.
All right, before, when I just sent them on an afternoon break, I could see some worried looks on your faces. It's not my intention to, do JOA and everything else and keep plowing through this afternoon. But I wanted to talk to you all about scheduling so I could give them an idea before I let them go for the day. I saw the looks. All right. So the state is rested. Obviously, we have a number of things we got to do. First and foremost, the JOA. I'm just surmising that it's going to be a lengthy JOA argument. So we got to get through that. Now, depending on what the ruling is on that, we also, if I do deny it, want to talk with Ms. Benefield about my colloquy regarding testifying or not testifying. It won't be to get answers at this point. It'll just be the colloquy that I go through. I'm
Something
looking
he
back
has
through my
to do.
notes. We've still got the issue of Vicky Mechanic, trial sub, and Richardson hearing. We've got the issue of Daubert and what's his name? Bliss? The expert. Ferris. I don't know where I got Bliss.
He's a police officer. You smushed them together.
Okay. We've got that. And I have another Richardson issue.
How many Richardson issues do you have? Jeez.
It just says 391 emails.
Oh,
Richardson emails.
that's insane.
And then we also have the issue of Faith Brown. And she wasn't listed, but you want to call her to authenticate those emails and I would assume put her own
To impeach.
her own explanation for them.
Yes.
And which would be inconsistent with the testimony Ms. Murphy gave.
And there's one other matter.
Oh, all right.
In an effort to protect Miss Benefield, because we've yet to deal with this, I issued another subpoena to the JA yesterday. So I've already heard from Miss Floyd, who has filed, the court probably hasn't caught up with it yet. She's filed another motion to quash, but she's also filed for sanctions. So the court may want to deal with that.
Okay. Well, I guess we'll eventually just kind of wait and see if her presence is obviated by Miss Brown's testimony. I don't want to make assumptions.
I understand.
So,
y'all, how many subpoenas do
give
we
you
need?
all the option. If you want to, I can give you the break that I'm giving them. You all can talk about, do we want to do some more work tonight? How late do we want to stay? Do we want to get all the way through this? Would it be better that we took care of some of this in the morning? Because I don't know when is Mr. Ferris going to be available?
I would anticipate when we decide to call them, they'll be available.
Okay. All right.
I think we could do the JA, Your Honor, and the other stuff. We could do the JA, and maybe if you want to do the discovery now, I certainly wouldn't mind breaking a little early. I would guess that would be fine with them also.
Can I stop you? When you say JA, I think judicial assistant.
JOA.
JOA. Okay. I just wanted to clarify. Well, yeah, I think let's at least get that done this evening.
Yes. Okay. That was gonna be, I was trying to figure out if you meant JOA or JA.
Yeah, sorry.
So now,
that's the reason why breaking early.
Right. So let me give you all a break. Absolutely. When the jury comes back, I'll let them know that we have some work to do on our part. We're not leaving early. We've got stuff to do. And then we can hit the ground running tomorrow morning. Just so you know, because it's as soon as I said tomorrow morning, it was in my head. We could still start at 9. I'm open to that. But I will have a hearing at 8:30 because I've got motion for release of uncharged offender, 33-day motion. I'll have to hear first thing. If it hasn't been obviated by the filing of the information or a null pros, I don't know yet.
And that's scheduled for 8:30?
I set it for 8:30 tomorrow. I asked for it to be set for 8:30. So you all take your break, and then I'll see you back here in about 12 minutes.
Thank you.
What do you guys think? I
think they're crazy.
I am getting all my GoPros put in a case. I got too many things to deal with.
Is this
Okay.
Is this picture here? Is this Doug and Ashley?
Yep.
It doesn't look like her.
I know.
Well,
I know. It doesn't. No, ma'am. It sure don't. How are you doing? How's everybody doing? I hope she testifies. I want to see the drama.
I'd like to see her testify. I'd like to hear what she has to say.
Well, I'm wondering if she testifies if she ain't going to be another Amber Heard.
Oh, well, I didn't hear that, so I wouldn't know.
No, we're talking about manipulated tears and acting. Amber Heard's an actress, and she put on the best performance of her life on the stand.
Did she?
Better than her own. Oh, look what look at my hair.
It's lovely. Did you sleep with the rats? Did you sleep with the rats?
I hate it when it gets hung up in a clip.
Clip. I know. I really do know.
Got hung up in a clip.
Yeah, it does that sometimes.
Okay, we are going to come live. I'm just letting y'all know. We will be live again at 7 Central, 6. 7 Central, 6.
Something.
6 Central, 7 your time.
Okay. Tonight? Who you live with?
Jules and whoever hops on.
Oh, okay. Whew.
Had a long day at work, my dear?
Yeah.
Well, you got work. Yay. And Braxton, congratulations, dude.
What kind of job did he get?
Something to do with tech and computers.
Oh, that's good.
Case 1 says manipulations for sure. Cindy RN, I think she's sunk. Someone said she's sinking about as fast as a Titanic.
That's pretty bad.
That's bad.
That's real bad.
That real bad.
Yeah, that's real bad.
I've got to put the state. Yes. Put that there. So, yeah, I know that the lead shooter stuff was a little, they're saying it, so I'm kind of, but I just don't want to say it too much. I think that was a little technical, but it is what he said. I understood it all.
I've taken gun
lead shooter
to purchase lead shooter courses before, so yeah, I understood it. But I really had to have him slow down because there was just no way I could keep up with him because he knew his stuff so well. He was like, yeah. It's like,
yeah, I know y'all probably got, why is it so slow? Was it fast earlier? No, I slowed it down a little.
No.
That's one thing good about this kind of thing is I can always slow it down or speed it up, whichever is happening. So, okay. I have to say, the defense barely went with the state did not go along with their witness list.
Of course not.
There was a lot of people on here that weren't even called, and a lot of people were called that weren't on here. So this is what I think about this.
Oh, yeah, well, that's kind of like, ready for this? Breaking. The left confirms support for gender surgeries for minors. Call now to protect our kids and see what you can do.
Ooh, pineapple, no politics.
Oh, yeah. Oh, yeah.
Oh, man. Sorry, y'all. I definitely fell asleep with this baby. It is so hard when you have a peaceful sleeping baby not to go to sleep with them.
Which baby was sleeping? The puppy?
No, Miss Kevin's son.
Oh, you had your baby?
She's holding her baby and he went to sleep and she passed out with him.
Yeah.
You didn't miss anything. I know, right? Sleep when you can.
You got that right.
Your hair looks so pretty.
I forgot to wash it one of these days. This is what you call natural curly, and I really like it. When I was in high school, I didn't. It was kind of like I never had the same hairstyle twice because it was different every single day.
Yep.
Yep. Yep.
So, Miss Kevin, did you get everything packed for the lake? Oh, I don't know if you heard that, but that felt great. This morning was the best part of trial. You missed this morning.
What was it?
The daughter of the deceased got her butt in trouble with the judge.
Really? Why? What'd she do? Did she tell stories? Did she tell
Yeah,
stories?
she was. Oh, we're back up. Yeah, she did a no. We're back up.
We're back already? That was a fast 12 minutes.
Witness, and when she's done, then we could do the.
Well, we were a little behind, remember, because we slowed it down.
Oh, yeah.
Yes, sir.
It's never easy.
Was she just doing the flick off scratch?
Maybe. Yeah, she was. See what she thinks about all this.
She will not be a long witness.
Has the Olympics started?
Court would entertain however Your Honor wants to do it. While we have the jury here, I can call her. Or case law even says the Supreme Court case of State v. Smith, the court could call her. There's a court witness.
26.
She's done, then we could do the JOA or we could do it reverse.
I'm sorry, did you say she's here?
She may be outside now. She was on her way over.
I would at least like a few minutes to speak to her based on the fact that I didn't know about her.
Yeah, of course. I'd absolutely give you that option. So that may, and certainly based upon the case law, certain witnesses and facts and evidence are going to have to be presented before, not Bliss, Ferris.
I just don't know how we can accomplish that when the evidence that they're attempting to seek also, I think, was never provided to the stage. That's the other subject of your Richardson hearing, is those emails from the sealed hearing that we've now had access to. I think it had to have been obtained by the defense from Ms. Faith, whatever. Faith Brown, and because the state's never got those until yesterday.
What was the date? September 30th, 20.
Judge, those emails came from the state.
You're gonna have to show me where.
He is so.
Well, hold on, we don't need the back and forth. I'm trying to figure out.
Okay. Are you
Give
interpreting, Diane?
that option? So that may.
I can.
I'm having a hard time
Based upon
understanding.
the
I'm sorry.
case law, certain witnesses and facts and evidence are going to have to be presented before, not Bliss, Ferris.
I just don't know how we can accomplish that when the evidence that they're attempting to seek also, I think, was never provided to the stage. That's the other subject of your Richardson hearing, is those emails from the sealed hearing that we've now had access to. I think it had to have been obtained by the defense from Ms. Faith, whatever. Faith Brown, and because the state's never got those until yesterday.
What was the date? September 30th, 20.
Judge, those emails came from the state.
You okay?
You're gonna have to show me where. Because I don't understand my.
Well, hold on, we don't need the back and forth. I'm trying to figure out. Listen, this is for me,
who typically is just, let's start the trial, let's go, let's get this thing done, not delaying it for the jury any more than we have to. So this is really outside the box for me. With all of the things that need to be done, what do you think about we make tomorrow a work day? I let the jury go, and then we come back Monday and hit the ground running with the defense case in chief. Tomorrow's a work day for us.
I think that would be outstanding.
My first one of the trial.
Give him
That really would
one,
work out pretty well.
that a boy.
Got witnesses like planes stacked, and my head is spinning over it. So yeah, that
You're
would-
not
And just
prepared
so you
is
know,
what you're
State, this
saying.
is also what I'm contemplating is the fact that whether or not I find any kind of Richardson violation for the emails or whatever the other one was, I can't remember what the other one was, then you have the entire weekend to go through everything. And we kind of hit reset, and then defense, you can come forward with your obligations. If it's a witness you expect to call, a document, a tangible object you intend to use at a hearing or trial, specifically identifying it, and hopefully that'll obviate those issues. Again, it's a little bit different for me, but what do you think?
And Judge, I would be fine with that. My only concern is that I thought some of the alternates had conflicts next week, and I don't remember, and maybe it was actual seated jurors. I can't remember.
No,
There were conflicts that started next week.
But I don't know
I'm
if
not
it
sure what they were.
started Monday or Wednesday or.
I think the juror that, the gentleman we had last today, he has a conference starting Monday out of town. Not that we would be done tomorrow.
Judge, I can only tell you that for my purposes, I believe I could have pretty much, even though I had some problems, I think if we hit the ground running Monday morning, I think I can move this thing pretty good.
Right, but does
How
that mean
many
finish
days?
Monday or finish Tuesday?
Oh,
Define
definitely don't,
finish.
definitely don't finish Monday.
All right, so defense case done Monday. And
Then
then
we
you,
close Tuesday.
and then
Would
you,
that be the?
I think that might be optimistic. I think Wednesday probably is more realistic.
right, so finish defense case Monday, but then we have jury instructions.
Right.
Oh, can't. I apologize,
That's
sir.
okay.
So you expect to finish Tuesday?
I hope to finish Tuesday. I didn't mislead the court when I said I had a number of witnesses. I will do my best to end it on Tuesday, but it's going to be challenging.
He's got a front and back of witnesses.
Yes, I mean,
He's got twice as
correct
he
in
has twice as
identifying
many
that some of
witnesses
the
listed.
jurors expressed that they had time restraints, but however, both sides chose to keep them.
Well, I think what would Wednesday on the calendar be?
Next Wednesday is the 31st.
We should be okay. I know for me, I had some scheduling issues at or around the 1st. So
Right.
we can try to finish the case up Tuesday, if not early Wednesday.
Judge, I just think if we're talking about the defense not even being done on Tuesday, I don't want to take a whole day with nothing. I mean, but I recognize that I don't make the final decision, but that would be my.
I didn't do anything.
Opinion is to not go a full day without doing any trial tomorrow.
All right. Do you have some witnesses, defense, that you could call tomorrow afternoon?
Yes.
All right. So what we could do is we could do some work this evening. Again, depending on what my ruling is on the JOA, we come back tomorrow morning. Oh, and I checked, the information was filed, so I do not have the hearing at 8:30. But we can start first thing tomorrow morning with these hearings that we need to get through. Go to lunch, and I tell the jury to be back here at like 1 o'clock. And then we start the defense's case in chief around 1. And go as far as we can. Okay?
Okay.
You're nodding your heads, but yes.
Yes, sorry.
Okay. All right, so if you could, let's bring the jury back out. I'm going to release them for the evening and ask them to be back at the jury assembly room tomorrow about 12:45 with a goal of having them up here around 1 o'clock.
So, I'm sorry, Judge. I'm wondering, where does that leave me with Faith Brown?
On Monday.
Well, if she's not available tomorrow,
She's not. Is she available Monday? No, she's out.
I'd say maybe call her Monday.
Yeah, that'd be fine. I
If they have, she's not available.
I just want to make sure she's available.
Sure.
Right, or is she under subpoena?
No.
Judge, I just feel like the state doesn't have the option to say our witnesses are not available. I mean, if they're traveling or the next morning or whatever, but to delay an entire day because they didn't make arrangements with their witness, who they haven't listed, seems outrageous.
No, hold on.
Okay.
This is me, because I want to get these, I got a bunch of hearings that I got to get done,
Okay.
including colloquy with the defendant. If Faith Brown isn't available tomorrow, then we can just call her Monday, and that'll give you a chance to get a deposition done.
That's a lot to
Step out
ask.
to ask. What's he asking?
You want me to bring her in?
No, I just need to know, is that the plan?
Yeah.
So because I want to let the jury go, tell them to be here tomorrow at 12:45.
He's out there asking her now. And if there's no chance that we could put her on today, then.
No, I agree with the state. She hasn't even been listed. So I certainly will allow you to call her because I understand the reason why you need her. But I think the state, again, hearkening back to that due process concept, they have a right to speak with her and take her deposition.
I was talking to Kristen. You can interpret it. I said, Kristen, please subscribe. Click the bell so you know when we go live. We have a live tonight at 6 p.m. Diane. So if the defense calls every one of the witnesses listed, they have 21. All the ones I highlighted were the states. So the state and the defense had the same witnesses on the list. So true. July has been an amazing month, and to end the month, we're doing a subscription campaign. And if you want to win a free Starbucks tumbler, just click the subscribe button. That's it. It's easy. Then leave in the comments, I sub, so we can get you in the drawing. The winner will be announced July 31st. Good luck, everyone, and thank you for subscribing. Oh my God, y'all, we did it. I can't believe it. We actually did it. Exciting news. Memberships have launched. Memberships are a great way to financially support this channel. Starting at the juror level of membership, we will be hosting members-only lives. Also, at the judge level, we will be having VIP events. We hope you will enjoy sporting the membership badges and soon to come exclusive emojis. Thank you for watching and supporting the stream and my dream to provide accessibility to the deaf and hard of hearing. If you want the website for Ashley, go to the members chat in our Discord, and it's listed there. You can go and look at it. You can always go back and watch it later. I don't see Jules in the courtroom at all. Thank you, Miss Kevin. What are we waiting for? The jury? Yeah, I know they're going to dismiss, but I want to know what they're going to do. Are they going to be in there working and spilling the tea so we get to know what's coming? Maybe, Ronnie. I'm waiting for that. They better have something to show that she really was harmed and her daughter. I just don't like that the pictures of her daughter are not connected.
She will be available tomorrow at 9 o'clock. She's got a little window, so we're good.
All right.
So we're gonna do all the motions this afternoon?
Yeah.
Thank you, Judge.
Yep. And hopefully she's available for you to speak with her. Do you want to step out and make those arrangements now?
I would, yes.
But while you're doing that,
Yeah.
can one of you stay?
Yes, I'll
And I'm
stay.
going to tell the jury 12:45 tomorrow? Well, no, wait a minute.
Right, now we could have them here in the morning.
Now I need them here in the morning.
Yes.
Okay. All right.
When are they telling the jury?
Hold on. I just want to make sure she's going to be available. Because you guys have every right and should be able to speak with her about her expected testimony. Did that come up during your conversations?
It might come up, but I'm sure she'll talk to them, Judge.
Go ahead.
You see the man in the back with the beard and ponytail?
I feel like a
That's her
vacation
pastor.
was snatched away from me. I was picturing having tomorrow off.
Where is Jules? That would be nice, but I'm going to be ready at 8 o'clock my time, 9 your time. This trial has been all kind of messed up and crazy. We never know what's going to happen. Oh, that's mean. I know. I don't know where she's been. Let me call her. She's not in the courtroom. Maybe she'll pick up. Man, she called me 6:45 my time the other day. Luckily, I was awake. Not answering. So, what is that? What you're doing? Are you doing? Oh, she's calling.
Jack. Is she out there? Okay, Judge. It's never easy. We have a small complication with Faith. It's an issue that Your Honor's going to have to deal with. She was not under subpoena by either side, and was not told that because she wasn't expecting to be witness, that she could not observe the proceedings. So she has watched some of the proceedings.
Who is this?
Once I contacted her, told her that we needed her, we told her to stop, and of course she's conformed to that. I don't know if that presents an issue, but I want to disclose that to the court, and Ms. Brown wanted me to as well.
Okay. You don't have to say anything now. I'm just, you're on notice.
Yeah.
We're just waiting for her, Miss O'Donnell, to come back in and confirm that we can get, you guys can speak with her tonight or tomorrow. Yeah. Just, I need to know that answer so then I can decide, I could let the jury go. Because if you can't speak with her tonight, that'll be a whole other issue. Or depose her in the morning, one or the other.
Cool, Braxton.
All right, Miss O'Donnell is back. Is she going to be available for you to speak with her this evening or tomorrow morning?
I spoke with her. We did not set up a time, but I think she will be available when I need to speak to her again.
Okay, all right, great. So I'm going to tell the jury to be here tomorrow morning, 8:45, start at 9. Okay.
Sorry, Judge, I didn't realize you needed me to come back.
No, it's fine. Don't worry about it. Yes, bring him in.
Court starts tomorrow at 9. Jules was all happy that she could stay in late and not get up at the crack of dawn and drive an hour and a half in the morning. Now, because she thought it was at 12:30. Now she's got to come back. At 8:30 in the morning, be there. He is doing amazing. Braxton is a good young man. Yeah, rush hour traffic. She's avoiding it. That's why she left now. She didn't want to sit for all of this when she had an hour and a half to drive, plus to have our live at 7 her time. So, y'all, please come back. Anybody want to help me get on with some of the other mods? Like,
All right, y'all can have a seat. Welcome back, everybody. I know what you're thinking, that was longer than 15 minutes. But, okay, so there are some things that we need to do on our end. And the reason I gave you that break was to have a conversation with the attorneys and kind of make a list of everything that we need to do before we can move on to the next step. So what I'm going to do is we're going to stay this evening and keep working, but I'm going to let you all go for the evening. So remember, please don't discuss amongst yourselves anything about the case or begin deliberations. Don't talk with anybody outside of the jury about the case. And please don't do any research on people, places, things, or legal topics you've heard anything about. Tomorrow, if I could have you downstairs in the jury assembly room at 8:45, and we're going to have a goal to start up here about 9 o'clock. Figure if we stay late, and then some things tomorrow morning, we should be ready to get going now. Okay?
Yes, sir. Okay, thank you.
All right, thank you. Just fold up your notes and leave right there on your chair. And we'll see you tomorrow.
Cindy, RN, you go get that nice, refreshing shower. I got to take a shower before my husband gets home. So LOL, make him think I'm doing something during the day besides this.
All right, the state having rested defense, your JOA.
Yes, this is hard work.
I have several bases upon which Ashley Benefield at this time, Your Honor, moves for a judgment of acquittal. To begin with, as the court knows, the information charges second-degree murder and requires proof that Ms. Benefield acted with a depraved mind. Furthermore, the evidence that exists at this point has raised a significant self-defense claim. And it's our position that, number one, the state has utterly failed to offer any evidence whatsoever to establish the essential element of a depraved mind. And number two, the state has failed to offer any evidence to overcome the self-defense claim that was raised as a result of the 9/11 call, wherein my client is heard to exclaim, "He attacked me and I shot him," together with the scratches and the bruise to the left side of her face. So let me expand on that a little bit. For purposes of a depraved mind, we need ill will or hatred. No credible evidence has been forthcoming in any shape, form, or fashion that Ashley Benefield acted with ill will or hatred towards Doug Benefield. What has been established is that Ashley Benefield feared Doug Benefield and that Ashley Benefield wanted to be done with that relationship, but there has been no evidence at all that Ashley Benefield hated him, acted out of ill will, spite, or malice. The record is devoid of any evidence establishing that. There's also no demonstration, Your Honor, of indifference to human life, the alternative element. In fact, what there is evidence that in response to this terrible event, Ms. Benefield immediately fled next door to call 9/11. And 9/11, of course, is what you do to summon help. And there has been nothing indicated otherwise that Ms. Benefield displayed indifference to human life. In particular, Your Honor, John Sant put the self-defense issue in play. He testified that Ms. Benefield said, "He attacked me and I shot him." The state has failed to negate in any capacity whatsoever, even when viewed in the light most favorable to the prosecution, that there has been proof established beyond a reasonable doubt that Ms. Benefield's use of force was not justified. All we have is "he attacked me and I shot him." There's been nothing to undermine that. The state claimed that the release of the Broder report was the linchpin, and I think that that's pretty much been voided entirely by Dr. Broder's own testimony, yet alone Dr. Quintal's. And they have utterly failed to prove beyond a reasonable doubt that the use of force was not justifiable. Under those circumstances, at this point, Judge White, no reasonable jury could convict Ashley Benefield. And if they are properly instructed on the law of self-defense and the state's burden to disprove it, they could conclude that the state has failed to meet its burden. The self-defense context, Judge White, is crucial because it directly contradicts the notion of a depraved mind, and that Ms. Benefield was acting pursuant to that as opposed to acting in self-defense. She acted out of a legitimate fear for her safety. Then I have two other bases. Again, the court should remember that the state's theory, very specifically advanced in the opening statement, was that 3 days following the shooting was the denouement, the release of Dr. Broder's report, and therein was the reason for the shooting. Their alternative theory was that she killed him to keep him away from Emerson, their child together. What evidence has been produced to establish that? We heard from Dr. Broder nothing whatsoever contained in his report that was in the slightest manner detrimental to Ms. Benefield. Quite the contrary, Dr. Broder told us he concluded that Ashley had no impetuous tendencies, was not prone to anger. And of course, then there was Dr. Quintel, who said that, yes, she was concerned about the release of Broder's report, but only because she was afraid it would create reprisal from Doug Benefield if he found out what she said about him. And of course, then there's the whole issue about the email where Broder's release of that report was not scheduled for the 30th. The only evidence that we've seen that supports their alternative theory, the state's alternative theory that she killed her husband to keep him away from their child, is this: 5 reports of abuse of Emerson were filed with DCF. Of those 5, 2 were from independent sources. Where is there anything in that other than sheer speculation, trying to roll an inference and an innuendo into a fact, where's there anything possible that justifies the fact that 5 abuse reports were filed, 2 of which were by independent third parties? How do you go from that to killing Doug Benefield to keep him away from the child? This is their case. They have the burden to produce that. They haven't done it, Your Honor. And we think a judgment of acquittal is appropriate. Thank you.
Thank you, sir. State?
And Judge, just at the onset, I disagree with a lot of the defense's recitation of the facts as they've come out. I believe a lot of what he said, witnesses said, were not accurate. I don't believe that a lot of the witnesses said exactly in the manner that he just said the things that he said. But anyway, Judge, clearly the state has shown that this defendant killed Doug Benefield. She shot him 4 times. He died as a result of that. There is no dispute. No one is disputing that she did not kill him. So the only issue would be the depraved mind, regardless of human life. And the defense did mention ill will, hatred, spite, or ill will and hatred, but there is also spite or evil intent. And that is disjunctive. So it's or. And ill will is a very low threshold, to be honest. And the state has shown extensive evidence of motive, of the fact that this woman did not want to share custody of her child with this victim, to the point where she would make allegations against him of sexually abusing his 1-year-old daughter and physically abusing his 1-year-old daughter. And none of these were sustained. And she moved on and on and on and on. And she made comments like, I'll do whatever I have to do to keep my baby a-hole. I'm running out of time. And she's frustrated that nobody's helping her. I'll do whatever I have to do. She's making all of these comments at the same time that she's making all of these false complaints. And the state does call them false complaints. Of abuse to her child. Also, I think defense counsel has made a much bigger deal about Dr. Broder's report coming out than I think the state actually ever did. The state had said that this was the same exact judge that she had not had luck with before. And implied that she didn't want to be in front of this same judge again. And in addition, Dr. Broder's report was coming out, and that was going to be a problem as well. So I think there are several reasons. But when you talk about the actual evidence itself of the shooting, she shot 4 times. And the entrance wound of the fatal wound is not front. It is side to side. So he was turned away from her. And then it's the state's argument that he was moving his leg to run when he was shot as he's running away. She then just leaves him there to die and runs away. And Judge, I think all of these things together, in the light most favorable to the state, I don't think the defense has put on any evidence of self-defense. The defense has attempted to put in a lot of evidence, and things were objected to and sustained by Your Honor. So a lot of the things that the defense just argued have not come in as evidence. So in the light most favorable to the state, we would ask you to deny the JOA. Thank you.
Mr. Taylor, would you like to place any rebuttal on the record?
Very briefly, thank you.
Or not briefly?
Yep, no, briefly. So here's what we have according to the state. We have a woman who is going through a divorce, who has no prior history of criminality or arrest, who, according to Broder, has no impetuous fits of anger, who has done everything according to the requirements of the law, filing a report after report, not doing anything but staying in compliance as to what a citizen is supposed to do. And she goes from that to killing Douglas Benefield on a naked theory. There's no evidence in support for a predicate to establish that theory. There's an inference. You have to take an incredible leap of faith to go from somebody who has no prior history and is living with a gentleman who's committed this kind of conduct, and you go from there to killing him. She didn't shoot him 4 times. He wasn't running away. It's going to be a pretty good trick. As the court knows, the trajectory of the leg bullet was up. So how high do you want to lift his leg as he's running away? Because she would have to be laying on the floor and shooting up to be able to get that bullet to go into his calf and out his knee. That's a real trick. I would suggest to the court, we have raised the legitimate issue of self-defense by virtue of that 9/11 call. They have failed and failed miserably to rebut it. And I thought it was very, very clear. Dr. Vega, I asked him, would this be an accurate statement, Dr. Vega, that the pistol was facing Douglas Benefield when he was shot? Dr. Vega said, yes, that would be an accurate statement, no matter how much she wants to twist it, and I hope she stays with it because I think the jurors will punish her. The bullet may have gone in the side, but Dr. Vega said he was facing the pistol. She was firing from in front of him. That's uncontradicted. Thank you.
All right, thank you both very much. I'm not aware of any recent changes in the standard by which I'm to make my ruling on a judgment of acquittal. I think I heard the defense argue that no reasonable jury could find the defendant guilty beyond a reasonable doubt. I know certainly the appellate courts talk about looking at cases in that light, and I believe that's the standard at the close of all evidence. But my understanding of a judgment of acquittal motion is I am to look at the facts in the light most favorable to the state, including any reasonable inferences therefrom, and decide whether the state has established a prima facie case. Am I mistaken?
No.
Okay. All right. I just want to make sure. So, I think it is a very interesting and unique argument that the defense raised, and they very well could be right that the issue of self-defense can be established during the state's case in chief by a preponderance of the evidence. I don't find support in the law for that. And I think that my findings from earlier are bolstered when you consider at the judgment of acquittal, I'm not looking at any evidence that the defense has produced or any inferences on the defense evidence. I'm looking solely at the evidence presented by the state. I have to construe all facts and in the light most favorable to the state. Any reasonable inferences that can be drawn from those facts have to be inferred in favor of the state. And I'm only looking to see if they've established a prima facie case for the charge or charges alleged in the information. So as I look at the information that we all agreed is the operative pleading in this case from November 16th of 2020, the state has made a prima facie case, I think, based upon the facts that have been established. Again, looking at them in the light most favorable to the state, including the reasonable inferences, I do find that the state has established the elements of murder in the second degree prima facie. There's a prima facie case for the elements. So I will deny the judgment of acquittal. You're going to see Ms. Brown. I'm assuming you want to talk to her first and look through these emails before we address the Richardson, but that's just an assumption.
There have been some developments with the Richardson. You're talking about the Richardson issue based on the emails.
The 391 emails.
It's 390.
Was it? I might be mixing apples and oranges. Something was 390 and something was 316. And
I think there's two issues. I think the first issue was this document that we got that you unsealed had a part missing. And so I could not identify this as something that we gave to the defense. Mr. O'Keefe and I have talked, and he showed me the part that was missing. And based on that part missing, I will go back now and try to find it. So
what is it, a header or something?
Yes, it was the top of an
The
email.
auto-generated header?
Yes.
All right.
And he was saying that it came from a Google search warrant. I said, I would not have gotten Stephanie Murphy's emails from a Google search warrant. Well, apparently this was in Ashley Benefield's Google account. And the heading forwarding it to her was not on this. That being said, I can no longer represent that we do not have this. However, the defense listed it as number 391. Is that what the number is?
277.
277 on their exhibit list. And it listed the entire Google search warrant return data. And I recognize that there's not a lot we can do now with what I'm holding in my hand, but I just want to reiterate that the defense is supposed to give us what they intend to enter. So saying to me that the Google search warrant return, which had hundreds and hundreds of documents, that is not complying with the rules of discovery. The rules of discovery are that you give me copies, or at least clue me into where it is and what exact pages are intended to be entered. And that's the rules of discovery. So I don't know that there's a whole lot we can do to solve this now, and anything that there would be to solve, I can hopefully do that in the future before we have any more testimony about these. But that I can just tell you that that's sort of some of the difficulty that the state's experiencing, is that we're looking at some of this for the first time because we haven't been on notice of it.
So are you asking or alleging a Richardson violation? Because it's per se reversible error if I don't conduct a Richardson hearing.
I would ask you to go ahead and conduct a Richardson hearing, Judge, and then just to be safe.
If you want to do it now.
Yes.
All right. So the issue is a discovery violation by the defense, and I just need you to outline it specifically for me. Are you saying that they did not turn over evidence they should have, or is this based upon the alleged failure to specifically identify documents and other tangible objects that they intended to use at trial, or is it something else?
It is the second, Judge. It is that a list of 365 items, and they are all folders, computer folders with attachments and different pages, is not the notice that is required by the defense when they are required to give the state notice of what they intend to enter into evidence. So while the file umbrella may have been listed on this exhibit list, the state was not put on notice or told which pages would be used as an exhibit. So that would be the substance of my argument.
Did these emails come from the state? Were they recovered by law enforcement?
Yes.
And so you listed them in your discovery and provided them to the defense?
Yeah, and Judge, I have not been able to verify that. This is the first time.
Yeah, so don't say yes if you haven't verified
But
something.
I am saying yes because the defense has shown me the page that I was missing that puts the puzzle together and shows that it probably was, as they are saying, that it came back to us in a search warrant amongst thousands of documents. So without verifying that, I would take that as true based on that representation that I can probably go back now and trace it and see that it's probably part of the thousands of documents. So that would not be the basis of my objection or my allegation. The basis would be not complying with the specific notice requirement of what exact documents you intend to use at the trial.
All right, you want to be heard?
I think what keeps bouncing around in my head is I understand and I appreciate that even though there's hundreds of thousands of pages, we are supposed to extract and list specifically what we intend to use. But what keeps bouncing around in my head is I never expected a witness that the state called come in and perjure themselves. And now we would have been fine if Stephanie Murphy had just told the truth. And now we're in this position where the emails clearly demonstrate beyond any shadow of the doubt that the testimony was wrong. So I think the court should factor that into the position we find ourselves, because I understand and I appreciate technically it's a violation. I would suggest the court certainly wasn't willful. But let's assume the state gets their way. We live with perjured testimony. That can't be right either. So we have to find the happy medium here somehow, understanding and appreciating that we were on guard for this development months ago, and that was why we issued the subpoena to the JA. But I will tell the court candidly, I never actually expected to see it again on the witness stand in front of the jury.
Thank you, sir. Rebuttal?
Yes, Judge. I think that is, I'm trying to find the right word. On July 16th, Your Honor,
I think the obligation is different, and I agree with that interpretation of the rules. The final analysis is the prejudice, and it's not the prejudice we typically think of. The answer is, how would the other side's trial preparation have been different. Certainly, I can imagine the state may have made different arguments. They may have prepped witnesses differently. But just at the end of the day, this was in the state's possession from whenever they had it from the search warrant. So I just don't find that there is any prejudice. So that's my findings on the Richardson hearing regarding the emails. I had down that I was supposed to do another Richardson hearing. Was that the only one?
It was about Faith Brown because she was not listed.
Yes. Okay. Do you want to be heard on that?
We just have a minute. We were just
Of course.
discussing it.
Y'all, I am so sorry. I'm a little pissed off. I didn't know that was going to happen. I'm sorry, y'all.
We've decided not to ask for a Richardson hearing on Ms. Brown. The state's concern was that along with these emails, that it feels a lot like sandbagging to the state or trial by ambush, as I think your judge, as your honor called it. And that was our concern. But in the light most favorable, in our minds, to the defense, we'll assume that they realized once that this mechanic couldn't be called, then they listed or they were planning to call Ms. Brown. I don't know, because I'm not sure when they thought this mechanic could be called.
Now that you've had it, and you don't have to respond, now that you've seen my order that has been unsealed, I would think that the way I wrote it would clearly explain that my thought process of who's available to authenticate that email string and where Ms. Mechanic would fit on that hierarchy.
Yes.
And I think that Mr. Taylor is moving along consistent with my order.
Yes, sir.
Although I will say this, while Ms. Murphy testified extensively about the email and the substance of the email, you never authenticated it with her. You never laid the predicate. And I was waiting and waiting and waiting. So I think she's available to authenticate it. And I think Ms. Brown is available to authenticate it. Sounds like it's going to be Ms. Brown. Sounds like you have the opportunity to depose her this evening. Quite frankly, Ms. Brown may have different thoughts on the interpretation of that email, and you'll have the opportunity to depose her before she testifies.
Thank you.
Okay, so to be clear, Richardson withdrawn as to the listing on calling of Ms. Brown. So hold off on mechanic subpoena for now. The argument about it.
Yes.
Okay.
I
well,
think so.
I'm just going to put that on the back burner for now.
Got it all up and running again. I apologize, guys.
We still have a few minutes. I would like to, at a minimum, read my colloquy to Ms. Benefield regarding defendant testifying. I typically will do this in a trial. I'll do it early on, but I know we're a couple days into it. So at least the defendant will know the issues that I will bring up.
Does the court's colloquy include recitation of the penalty?
I don't think so. Let me look real quick.
If it does, Your Honor, I would ask that you
Skip that?
respectfully.
Fair enough. No, let me look. I don't think it does. All right, Ms. Benefield, listen closely. This is what you're going to hear me say. It might be tomorrow. And then I'll tell you the questions they'll be asking. It might be Monday. I don't know. One of the most important and fundamental constitutional rights you have is the right to remain silent and not testify in this case. You cannot be compelled to testify. That is, the state cannot call you as a witness. It's your decision and yours alone whether to testify or not. You should speak with your attorney about your options and the positives and negatives and benefits and risks with testifying in your own defense. For example, your testimony may provide facts that would prove certain affirmative defenses or allow your attorney to make certain arguments in your defense. But if you testify, the prosecutor will have the opportunity to cross-examine you, just as your attorney has had the opportunity to cross-examine the state's witnesses. For example, on cross-examination, the state would have the opportunity to impeach your trial testimony with prior inconsistent statements that you may have made in the past, or any of the other ways that are allowed by Florida statutes to impeach. I would normally then go into prior convictions, but those don't apply in this case, so I'm going to skip that whole section. It's important to listen to the advice of your attorney about whether to testify or not in this case, but as I said a moment ago, the decision is entirely yours and yours alone to make. So your attorney may advise you that you should testify, and you can say no. Or your attorney may advise you that you should not testify, but you can. If you choose to testify, I will instruct the jury to consider and weigh your testimony and credibility as it would every other witness in this case. If you choose not to testify, I will instruct the jury that they are not permitted to consider the exercise of your right to remain silent as any evidence of guilt or let it influence their verdict in any manner whatsoever. And then the questions would be along the lines of, have you had, not that I won't want to know anything at all that you've talked about with your attorney, but just confirming you've had time to consult with your attorney and make this decision. What is your decision? Confirming just sort of like a plea that you're not under the influence of any alcohol or drugs. You understand what you're doing. You're not being forced, threatened, or coerced to to take this case to trial.
Judge, I have to tell you honestly, no disrespect intended. I think it's intrusive into the attorney-client relationship. I have, as a professional, discussed this matter with my client. My client trusts that I have her best interests at heart. And I think that this unintentionally potentially drives a wedge between my relationship with my client.
Do you have case law about that? There's cases out there that talk about the colloquy with the defendant regarding testifying or not testifying.
I don't have a problem with you advising Ms. Benefield that she has the right to not testify and the equivalent right to testify if she wants. I even don't have a problem with you saying if she chose to testify, then her credibility gets put in evidence like anybody else. I start getting uncomfortable when it goes beyond that. I begin to feel that it is an unintentional intimidation of a woman who has made a choice or is in the process of making a choice after consultation with her attorney. And this is just piling the pressure on the client. I'm sorry, Your Honor. I find it uncomfortable.
You wouldn't be heard for the record. I mean, it's my decision.
I would like to be heard. I have heard this colloquy dozens and dozens and dozens of times. And the fact that the defense acts like this is somehow wrong or intimidating is offensive. And it's not about what Mr. Taylor is comfortable with. It's about what the court is comfortable with at this point. And what is important is that we find out what is in the mind of Ms. Benefield when she makes a decision. That is not for Mr. Taylor to speak. That is for Ms. Benefield. So she needs to know everything that the court is going to do in its colloquy, as we do with every defendant in this position, just like everyone else.
All right. I guess when we get there, I'm going to tell you what I say. And if you instruct your client not to answer, that'll be fine. I think I've shown that I don't get too upset when people disagree with me. So if you say, hey, don't answer that, okay. But I'm going to have it on the record Because in the
The
future, if
judges
anybody said, well,
punch
I didn't
back.
know, I thought
I never
I
saw
thought I
it.
couldn't testify. My lawyer told me no. I mean, the plethora of cases that are out there, I think the case law supports a colloquy with the defendant regarding the right to testify and the right to remain silent. But so I'll ask, make sure that nobody has threatened you, forced you, or coerced you to make this decision.
Oh my
Nobody's
God.
promised you anything, any benefit or a particular outcome to make this decision. That you've made this decision freely and voluntarily. That is, it's your decision and your decision alone.
Yeah.
If your choice is to testify, I'm just going to ask you if you've had adequate time to prepare with your lawyer for that testimony, and then I will make my findings. So that's what I do. So I'm glad I brought it up. That way you're aware of it. And if you decide not to answer any of those, that'll certainly be your prerogative. So we'll have that. Like I said, we'll have that. I want to let you know about it.
That
and then we'll
lawyer
have that
has some
conversation,
cojones, man.
either tomorrow or next week.
Sorry, I'm reconfiguring. I've discovered something.
That was everything
That
on my
lawyer's
list.
got some big cojones, man.
One matter about an ex-party. Brief
How many
discussion
matters are you
with
going to
the
bring
board,
up?
And I supplied the court with some case law to support my position, and I'm hoping that the court will, now that the defense case is starting, I'm hoping that the court will give me some response.
All right. Well, I think
Oh my God.
whenever you had approached me about this case that you gave me the other day, ex parte, without going into the details, my answer was, I think that the state has every right to be heard on this request.
Yeah.
So I will leave it to you. Do you want to talk about it?
This is insane.
Fair enough. Can you give me a moment?
Of course. Absolutely.
That judge is being so freaking fair. I would be unfreaking glued on that man. Oh my gosh, y'all. Snap. I just rearranged my desk and I'm really thrilled with it. I don't know why I didn't think of this sooner. I didn't think of it sooner. Created more room. Small desk. Oh, yeah. Oh, God. I'm my brain is this. How do we respond to this? No. Doesn't make sense. Uh-oh. Are you watching what's going on? You won't believe the guts of her attorney. He's got some cojones, man. God almighty. That was Jules. This feels better. I don't know why. Like I said, guys, it's going to take me another, it can take weeks or months to get you to figure out exactly how you want everything set up in your thing. God, she's watching.
All right, Judge White.
Yeah, I like this better.
Request withdrawn.
Okay.
What did he say?
All right. Anything else we can talk about?
All right.
Who is the?
We're good. Request withdrawn.
Okay. All right. Anything else we can talk about?
Who is the
today?
bald man?
No.
What time are we starting tomorrow? 9, she said 9.
Where's my list going? Let's shoot for 8:45, just in case there's any last minute stuff, and then with the goal of starting at 9.
And is the plan then to have testimony all day?
Yeah, I think so.
Okay.
Right, we're gonna have
Wow.
them lined up one after another, ready to go.
Pretty much.
Okay.
All right, we'll leave you off the record until tomorrow morning.
Thank you, Judge.
Holy crap. Wow. I don't know what to think about that. Oops. Not what you're supposed to see. There we go. Yeah, I kind of agree with you on that. I'm sure you know that. Yeah. Now I'm out of focus. Come on, focus. Focus. Oh well, we're tail ending it. Okay, guys. Please come. My screen is not staying where I put it. Oh, there we go. Please come back tonight at yeah, that's going to work. Come back tonight at 6 Central, 7 Eastern. See, that's where it's focused. And we will have Miss Jules and maybe a surprise guest. Who knows? We never know how tonight's going to go. All right. Yeah, it's just, well, I'm sitting closer to the camera versus back here. Yeah. And so when I turn it off, it'll refocus. My sound seems echoey. Is it me or does it sound good? Because right now my mic is about that far away. So C. Morales, how is my sound? Is it too loud? Just right? Kristen, thank you for joining. I forgot you were here and I was talking without signing. My bad. So hopefully we'll see all of you tonight at 6 Central, 7 Eastern. Yeah, crazy. Okay, guys. We'll see you in a little bit. Okay? I didn't prepare very well for this, did I? Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.